ಏನಾಗಿದೆ ನಿಮ್ದ್ರಲ್ಲಿ? ಅಂಬ್ಲಿಕೊಪ್ಪ, ಆಮೇಲೆ 32/7 ಹೇಳ್ಬಿಡಿ.
Sir, court officer, sir.
ಸರ್ ಹೇಳಿ.
ಸರ್, ಸೀರಿಯಲ್ ನಂಬರ್ 14 ಅಲ್ಲಿ ನಮ್ ಇದು ಕ್ಲರ್ಕ್ ಒಂದು ಸೈಟೇಷನ್ ಕೊಡ್ತಾರೆ. ನಾನು ವಿಡಿಯೋ ಕಾನ್ಫರೆನ್ಸ್ ಅಲ್ಲಿ ಅಪೇರ್ ಆಗ್ತಿದ್ದೇನೆ, ಪ್ಲೀಸ್.
ಸರ್ ನಿಮ್ ಕಲೀಗ್ಸ್ ಯಾರು ಇಲ್ಲ ಸರ್ ಇಲ್ಲಿ?
ಇಲ್ಲ, ಈಗ ಬರ್ತಾ ಇದ್ದಾರೆ, ಕೊಡ್ತಾರೆ ಸರ್. ಸೀರಿಯಲ್ ನಂಬರ್ 14 ಸರ್.
ಓಕೆ ಸರ್, ಓಕೆ ಸರ್,
ಥ್ಯಾಂಕ್ ಯು.
ಮಧ್ಯಾಹ್ನ ಮಾಡಿಲ್ಲ. ಬ್ಲಾಕ್ ನಂಬರ್ 32 ಅಷ್ಟೇ ಇದೆ ಇದರಲ್ಲಿ. ಒಂದು ನೀವು ಪ್ರೇಯರಲ್ಲಿ ಹಾಕೋದು
ಅನೆಕ್ಸರ್ ಬಿ ಅಲ್ಲಿ ಇದೆ. ಆಸ್ ಪರ್ ಅನೆಕ್ಸರ್ ಬಿ ಅಂತ 32 ಅಷ್ಟ ಬಂದಿದೆ ಸರ್. ಇದೊಂದು ಸ್ಪೆಲ್ಲಿಂಗ್ ಮಿಸ್ಟೇಕ್ ಐತೆ, ಇದಷ್ಟ ಹಾಕ್ರಿ ಅಂತ ಅಷ್ಟೇ. 1A ಬಾರ್ಸ್ 7 ಬಾರ್ಸ್ ಅನೆಕ್ಸರ್ ಬಿ ಪ್ರಕಾರ ಹಿಂಗಿದೆ ಸರ್.
32 ಬ್ಲಾಕ್ 1A7 ಹೇಳಿ ನೋಡೋಣ. ಅವು ಎಲ್ಲ ಕ್ಲಿಯರ್ ಆಗಿ ಹಾಕ್ಬಿಡ್ಬೇಕು ಸರ್, ಸರ್ವೆ ನಂಬರ್ ಇದ್ದಾಗ.
ನಾನು ಅದು ಆಸ್ ಪರ್ ಅನೆಕ್ಸರ್.
ಹಲೋ, ಗುಡ್ ಮಾರ್ನಿಂಗ್ ರಮೇಶ್, ಹೇಳಿ. ಆಯ್ತು ತಮ್ಮದು?
ಸರ್
ಸರ್ ಹೇಳಿ.
ಸರ್ 2007 1 KCCR ಕೋರ್ಟ್ ಅಲ್ಲಿ ಬುಕ್ ಸಿಗಬಹುದಾ ಸರ್?
ಒಂದ್ ನಿಮಿಷ ಸರ್, ಒಂದ್ ನಿಮಿಷ.
2007 1 KCCR 715 ಸರ್.
KCCR ಇಲ್ಲ ಸರ್, ILR ಇತ್ತು. KCCR
715 ಸರ್.
ಸರ್ ಆಯ್ತು.
ಇದನ್ನ ಕುಂದರ್ ಜಡ್ಜ್ಮೆಂಟ್ ಸರ್ ಇದು.
2007 1 KCCR 715.
ಎಸ್ ಸರ್ ಕರೆಕ್ಟ್. ಇದನ್ನ ಕುಂದರ್ ಸರ್ ಜಡ್ಜ್ಮೆಂಟ್.
ಅಲ್ಲ ಸರ್ ಸೈಟೇಷನ್ ಸರಿಯಾಗಿದೆಯಲ್ಲ?
ಹಾ ಸೈಟೇಷನ್ ಸರಿಯಾಗಿದೆ ಸರ್. ಹೌದು
ಆಯ್ತು. ಎಷ್ಟಂತ ಹೇಳಿದ್ರಪ್ಪ ಅವರು? ಇವತ್ತು ಮಾದೇವ್ ಬಂದಿದ್ದಾರೆ. ಮಾದೇವ್ ಹೆಚ್ಚು ಮಾದೇವ್ ಬಂದಿದ್ದಾರೆ. ಇದೊಂದು ಲೈಬ್ರರಿ
ಸರ್ ಅದು ಸೀರಿಯಲ್ ನಂಬರ್ 14 ಮ್ಯಾಟ್ರಿಗೆ ಸರ್.
ಸರ್ ಒಂದೇ ನಿಮಿಷ ಸರ್, ಒಂದೇ ನಿಮಿಷ. ಮಾದೇವ್ ಬಂದಿದ್ದು ಒಂದ್ಸತಿ ಹೇಳ್ತೀರಾ? ಫೈಲ್ಸ್ ಅಲ್ಲಿತ್ತು. ಮಾದೇವ್ ಬಂದಿದ್ದಾರೆ ಇವತ್ತು. ಹಾ ಬುಕ್ ಪ್ರಿಂಟು ನಡೀತೈತಿ, ಬುಕ್ಕು ನಡೀತೈತಿ. ಪ್ರಿಂಟ್ ಕೊಟ್ಟರು ಬೆಸ್ಟ್. ಸರ್ ಆಯ್ತು. ಸೀರಿಯಲ್ ನಂಬರ್ 14 ತಾನೇ ಅದು?
ಹೌದು ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 14.
ಆಯ್ತಾಯ್ತು.
ಥ್ಯಾಂಕ್ ಯು ಸರ್, ಥ್ಯಾಂಕ್ ಯು ವೆರಿ ಮಚ್.
ಮೇಡಮ್
My lord. My lord.
Yes.
The matter pertains to education, my lord. I request at 2:30, my lord. PG course for extra attendance.
ಕನೆಕ್ಟ್ ಮಾಡಿಸ್ಬೇಕು. Adjournments, page 14, 82 to 84. My lord, serial number 84. Yes. 84-1, I have 5 wakalat. ಯಾರಿಗೆ? ಫಾರ್ ದಿ ಪಿಟಿಷನರ್ಸ್ my lord. ಅದರ ಬಂದಿಲ್ಲ ನನ್ನ ಹೆಸರು ಅದರಲ್ಲಿ. ಈ ಎರಡರಲ್ಲೂ ಪಿಟಿಷನ್ ಹಾಕಿದ್ದೀರಾ? ಎರಡರಲ್ಲೂ ಪಿಟಿಷನ್ ಇದ್ದೀನಿ. ದೆನ್ my lord, ಶಿವಾನಿ ಮುರಾರಿ ಅಂತಿದೆ. ಶಿವಾನಿ ಮುರಾರಿ ಅಂತಿದೆ. ಫಸ್ಟ್ ಅಲ್ಲಿ ಇದೆ. ಸೆಕೆಂಡ್ ಅಲ್ಲಿ ಬಂದಿಲ್ಲ. ಯಾರು ಶಿವಾನಿ ಮುರಾರಿ ಅಂತ ತೋರಿಸ್ಬೇಕಾ ಎಪಿ ಮುರಾರಿ ತೋರಿಸ್ಬೇಕು? ಎರಡರಲ್ಲೂ 84. Shri AP Murari submits that he has filed Wakalatnama. Registry is directed to print the name of Shri AP Murari along with Shivani A. Murari in WP 102528 or 21 and print the name of Shri AP Murari as that appearing for the petitioner by deleting the name of Shri SV Yaji in WP 102517 or 21.
And 94 is also connected to this.
Connect 94.
94.
Relist on 20.
Monday. ಆಮೇಲೆ ಅದು ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ ಬರ್ಬೇಕು ಅಲ್ಲ, ಬಿ ಗ್ರೂಪ್ ನಲ್ಲಿ ಬರ್ತಾ ಇದೆ.
ಆಗಲ್ಲ ಮಿಸ್ಟರ್ ಮುರಾರಿ. ರಿಲಿಸ್ಟ್ ಆನ್
ಮಂಡೇ ಆರ್ ಟ್ಯೂಸ್ಡೇ ಮೇಲೆ ವೆರಿ ಸಿಂಪಲ್ ಅದ.
ಸೇಮ್ ಡೇಟ್ ಕೊಡ್ತೀವಿ ಬಟ್ ನೆಕ್ಸ್ಟ್ ಮಂತ್ ಕೊಡ್ತೀವಿ. 25th March. ಸೇಮ್ ಡೇಟ್ ಬಟ್ ನೆಕ್ಸ್ಟ್ ಮಂತ್.
ಫಸ್ಟ್ ವೀಕ್ ಆಫ್ ಮಾರ್ಚ್.
ಇಲ್ಲ ಬಹಳ ಜಾಸ್ತಿ ಇದೆ. ನೆಕ್ಸ್ಟ್ ಅವ್ರು ಬಂದು ಬೈಕೊಳ್ಳೋದು ಬೇಡ.
16 85 to 87, page 17 88 to 91, page 18 92 to 98, page 19 99 to 106.
103, my lord. Some another matter is connected to the same petitioners.
103 connect with so and so and
one Girish payment.
Serial number 77, my lords. There is some urgency. Delivery warrant is issued. Yesterday I made a mention, my lords, to post it in preliminary hearing. It is posted in orders, my lords. Type copy is not furnished. That is the office objection.
77. We'll see when it.
Please.
Yes.
One
The operative portion, my lords. It is shown as Ambikoppa instead of Amblikoppa. Ambikoppa. Operative portion of the judgment.
ಏನ್
filed by the petitioners without inquiry, without notice.
ವಾಷಿಂಗ್ ಅಂದ್ರೆ ನೋಟಿಸ್ ಆಗ್ಬೇಕು. And AG accepts notice for respond number 1 to 3, seeks for and is
The
granted.
interim and status quo may be granted by that.
After 2 years,
This, if the connected matter has been disposed by,
2 weeks time to obtain.
madam, connected matter has been granted by this honorable court, madam. ಇದರಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
ನೀವು 2 ವರ್ಷ ಆದ್ಮೇಲೆ ಬಂದ್ಬಿಟ್ಟು ಸ್ಟೇಟಸ್ ಕೋ ಕೇಳಿದ್ರೆ ಕೊಡಕ್ಕಾಗಲ್ಲ. Released on 26th March.
3.
ಏನಪ್ಪ primary ಏನಿಲ್ಲ 23 ಇದು. Primary ಏನಿಲ್ಲ 23 ಇದು.
Kindly pass over the matter.
ಏನಕ್ಕೆ ಪಾಸ್ ಓವರ್? ಇಲ್ಲಿ ಇಶ್ಯೂ ನೋಟಿಸ್ ಅಷ್ಟೇ 23 ಇದು. Circular right. Vivekananda General Hospital. Issue notice to the respondent returnable by 9th April.
4. CS sector.
ನೀವು ಯಾಕ್ರಿ 23 ಇಟ್ಕೊಂಡಿದ್ದೀರಾ preliminary hearing?
This matter, my lord, sir, mutation entries are affected.
And AG accepts notice for respond number 1 to 3, issue notice to respond number 4 to 9 returnable by 9th April.
5. SC Bhuti.
Preparing for the petitioner,
Issue notice to the respondent returnable by 9th April.
seeking stay.
After 2 years, no.
6. CS sector.
Only government is the part.
And AG accepts notice for respond number
1 to 3.
1 to 3. 6 bond is granted 3 weeks time to obtain instruction, make a submission. Released on 27th March.
Please.
7. SK
Shri Prashant Osmani is directed to accept notice for respondent, counsel for the petitioner to furnish 2 sets of the petition along with annexure on the said counsel. Released on 28th March.
8. Deepak Kulkarni.
Deputy Commissioner.
15th February 24. ಫೈಲಿಂಗ್ ಮಾಡಿದಾಗಲೇ ಸರಿಯಾಗಿ ಮಾಡಬೇಕು. And AGA accepts notice for respond number 8 to 10. Issue notice to respond number 1 to 7 returnable by 9th April.
dependent is not required. My lord may peruse the order at ink page number 42, my lord.
Notice to the respondents is dispensed with in view of the proposed order to be passed. Petitioner is before this court seeking for the following leaves. The respondents had filed a suit in OS number 44 of 2017 seeking for a perpetual injunction against the defendants from disturbing the plaintiff's peaceful possession over the suit scheduled property. The petitioner had filed an application under Order 1 Rule 10(2) of the Code of Civil Procedure to be impleaded as a party defendant in the proceedings, claiming that he had purchased the property and was in possession of the said property. The said application came to be dismissed by order date 31/20. Application was numbered as IA number 10 and came to be dismissed on 31/20/24 on the ground that the impleading applicant claims to be a purchaser of the property. The suit being, having heard Sri Santosh Raut, learned counsel for the petitioner, the suit being one for perpetual injunction, any order passed therein will be binding only on the defendants in the said suit and not on the plaintiff, not on the impleading application who is not made a party to the said suit. In that view of the matter, I do not find any committee in the order passed by a trial court. The petition stands dismissed at the stage of admission itself.
10, CS still open.
Yesterday, who mentioned it at 1:30 and sought for adjournment without, when we said that no adjournment would be granted?
ನಿನ್ನೆ 2:30 ಅಂತ adjournment.
ಬೆಳಿಗ್ಗೆ ಪಾಸ್ ಓವರ್ ಮಾಡಿ ಮತ್ತೆ 1:30 ಬಂದ್ಬಿಟ್ಟು ಅರ್ಜೆನ್ಸಿಯಲ್ಲಿ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ತಗೊಂಡೋಗಿದ್ದು ಯಾರು?
ಶ್ರೀಕಾಂತ್ ಪಾಟೀಲ್ client.
My colleague has submitted. My colleague
We
has.
had told in the morning there is no requirement
In fact, I was
for
not.
you to be
in
present
station
also. Why did your colleague do that? You should not be doing like this.
I'm sorry.
ಪಾಸ್ವರ್ಡ್ ಮೇಡಮ್,
ಏನಕ್ಕೆ?
ಪಾಸ್ವರ್ಡ್ ಬೇಕಾಗಿತ್ತು.
Who are you for?
ಪೆಟಿಷನರ್ ಮೇಡಮ್.
We're not passing or we're dismissing the matter.
ಮೇಡಮ್, the facts are the different ಮೇಡಮ್.
Again, facts are different. There is
My
a 3 and 7 is not maintainable. File a suit under 92.
That is, in that is second petition. The first petition is regarding order 1 rule 10 application.
OS number 28.
3 and 2, 3 and 7. Reaction first.
Pass over. But they don't make a mention at 1:30 and take time.
Please, much obliged.
11, Prashant Usmani.
Lordship, matter pertains to belated payment of leave encashment. Matter pertains to the payment of belated payment of leave encashment, Your Lordship.
Even encashment you have to pay.
Your Lordship, it is covered, Your Lordship.
But namde one judgment. Leave.
In the identical matter, Your Lordship has given interim stay also, Your Lordship.
We have written one more judgment contrary to this. That has not been pointed out in this. This is a later judgment. Leave encashment will also come under 33 because it's a wages, it's part of the wages. Entitled to, earned. Notice to the respondent is dispensed with in view of the proposed order to be passed. Petitioner is before this court seeking for the following leaves. The respondent workman had filed an application number 10 of 2017 under section 33C2 of the Industrial Dispute Act 1947, seeking for payment of, seeking for leave encashment benefits along with interest at 10% per annum. The leave encashment was quantified at rupees 1,64,000. The Labour Court allowed the said application. It is challenging saying the petitioner is before this court. The submission of learned counsel for the Prashant Osmani, learned counsel for the petitioner, is that leave encashment is not wages. The application for leave encashment was filed with a delay of 1 year and as such ought not to have been entertained by the Labour Court. Further submission is that leave encashment is not wages which could have been sought for under section 33C2 of the ID Act. Leave encashment, heard learned counsel for the petitioner on produced papers. Leave encashment is availed of by a workman or employee as regards the leave already accrued to the account of the workman stroke employee. This leave standing to the credit of the workman, he could have either availed the leave in terms of absence from work and or for encashment in lieu thereof. Therefore, it forms part of the wages. If a request is made for encashment, the same would form part of the wages. In that view of the matter, the same would be covered by section 33C2 of the ID Act, and there is no requirement for raising an industrial dispute under section 10 and for the same to be referred by the appropriate government to the Labour Court. I do not find any infirmity in the order passed by the trial court, by the Labour Court. The petition stands dismissed at the stage of admission itself. The time granted by Labour Court, just go to that time, is extended by a period of 30 days from today for compliance.
12, Ravi Agde.
Hearing for petition. One more petition is pending for consideration before this honorable court.
Mine director Yarappa idu.
Kushal V. Bolmal appears in that matter.
Huh? Yaru?
Kushal V. Bolmal.
Is directed to accept notice for respondent, connect with so and so and relist on 27th March.
Please.
Part.
Record the notice.
Number 1 and 2 issue notice to respond number 3 and 4 returnable by 15th April.
14, Chandrasekhar Gowda.
I appear for the petitioner, my lord.
Yes.
I appear for the petitioner, my lord.
Yes.
The fifth petitioner is my brother, my lord. I have challenged annexure A, my lord. The deputy commissioner in review petition. My review petition was rejected, my lord, based on the delay, my lord. Annexure B is form number 7, my lord. I applied in the year
1924 not ordered. Why have you moved the matter?
My lord, they are formal parties. My lord, my name is excluded from the RTC, my lord. Some third party was interfering my position, my lord. The other respondents are formal parties, my lord. They have a separate grantee.
They are parties to this order under the revision petition.
Yes, my lord. They are formal parties.
Formal parties they are parties to the revision under 136(3).
Yes, my lord. ಅವ್ರನ್ನ ಹೆಸರು ಅದರಲ್ಲಿ RTC ಅಲ್ಲಿ ಮೆನ್ಷನ್ ಇರೋದ್ರಿಂದ ಫಾರ್ಮಲ್ ಪಾರ್ಟಿಯಾಗಿ ಮೆನ್ಷನ್ ಮಾಡಿದ್ರು, my lord.
ಅವ್ರ ಹೆಸರಲ್ಲಿ ಇದ್ರೆ ಫಾರ್ಮಲ್ ಪಾರ್ಟಿ ಹೆಂಗ್ ಆಗ್ತಾರಪ್ಪ? ಅವ್ರ ಹೆಸರು ಡಿಲೀಟ್ ಮಾಡಿ ನಿಮ್ಮ ಹೆಸರು ಹಾಕ್ಬೇಕಂದ್ರೆ ಅವ್ರ ಹೆಸರು ಡಿಲೀಟ್ ಮಾಡ್ಬೇಕಾಗತ್ತೆ.
ಇಲ್ಲ, ಅವ್ರ ಹೆಸರು ಹಾಕಿಲ್ಲ ಅದರಲ್ಲಿ. ನಮ್ಮ RTC ಅಲ್ಲಿ ಕರ್ನಾಟಕ ಸರ್ಕಾರ ಅಂತ ಮೆನ್ಷನ್ ಮಾಡಿದ್ದಾರೆ. They are separate grantees, my lord. Kindly see, my lord, Annex B, my lord. Annex C is grant certificate, my lord. It was granted in my favor, my lord. Adesha, Shri Manju Shambugowda, who is my father, my lord. Sakin Gunavante, Ivarannu, Gunavante Gramada survey number, my lord. Subject properties, my lord. Survey number 110, 37 Gunte was granted, my lord, in my favor. On 30/11/1981, my lord. Then, my lord, the occupancy certificate in form number 10, my lord, issued In my lord, 29 March 1983, my lord. Second item is survey number 110, area, my lord, 37 Gunta. My father name was showed in the RTC, my lord. Kindly see, my lord, page number 42. Annex F, my lord.
One nimsha. Name of the respondents are entered into in their respective RTCs for 22 ISAs in the same property.
After bifurcation, our ಹೆಸರು ಬೇರೆ ಬೇರೆ ಆಗಿದೆ.
Any order passed will affect them. How can they be found?
No, my lord. They are original grantee, my lord. They have separate grant certificate. It is this subject matter is, my lord, only my grant certificate only, my lord.
What is
Nange
your
30
what is your
Nange
property
30
number?
Property number survey number 110, my lord.
Measuring 7 acres, 19 guntas.
Illa,
7 acres, 19
out of that, my lord, 37 gunta was granted, my lord, in my favor. Kindly see, my lord, page number 35, Annex C, tribunal order, my lord. Page number 35, Annex C, my lord. In the operative portion, my lord, Adesha, Sri Manju Shambugowda, who was my father, my lord, Gunuvante, Ivaranu Gunuvante Grammar survey number, next survey number, my lord, 110 ಪೈಕಿ 37 ಗುಂಟೆ. So and so ಜಮೀನುಗಳಿಗೆ ಅಧಿಭೋಗದಾರರೆಂದು ಭೂನ್ಯಾಯ ಮಂಡಳಿಯು ಸರ್ವಾನುಮತದಿಂದ ನೋಂದಾಯಿಸಲು ತೀರ್ಮಾನಿಸಿತು, my lord. It was passed in, my lord, 30/12/1981, my lord. Then, my lord, occupancy certificate, next page, my lord, 36 was granted, my lord. Second item, survey number 110, area 37 gunte, my lord. Arjidara Manju Shambugowda, who is my father, my lord. Then, my lord, my father's name was reflected in the RTC, my lord. Kindly see, my lord, page number 42, Annex F, my lord. First name Manju Shambugowda. One third share, my lord. Anshavari Hakku. First page number 42, my lord. Manju Shambugowda.
Yes.
After his death, my lord, my name and respond number 5th name also shown in the RTC, my lord, page number 42. First name, my lord, Manju Shambugowda died. Ganapaya Manjugowda and Vagaire. One third share, my lord. Then, my lord, page number 50, ವಾರಿಸ ಎಂಟ್ರಿ, my lord, ಮಂಜು ಶಂಭುಗೌಡ ಇವರು ದಿನಾಂಕ 25/12/1996 ರಂದು ಗುಣವಂತೆ ಗ್ರಾಮದಲ್ಲಿ ಮೈತರಾಗಿರುತ್ತಾರೆ. ಅವರಿಗೆ ಈ ಕೆಳಗಿನಂತೆ ಸರಳ ವಾರಿಸುದಾರ ಇರುತ್ತಾರೆ. Totally 9 members were there, my lord.
Yes.
Ganapaya Manjugowda, who is the petitioner in this petition, my lord. Shambugowda, fifth respondent. Others are daughters, my lord. ಇಲ್ಲಿ ಈ ಕಡೆ ಕಾಲಮ್ ಅಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ ಸರ್ವೆ ನಂಬರ್ 110 36 ಗುಂಟೆ 12 ಆಣೆ ಅಂತ ಮೆನ್ಷನ್ ಇದೆ ಕಾಲಮ್ ಅಲ್ಲಿ. Then, my lord, the property was rectificated, my lord, by Kandaya Adalat based on the, my lord, revenue inspector report and Shanboga report, my lord. Kindly see, my lord, page number 56, my lord. It was wrongly submitted, my lord, report. Kindly page number 56, my lord.
Yes.
Second para, ಗುಣವಂತೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 110, ಆಕಾರ ಬಂದ್, ಕ್ಷೇತ್ರ 7 ಎಕರೆ 19 ಗುಂಟೆ. My lord, typed copies in page number 57, my lord. ಖರಾಬ್ 5 ಗುಂಟ, ನಿಕ್ಕಿ 7 ಎಕರೆ 14 ಗುಂಟ, ಆಕಾರ 2.6 ಇರುತ್ತಿದ್ದು, ಕಾಲಮ್ ನಂಬರ್ 9 ರಲ್ಲಿ ಕ್ಷೇತ್ರದಲ್ಲಿ ವ್ಯತ್ಯಾಸ ಇದ್ದು, ಕಾಲಮ್ ನಂಬರ್ 9 ರಲ್ಲಿ ಒಟ್ಟು ಕ್ಷೇತ್ರ 6 ಎಕರೆ 22 ಗುಂಟೆ 14 ಆಣೆ ಇರುತ್ತಿದ್ದು, ಆಕಾರ ಬಂದಂತೆ ಉಳಿದ ಕ್ಷೇತ್ರ 31 ಗುಂಟೆ 2 ಆಣೆ ವ್ಯತ್ಯಾಸ ಇದ್ದು, ಕರ್ನಾಟಕ ಸರ್ಕಾರ ಹಕ್ಕು ಪಹಣಿಯಲ್ಲಿ 0.27 ಗುಂಟೆ 8 ಆಣೆ ಇರುತ್ತಿದ್ದು, 1965 ರಿಂದ 1982 ವರೆಗೆ ಕೈಬರಹ ಪಹಣಿ ಪತ್ರಿಕೆಯಲ್ಲಿ ಕರ್ನಾಟಕ ಸರ್ಕಾರ ಒಂದು ಕಡೆಯಲ್ಲಿ 29 ಗುಂಟೆ. ಇಟ್ ವಾಸ್ ಅರ್ಲಿಯರ್, ಮೈ ಲಾರ್ಡ್, ಆಫ್ಟರ್ ಮೈ ಗ್ರಾಂಟ್, ಮೈ ಲಾರ್ಡ್, ಕರ್ನಾಟಕ ಸರ್ಕಾರ 29 ಗುಂಟೆ, ಹಾಗೆ ಇನ್ನೊಂದು ಕಡೆ ಕರ್ನಾಟಕ ಸರ್ಕಾರ 15 ಗುಂಟೆ 2 ಆಣೆ, ಒಟ್ಟು 1 ಎಕರೆ 42 ಇರುತ್ತಿದ್ದು, ಪಹಣಿ ಕಾಲಂ 9 ರಲ್ಲಿ ಕ್ಷೇತ್ರಕ್ಕೂ ಹಾಗೂ ಆಕಾರ ಬಂದ ಕ್ಷೇತ್ರಕ್ಕೂ ಮೇಳ ಇರುವುದಿಲ್ಲ. ಈಗಿನ ಗಣಕೀಕೃತ ಪಹಣಿ ಪತ್ರಿಕೆ ಕರ್ನಾಟಕ ಸರ್ಕಾರ 27 ಗುಂಟೆ ಇರುತ್ತಿದ್ದು, ಇದು ಕೂಡ 31 ಗುಂಟೆ 2 ಆಣೆ ಕ್ಷೇತ್ರದಲ್ಲಿ 27 ಗುಂಟೆ 8 ಆಣೆ ವಜಾದಲ್ಲಿ 3 ಗುಂಟೆ 10 ಆಣೆ ಉಳಿದು ಉಳಿದ ಕ್ಷೇತ್ರ ಯಾರ ಹಕ್ಕು ಅಂತ ತಿಳಿದು ಬರುವುದಿಲ್ಲ. ಕಾರಣ ಸದರ್ ಹಕ್ಕನ್ನು ಭೂನ್ಯಾಯ ಮಂಡಳಿಯಿಂದ ಇತ್ಯರ್ಥವಾಗಬಹುದಾಗಿ ನಮ್ಮ ಅಭಿಪ್ರಾಯ ಇರುತ್ತದೆ. ಈ ಬಗ್ಗೆ ಕೈಬರಹ ಪಹಣಿ ಪತ್ರಿಕೆ ಲಗತ್ತೆ ಇಟ್ಟಿದ್ದೇನೆ. 28/10/2015, my lord. This was reported. My lord, the next report is, my lord, page number 58, annexer K, my lord, by the revenue inspector, my lord. Next typed copies there, my lord, page number in 66. Same was, my lord, ಆಕಾರವನ್ ಪ್ರಕಾರ ಗುಣವಂತ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 110 7/19 ಗುಂಟೆ ಇದ್ದು ಲಾಸ್ಟ್ ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್ ಅಲ್ಲಿ, my lord,
ಅಲ್ಲಪ್ಪ ಇವರೆಲ್ಲ ಹೆಸರು ಕೊಟ್ಟಿದ್ರಲ್ಲಪ್ಪ, ಶಂಭು ಬೆಣ್ ಗಣಪಯ್ಯ, ಗೋವಿಂದ್, ಕರ್ನಾಟಕ ಸರ್ಕಾರ,
ಹೌದು, ಅವರಿಗೆಲ್ಲ
ಗಂಗೆಕೋಮ್ ಶೋಭಾ, ಶಂಭು ಗೌಡ.
my lord, ಅವರಿಗೆಲ್ಲ ಸಪರೇಟ್ ಆಗಿ ಗ್ರಾಂಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇದೆ, ಟ್ರಿಬ್ಯುನಲ್ ಇಂದ ಆರ್ಡರ್ ಇದೆ. ನನಗೂ ಹಾಗೆ ಸಪರೇಟ್ ಆಗಿ ಗ್ರಾಂಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇದೆ ಅದೇ ಸರ್ವೆ ನಂಬರ್ ಅಲ್ಲಿ. ಇಲ್ಲಿ ಲಾಸ್ಟ್
ಆಸ್ ರಿಗಾರ್ಡ್ ದಿ ಎಕ್ಸ್ಟೆಂಟ್ ಆಫ್ ದ ಪ್ರಾಪರ್ಟಿ ನಿಮ್ಮ ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಅವ್ರ ಎಂಟ್ರಿಗೆ ಎಫೆಕ್ಟ್ ಆಗುತ್ತೆ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಇದರಲ್ಲಿ ಕರ್ನಾಟಕ ಸರ್ಕಾರ 29 ಗುಂಟೆ ಇದ್ದದನ್ನ ಒಂದೇ, ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ನಂಬರ್ 61 ಮೇ ಬಿ ಕೈಂಡ್ಲಿ ಸೀನ್, ಮೈ ಲಾರ್ಡ್. ಕರ್ನಾಟಕ ಸರ್ಕಾರ 1 ಎಕರೆ 18 ಗುಂಟೆ ಮಾಡಿದ್ದಾರೆ. ಅರ್ಲಿಯಲ್ಲಿ ಇಟ್ ವಾಸ್ 29 ಗುಂಟ, ಮೈ ಲಾರ್ಡ್. ಕೈಂಡ್ಲಿ ಸಿ, ಮೈ ಲಾರ್ಡ್, ಪೇಜ್ ನಂಬರ್ 61.
1 ಗುಂಟೆ ಇದೆ ಅಲ್ಲ, 61.
1 ಎಕರೆ 18 ಗುಂಟೆ ಹತ್ತಾಣೆ. ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ 4, ಮೈ ಲಾರ್ಡ್. ಕರ್ನಾಟಕ ಸರ್ಕಾರ
ಬಂದಿದೆ, ಕರ್ನಾಟಕ ಸರ್ಕಾರ
2 ಸಲ ಬಂದಿದೆ. ಲಾಸ್ಟ್ ಇಲ್ಲಿ, ಮೈ ಲಾರ್ಡ್, their reason is, my lord, ಈ ಮೇಲಿನಂತೆ ದಾಖಲುಪಡಿಸಿ ರಿಕಾರ್ಡು ದುರಸ್ತಿ ಪಡಿಸಬಹುದಾಗಿದೆ ಹಾಗೂ ವ್ಯತ್ಯಾಸವಾದ ಕ್ಷೇತ್ರ ಕರ್ನಾಟಕ ಸರ್ಕಾರಕ್ಕೆ ಇಟ್ಟಲ್ಲಿ ಯಾವುದೇ ಮಾಲ್ಕಿದಾರರ ಕ್ಷೇತ್ರ ವ್ಯತ್ಯಾಸವಾಗುವುದಿಲ್ಲ. ಈ ಮೇಲಿನಂತೆ ರಿಕಾರ್ಡು ದುರಸ್ತಿ ಪಡಿಸಲು ಆದೇಶವಾಗಬಹುದಾಗಿ ಅಭಿಪ್ರಾಯ ಇರುತ್ತದೆ. Based on this wrong report, my lord, my name was excluded totally 37 gunta, my lord. And page number 62 is the order, my lord, Kandaya Adalat order. No notice was issued, my lord. There is no hearing, my lord, and order was also not communicated to me, my lord. Kindly see the reason, my lord. ಕೆಳಗ್ನೂರು ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 110 ಇದರ ಕಾಲಂ ನಂಬರ್ 3ರ ಕ್ಷೇತ್ರಕ್ಕೂ ಗಣಕೀಕೃತ ಪಹಣಿಯ ಕಾಲಂ ನಂಬರ್ 3ರ ಕ್ಷೇತ್ರಕ್ಕೂ ಮೇಳವಿದ್ದು, ಪಹಣಿ ಕಾಲಂ ನಂಬರ್ 9ರ ಕ್ಷೇತ್ರವು ನಿವ್ವಳ ಕ್ಷೇತ್ರಕ್ಕೆ ಮೇಳವಿಲ್ಲದೆ ತಪ್ಪು ನಮೂದಿರುವುದನ್ನು, ನಿವ್ವಳ ಕ್ಷೇತ್ರಕ್ಕೆ ಮೇಳವಿಟ್ಟು ಮೇಲಿನ ಚೆಕ್ ಲಿಸ್ಟ್ ನಮೂನೆಯಲ್ಲಿ ಕಾಣಿಸಿದಂತೆ ದುರಸ್ತಿ ಮಾಡುವ ಬಗ್ಗೆ ತಹಶೀಲ್ದಾರ್ ಹೊನ್ನಾವರ್ ಅವರು ಭೂದಾಖಲೆಗಳ ಪರಿಶೀಲನೆಯಿಂದ ವರದಿ ಸಲ್ಲಿಸಿದಂತೆ ತಿದ್ದುಪಡಿ ಮಾಡಲು ಆದೇಶಿಸಿದೆ. Based on this order report, my lord, ಕಂದಾಯ ಅದಾಲತ್ was passed the order, my lord, excluding my name, my lord. Total 37 gunta, my lord.
Yes, Mr. Kanu, the others won't get affected because their name continues.
Yes.
ನಿಮ್ ಸರ್ಕಾರ ಹೆಂಗ್ ಜಾಸ್ತಿ ಆಗೋಯ್ತು? ಅವ್ರು ಕೇಳಿದೆ, ಅವ್ರು ಡಿಲೀಟ್ ಮಾಡಿ.
I'm illiterate.
ಏನಿದೆ?
Because your lordship, there is no grievance against the other persons.
This has been given.
Because according to their, because I am not having file, but according to their submission that your lordship, there is no grievance against the respondents. Their property is different and his
Name
property is
continues
different.
on page 72.
Yes.
We thought their name was
Yes.
deleted. Their name continues at 72. So they won't
Even
be
their
affected.
condition that you lordship, without giving notice to them, your lordship, without giving opportunity, the order is passed.
Petitioner ಗಿಲ್ಲ.
Yes.
ಆಮೇಲೆ ತಗೊಂಡಿರೋ ಸರ್ಕಾರಕ್ಕೆ,
ಅದೇ.
ಬೇರೆ ಯಾರಿಗೂ ಹೋಗಿಲ್ಲ.
ಬೇರೆ ಯಾರಿಗೂ ಹೋಗಿಲ್ಲ.
Petitioner is before this court seeking for the following reliefs. A notice to respond number 10 to 24 is dispensed with, since 5 to 24 is dispensed with, since they would not be affected by any order passed by this court in the present, proposed to be passed in this petition. Their names already continuing in the revenue records and no challenge has been made to their entitlement. The petitioner is before this court seeking for the following relief. The contention of the petitioner is that originally the agriculture property bearing survey number 110 measured 7 acres 19 guntas. The land tribunal, on the basis of form 7 which has been filed by Manju Shambhu Gowda, had granted occupancy rights on 30/12/1981 and issued Form 10 on 29/3/1983 to an extent of 37 guntas, Allah?
Yes, my lord. Yes, my lord. 37 gunta.
37 guntas. Thereafter, the name of Manju Shambhu Gowda had been entered into the record of tenancy and crops After his death, the name of his wife and children came to be entered into on 15 to 1999. A partition having been effected between the parties, between the family members, in terms of ME number 4666 dated 23 to 1999, the petitioner name got entered into in the revenue records. A Kandaya Adalat having been conducted, the revenue inspector Manki had submitted a report that there is a variation in the land, the variation in the measurement of the lands, and therefore had indicated that the name of the government can be entered into in respect of 1 acre 18 guntas. It is on that basis that the name of the government was entered into for the aforesaid 1 acre 18 guntas.
18 gunta 10 ana, my lord.
1 acre 18 guntas 10 annas.
To 24 dismissals.
Without a notice having been issued to the petitioner, despite the name of the petitioner and his predecessors having been in existence in the revenue records, while entering the name of the government, the name of the petitioner also came to be deleted. Challenging same, the petitioner had filed a revision under subsection 3 of section 136 of the Karnataka Land Revenue Act. The first respondent deputy commissioner dismissed the said revision petition confirming the order of the Special Revenue Adalat on the ground that the petitioner had approached the court, filed the revision petition after a period of 8 years, and as such there being a delay of 2771 days, no explanation having been given, the delay could not be condoned. Secondly, the revisional court held that a modification of the order of the Revenue Adalat, who was authorized to carry out such changes as may be required, could not be interfered with. Learned counsel for the petitioner, it is challenging the same, the petitioner is before this court. The submission of Sri Chandrasekhar Gowda, learned counsel for the petitioner, is that admittedly there being a grant of occupancy rights made under Form 7 in favor of the father of the petitioner, and the name of the father having been entered into in the revenue records pursuant to Form 7 and Form 10 having been issued, the name continuing in the records could not have been deleted unilaterally without issuing any notice. Though the Kandaya Revenue Court, Kandaya Adalat had the power to do so, it could only do so after issuing a notice and hearing the petitioner would be affected by any order passed in relation thereto. His submission is that even if there is a variation in the area, the same cannot be debited to the account of the petitioner, inasmuch as a grant of 37 guntas has been made in favor of the father of the petitioner, and thereafter credit to the account of the Karnataka government without any basis. Having perused the papers,
Because lordship, there is no, only that your lordship, only they could have given opportunity to the petitioner. Because without issuing notice to them,
that concession
But it was,
merits
my name was excluded. My name was excluded, my lord, after it.
supports the order passed by the revision court stating that there was an inordinate delay of 2771 days, which had remained unexplained, and as said, the revision court has rightly rejected the application for condemnation. Heard so and so, various papers. The revision court has rejected the application of the revision of the petitioner on the ground that there is an inordinate delay of 2771 days. This delay would have to be taken into consideration from the date of knowledge of the petitioner and not by the date of the order passed. Inasmuch as when the order was passed by the Kandaya Adalat, the no notice having been issued to the petitioner was not aware of the said order and as such could not be expected to challenge the said order. The delay of 2771 days may be true when calculated from the date of the order of the Kandaya Adalat, but from the date of knowledge cannot be said to, there cannot be said to be any any delay, since the petitioner has claimed that the petitioner has challenged the said order immediately on coming to know of the said order. Thus, the rejection of the application for condemnation delay, in my considered opinion, is improper. The revision court ought to have verified from the documents as regards the true nature of the claim made by the petitioner and if the documents supported the claim of the petitioner. The documents which have been produced along with the petition indicate that Form 7 filed by the father of the petitioner came to be allowed. Possession, occupancy rights were granted and a Form 10 issued. And thereafter, the name of the father of the petitioner was found from, was entered into on?
On my lord, I produced my lord at page number 42 from 1996, my lord. Before that also there, my lord.
At least from the
It
year
was-
1988, as can be seen, 1988, as can be seen from Annexure E, and continued till the order passed by the Kandaya Adalat on 30/5/2016. The name of the father of the petitioner having been in existence for nearly a period of 30 years, the same could not have been deleted without notice having been issued. Furthermore, after the name of the name of the petitioner's father, the name of the petitioner's father was entered into in the year 1988. Thereafter, there being a partition, the petitioner succeeded to the said property and his name was entered into. Thus, the name of the father of the petitioner and thereafter the petitioner's name being in existence in the revenue records from 1988 till 30/5/2016 for a period of nearly 30 years, without issuance of notice, the same could not have been cancelled. Records are there, we'll direct the name to be added.
Yes, my lord, please.
In that view of the matter, I pass the following order. Writ petition is allowed. The order dated 21/2024 passed by the Deputy Commissioner, Uttar Kannada at Annexure A is quashed. The order dated 30/5/2016 passed by the Special Revenue Adalat is also quashed. Respondent number 2 is directed to cause the entry of the name of the petitioner in respect
3, my
of-
lord, Tashildar. 3 Tashildar, my lord.
Respondent number 2 na pile. Respondent number 2, Tahsildar, is directed to cause the entry of the name of the petitioner in respect of 37 guntas, which has been, as regards which occupancy rights had been granted to the father of the petitioner. Liberty is however reserved to the official respondents to issue proper notice to the petitioner if they so choose fit and thereafter proceed with in accordance with law.
Obliged, my lord.
15, Sunita P. Krasur.
Yes.
Petitioner should.
What is Annexure B? Page 19.
And it should be is a
Sought for mandamus.
page number 19, they are seeking typed
Can you
copy.
seek for dispensation of these documents, madam? One page type marks a problem.
I shall do it, your lordships.
And you are seeking for dispensation of production of translated copies of a different language.
I shall produce it, your lordships.
Why are you doing like this? In the other matter also you did the same thing.
I apologize, your lordships.
It's a 24 matter. It hardly takes 3-4 days.
I apologize.
You filed
your
it on
lordships.
30th September 24. You could have done this by now.
I apologize, your lordships.
IA 1 of 24 has been filed for dispensation of production of type copy of Annexure B. A perusal of Annexure B indicates that the same is not legible and furthermore is not a complete document. In that view of the matter, IA 1 of 24 is dismissed. Petitioner is directed to produce the complete copy of Annexure B, legible copy of Annexure B. If not legible, to produce type copy of Annexure, complete copy of Annexure B. IA 2 of 24 has been filed for dispensation of production of translated copies of Annexure E series. A
It is
perusal
in
of the
Telugu,
said
your lordships. I shall
documents indicate that the same is in a language other than the official language and the regional language of this court, the same being in Telugu language. As such, IA 1 of 24 also stands dismissed. To comply with the office objection, relist on, when will you produce it?
Tuesday, your lordships. By Tuesday. The urgency is because they are trying to give the land to the other beneficiaries. That's the reason, your lordships.
Relist on 25th.
Please. Obliged.
16, Girish Bhatt.
Please, my lord. So Manda must to rectify the revenue entries.
And AGA accepts notice for respondent. Same order, survey number change.
Please. Good.
17, Srinand Pachapure.
Lordship, the petition number 1 herein has not the petition number 2 to 6, my lord. They have not relinquished 1 acre of land, my lord, out of 4 acres in favor of petition number 1. In respect of other 2 acres, my lord, portion of the same survey number, they also executed agreement of sale in favor of respondent number 5, who has filed suit for specific performance, my lord. When I made an application to enter my name pursuant to, my lord, the relinquishment date, he came and filed objection that the suit is pending. When I made an application in the suit, my lord, he stated that no, that property is different, this property is different, because boundaries are different. Against which I approved this honorable court and filed writ petition, my lord. This honorable court also dismissed the writ petition that both the properties, my lord, that though arising out of same survey number, the boundaries are different, my lord, extent and boundary is different. Lordship makes page number, order of this honorable court, Annexure M, page number 91.
Page number? This is survey number 34/3A.
Please, my lord.
Page number?
Annexure M, my lord, page number 91. Para 2 the reasonings, my lord, 93. Respond number 1, may I read, my lord? Respond number 1 instituted a suit for specific performance of contract based on agreement of sale dated so and so, registered on so and so in respect of 2 acres of land in survey number 34/3A. The present petitioner bar impleading applicant claims that defense number 1 to 5 executed agreement of sale in favor of the petitioner which is much prior to the suit agreement, and subsequently there is a registered relinquishment date in favor of the petitioner to an extent of 1 acre. This court finds that the peculiar facts arise for consideration in the case on hand. On examination of the stand taken by the defendant number 1 to 5 in the written statement, I am of the view that defendant 1 to 5 does not dispute that they are owners of 4 acres of land. Plaintiff is asserting that there is an agreement of sale in respect of 2 acres, while petitioner impleading applicant asserting that there is a relinquishment date to an extent of 1 acre. If defendant 1 to 5 are owners of 4 acres of land and having examined the boundaries indicated in the suit agreement and the boundaries reflected in the relinquishment date and agreement to sale in favor of the petitioner impleading applicant, the properties are not overlapping. Therefore, I am of the view that earnest judge was justified in relegating the impleading applicant to establish his right in an independent proceedings.
You are the impleading applicant.
Please note, in that suit. There he files the objection that that property, I am not necessary party because the property is different. And when I made application to the mutate my name, there he came and filed objections that suit is pending, there is an injunction order. And though initially my name was mutated, subsequently the same was set aside by the
Jendra, son of Babu Chaugala.
Please note.
On examination, number 1 to 5. He was the impleading applicant. Huh?
Please note, I am the implicated applicant in the suit. I am claiming right only on 1 acre, my lord, through a relinquishment deed. Other 2 acres of land, my lord, that is the subject matter of the suit, my lord. Boundaries are also different. Since suit is pending an injunction order, my lord, on that ground, the authorities, my lord, have refused to enter my name, my lord. And same was confirmed by the assistant commissioner and deputy commissioner.
But there's a finding that relegating the impleading applicant to establish right in an independent proceeding ಅಂತ ಹೇಳಿದಾರಲ್ಲ.
That's true, my lord. But
ಎಲ್ಲಿ ಎಸ್ಟಾಬ್ಲಿಷ್ ಮಾಡಿದೀರಾ?
ಇಲ್ಲ, total extent of land, 4 acres of land, my lord.
ಆಯ್ತಪ್ಪ, ಅದು ಸೇಮ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಅಲ್ಲೂ ಮಾಡಿದ್ರಿ. But this court, a coordinate bench said, therefore I am of the view that learned judge was justified in relegating the impleading applicant to establish right in an independent proceedings.
That's because to dispute, my lord, the persons who have executed relinquishment deed, they are also, my lord, the petitioners herein.
You had addressed the same argument, Rajendra, before the single judge.
Please, my lord.
And that was your impleading application which you had filed.
Please, my lord. I have made implicated application for the reason that
This court, which was rejected.
Please, my lord.
This court upheld the order.
Please, my lord.
And said you have to establish in an independent proceeding.
But also observe that, my lord, both the boundaries and property extent is different, my lord. It is not overlapping.
ಯಾವ್ದಾದ್ರು ಕೋರ್ಟ್ಗೆ ಹೋಗ್ಬಿಟ್ಟು ಫೈಂಡಿಂಗ್ ತಗೊಂಡ್ ಬಂದಿದ್ದೀರಾ?
ಇಲ್ಲ.
ಮತ್ತೆ ಇಲ್ಲಿ ಆರ್ಡರ್ ಮಾಡಿದಾರಲ್ಲ, is right in an independent proceeding ಅಂತ ಹೇಳಿ ಆಯ್ತು. You should do that to claim.
Lordship, I have registered instrument in favor of my lord. I know I am claiming only 1 acre, my lord. The subject matter of
1 acre or 1 guntano.
ಇಲ್ಲ,
is a finding.
Please, my lord, that's true. But the subject matter of suit is 2 acres. That is different out of same survey number.
We can't go beyond the finding of a court. When the court said you have to establish independent proceedings, you have to do that or challenge it. You can't still persist with your submission. ಇಲ್ಲ ನಂದು 1 acre ಇದೆ, ನನ್ನ ಹೆಸರು ಬರಬೇಕು ಅಂತ ಹೆಂಗ್ ಹೇಳಕ್ಕಾಗತ್ತೆ ನೀವು?
But the persons who have executed the relinquishment, they are not disputing. They are also, let's say, I will take notice, my lord.
We are dismissing it because there is a finding there unless you establish it. There is no question of entering your name.
The boundaries in the agreement of sale and the relinquishment deed, both are different. That is what I have stated. It's not overlapping to each other.
Notice to learned AG accepts notice for respond number 1 to 4. Notice to respond number 5 is dispensed with in view of the proposed order to be passed. The petitioner claims that 1 acre of land in survey number 34/3A has been relinquished in favor of the petitioner, the entire land measuring 5 acres. There is no, the contention is that there is no dispute as regard the 1 acre of land being owned by the petitioner. In this regard, they submit that a suit in OS number 92 of 2020 having been filed by respond number 5 herein. In the said suit, the petitioner had sought to implead himself. The impleading application having been rejected, the petitioner had approached this court in WP number 103603 of 2021 by referring to the order dated 24/8/2023 passed therein. His submission is that the respondents have only claimed 4 acres of land and have not claimed any interest in the right belonging to the property of the petitioner. A perusal of the aforesaid order dated 24/8/2023 indicates that this court held, inverted commas, therefore I am of the view that learned judge was justified in relegating the impleading applicant to establish his right in an independent proceedings. Inverted commas close. When such a finding has been expressed by a coordinate bench of this court, it was for the plaintiff petitioner to have established his right in independent proceedings. On inquiry as to whether such independent proceedings have been filed, learned counsel for the petitioner submit that no such proceedings have been filed, but insist that since a relinquishment deed has been executed, the name of the petitioner is required to be entered into in the revenue records in respect of the aforesaid 1 acre. And I said the order passed by the respond number.
Lordship, Tahsildar, Assistant Commissioner and Deputy Commissioner, 2, 3 and 4, my lord.
2, 3 and 4 ಎಲ್ಲ ಒಂದೇ order.
No, the separate, annexure A, B, C, my lord.
Order dated 29/9/2023 at Annexure C passed by respond number 4 and the order dated 22/1/2024 passed by respond number 3 at Annexure B and the order dated 27/8/24 passed by respond number 2 at Annexure A are not proper and are required to be set aside. In view of the specific observation made by this court, it would not be required for this court to go into the reasoning given in Annexure C, B, and A, reserving liberty to the petitioner to initiate such independent proceedings as observed by this court while it's order dated 24th August 2023. The petition stand in WP number 103603 of 2021. The petition stands disposed. In the event of the petitioner being successful in such independent proceedings, the petitioner is reserved liberty to approach the respond number
Four, my lord.
4 for causing such entries as may be required.
Please.
I'll ಮಾಡ್ಬಿಟ್ಟು ಮಾಡಿ.
Please.
18, Balgoda Patil.
My lord, a day's accommodation may be given, my lord. My office
Days
file,
accommodation ಇಲ್ಲ.
my lord, my office file has been misplaced, my lord, sir.
ಏನಿದು? CPC ನಾ ಒಂದು ನಿಮಿಷ.
Monday, my lord, kindly on Monday, my lord.
ಸುಡಿಂದು ಬಂದ ನೋಡೋದು ಫೈಲ್ ಕೊಡೋ.
You are claiming under JDR 1A and B that you are rental. 21 rule 97 is not maintainable.
I'll convince, my lord, kindly on.
ಏನ್ ಕನ್ವಿನ್ಸ್ ಏನಿಲ್ಲ.
Please.
And you have filed a separate suit. You are a tenant under the JDR who has been asked to be evicted. Not maintainable. The petition notice to respondents is dispensed with the new of the proposed order to be passed. The petitioner is aggrieved by the dismissal of the application filed under Rule 97 of Order 21 of the Code of Civil Procedure in execution number 39 of 2021. The petitioner claims to be a tenant under judgment debtors 1A and 1B, and as such in possession of the property, and it is in that background that the objector's application had been filed. In application under Rule 97 of Order 21 or 99 of Rule 21 could be filed only by a third party and not by a person claiming under the judgment debtor. In that view of the matter, the order passed by the execution court that the application filed by the petitioner is not maintainable is proper and correct. Furthermore, the petitioner had also filed a separate suit in OS number 5 of 2022, which is pending adjudication, reserving the petitioner's liberty to agitate all his right in the pending suit. Finding no ground for interference with the impugned order, the petition stands dismissed.
19, Appangowda. Appannagowda.
In his representation, he made a submission that he is in possession. He cannot, he only on the basis of possession cannot be entered, your lordship.
Pass an order.
Even himself has admitted that.
ಒಂದು ಆರ್ಡರ್ ಮಾಡಕ್ಕೆ ಏನಂತೆ? Right or wrong, we'll adjudicate it later.
Yes.
But you have to pass an order giving reasons, ಅಷ್ಟೇ. ಇದೆಲ್ಲ mandamus ಬರ್ಕೊಡ್ದು.
Your lordship.
Unnecessary litigation ಇದೆಲ್ಲ. ಪಾಪ ಅವ್ನು ದುಡ್ಡು ಖರ್ಚು ಮಾಡಿ ಬರಬೇಕು. Court fee no ಕೊಡಬೇಕು. Petitioner is before this court seeking for the following reliefs. The petitioner claims to be in physical possession of survey number 16/2, Muddapura village, Kampli Taluk, Bellary district. The petitioner had made an application ಯಾವ ಫಾರ್ಮ್ ಅಲ್ಲಿ ಮಾಡಿದ್ರು ಇದು?
Simple application is made.
ಸಿ ಫಾರ್ಮ್ ಕೊಟ್ಟಿಲ್ವಾ? For regularization of his occupation on 28/2024 at Annexure C. The petitioner is before this court contending that the said representation has not been acted upon and orders passed thereon, and as said the above relief of mandamus is sought for. Whenever any application or a representation is made to an authority of the state, it is required for the said authority to consider the same and pass orders accepting or rejecting the applications to representation made. Needless to say, if an order of rejection is passed, the same is to be accompanied by necessary reasons. In the present matter, the applications to representation having remained unconsidered by the respondent, I pass the following order. Petition is allowed. A mandamus is issued directing respondent number 3 to consider the representation dated 28/24 at Annexure C submitted by the petitioner in accordance with law within a period of 30 days from the date of receipt of a copy of this order. AGA for respondent number and AGA accepts notice for respondent number 1 to 3.
20 Vagish Hegde. Please, my lord. The government was granted the revenue pada land, my lord, to the petitioner in the year of 1997, my lord. But after lapse of the 27 years, the survey was not conducted, boundary was not fixed, my lord.
And AGA accepts notice for respondent number 1 to 3. The petitioner is before this court seeking for the following relief. The claim of the petitioner is a land in survey number 87 measuring 8 acres 31 guntas of Usri Grama of Sirsi Taluk was government pada land, out of which 1 acre 20 guntas had been granted to the petitioner.
Endorsement issued, your lordship.
Issue ಮಾಡಿದ್ದೀರಾ?
Annexed, your lordship. Annexed, your lordship. Because the suit is pending, your lordship, on that basis, your lordship.
My lord, that is, that suit was different, my lord. This petition is different.
Challenge this. Mandamus ಕೇಳಕ್ಕಾಗಲ್ಲ ಒಂದ್ಸತಿ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಕೊಟ್ರೆ.
ಹೌದು.
ಇದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿ ರೀಸನ್ ಕೊಡ್ಬೇಕು ಯಾಕೆ ಅದು ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಇಸ್ ನಾಟ್ ಮೇಂಟೈನಬಲ್ ಅಂತ. ಇಸ್ ರಾಂಗ್. ನೀವು ಮ್ಯಾಂಡಮಸ್ ಕೇಳಿ ಅದು ರಾಂಗ್ ಅಂತ ಹೇಳಕ್ಕಾಗಲ್ಲ.
The suit was declaration and injunction, my lord.
ಹೌದಪ್ಪ, ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡ್ಬೇಕಲ್ಲ ನೀವು.
Yes.
See, you are only asking for a mandamus.
Yes. To demarcate the boundary, my lord.
ನೀವು ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡ್ತೀರಾ ಇಲ್ಲ ಸಿವಿಲ್ ಕೋರ್ಟ್?
Civil court and as well as high court.
ಇಲ್ಲಿ ಬಂದಿರ್ತಾರೆ.
ಮ್ಯಾಂಡಮಸ್ ಕೇಳೋದು ಅವ್ರು ಏನು ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ.
Yes.
ಅವ್ರು ತಪ್ಪು ಮಾಡಿ ಒಂದು ತಪ್ಪು ಆರ್ಡರ್ ಮಾಡಿದ್ರೆ ಅದಕ್ಕೆ ಸರ್ಶ್ಯೂರೇ ಕೇಳ್ಬಿಟ್ಟು ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಬೇಕು. ಅವ್ರು ಆರ್ಡರ್ ಮಾಡಿದ್ಮೇಲೆ ಮ್ಯಾಂಡಮಸ್ ಕೇಳಕ್ಕಾಗಲ್ಲ. ನೀವು ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿ ಅಷ್ಟೇ.
Yes.
And AG accepts notice for respondent number 1 to 3. Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that a survey of the property which had been granted to the petitioner has not been conducted despite a request being made. The AG submit that the said request has been rejected while Annexure D dated 29/8/2023, reserving liberty to the petitioner to challenge Annexure D. The petition stands disposed. ಅದನ್ನೆಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ರೀಸನ್ಸ್ ಕೊಟ್ಟು ಚಾಲೆಂಜ್ ಮಾಡಿ.
This man. 21 Vishwanath Hegde.
Tuesday.
ಯಾಕಪ್ಪ?
ಸ್ವಲ್ಪ ಅದು ಅರ್ಲಿಯರ್ ಆರ್ಡರ್ ಒಂದಿತ್ತು. Let's.
ಬಹಳ ಮ್ಯಾಟರ್ ಇದೆ, ಮಾರ್ಚ್ಗೆ ಹೋಗತ್ತೆ. ರೆಡಿ ಇದ್ರೆ ಹೇಳಿ, ಇಲ್ಲ ಸೀರಿಯಸ್ ಡಿಫಿಕಲ್ಟಿ ಏನಿದು?
Next.
CPC.
Next, ಅಂದ್ರೆ before this, that order is not placed on record.
My lord, IA number 30 order, my lord. My lord, the application filed by the defendant number 225 to produce the document, my lord. Please, my lord.
65 ಅಲ್ಲಿ you are filed.
The present order is under order on IA under section 65. Before this, they had asked me to produce the original record, original document. I have said that there is no such document which is not in my possession. First of all, there is no such document. Secondly, I have contended that such a document is not in my possession. That application was, let's do ordered. The court said that since I am not in possession of the document, I cannot produce it. Now that document is sought to be produced by a secondary evidence.
ಏನ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅದು?
Wantani patra. Partition. My lord, the foundation is laid in the.
ಫೋಟೋಕಾಪಿ ನ ಒರಿಜಿನಲ್?
Please, my lord. My lord, foundation is laid, my lord, by producing the Xerox.
Photocopy na original.
My lord, Xerox copy is produced, my lord. My lord, for that reason, my lord, we filed application, my lord. Because the original is within the custody of defendant number 1, my lord. That application is allowed by the trial court. Next date, my lord, the defendant number 1 has filed the memo without challenging the said order. My lord, that is accepted by the trial court. Then, my lord, we filed application under section 65 of the Indian Evidence Act, my lord.
Yes.
The counsel for respondent seeks for and is granted 2 days time to produce certain earlier orders that you wish us to rely upon. Released on 25th.
Please.
22, HN Gulreddy.
Matter become infructuous. Matter become infructuous.
ಆಗೋಯ್ತಾ?
Notice challenge, your lordship, afterwards.
Learned AGA accepts notice for respondent number 1. Petitioner is before this court seeking for the following leave. Learned counsel for the petitioner submits that the meeting has been held and the above petition has been rendered infructuous. Accepting the said submission, petition is dismissed as infructuous.
23, Abhijit Kankonkar.
I'm for the petition, my lords.
Yes.
This is a writ of mandamus seeking direction against the respondent number 3 to issue NOC in my favor without insisting for a submission of the survey map. The facts of this case are, I have filed an
NOC for what?
NOC for the purpose of land conversion, my lord.
Without a survey map, how can they give you?
No, the fact is that the PDO here is asking for a certified copy of a survey map. But in the entire area, the village, survey map is not been issued by the revenue department as there is some ongoing issue. So I have already supplied him a copy of survey map, which he is not willing to take into consideration.
For the panchayat. The reason why that is sought is existence of the property is in dispute.
I have
carry out a survey.
That's why, since I cannot get it done, it has to be by the survey department. And the neighboring owner is contending that subsequent to this application being filed, the Gram Panchayat PDO has visited the spot.
Have you made an application for survey?
No, sir, I have not made an application because the contention raised by the respondent is not been brought to my notice.
Allappa, nimge conversion beko.
Yes, I have made the application, my lord.
Conversion, one of the documents to be enclosed is a survey map.
I have already given the survey map. He is asking for a certified copy. I do not have a certified copy, sir.
Has to be a certified copy only.
But then the thing is, the department.
Who did the survey? How did you get the survey? Where is that?
Which I have applied for the land conversion. I have given the entire village map. But then the thing is.
Apply for a certified copy.
No, in regards to that.
Survey?
My lords, in regards to that, I had earlier filed a petition before this honorable court in the month of June, seeking for all of these documents. A direction was issued to ADLR to hand over all these documents. The ADLR did not comply with the same.
Mr. Kankonkar, if you make an application for survey, then they'll carry out a survey. Without you making an application for survey, what documents will they give?
No, let me just explain. The fact is that the ADLR has himself filed an affidavit before the division bench. Thus, documents such as survey map, 11E, location map, and PT sheet cannot be issued in the entire Ramnagar village, as there is some dispute with the survey numbers. So since this being the issue, I am not able to obtain a survey map, sir.
When you lordship, the next area you lordship is to PDO, not the authorities.
Allappa, ಏನು mandamus ಕೊಟ್ರೆ ಏನು use ಇಲ್ಲ.
Yes.
I have given a
Ramnagar village.
Yes, entire Ramnagar village.
Ramnagar village taluka.
Entire village, Ramnagar.
Village
Unless he makes your lordship proper application, then the authority
Suppose
may
that
consider.
affidavit-
Otherwise, lordship.
I'll obtain a copy of it, sir, because it was filed in the division bench. I'll obtain a copy and submit the same.
The affidavit, let us
Yes,
see.
a date may be given us. I'll submit the copy.
This is it's petitioner ಒಂದು ಬೇರೆ entire Ramnagara village ಕೊಡಕ್ಕಾಗಲ್ಲ ಅಂದ್ರೆ it is
Yes.
firstly it's not believable, and if it is true then action needs to be taken. Everybody will be suffering.
One in the present petition also, he has not made any copy of the, that is also handicap with the lordship.
A date may be given, sir. I'll submit the copy of the said affidavit.
So he has made the application.
ಇಲ್ಲಿ ನಮ್ಗೆ ಎರಡು ಪ್ರಾಬ್ಲಮ್ ಇದೆ. ಒಂದು ಫಸ್ಟ್ ಕೌಂಟರ್ ಪಾರ್ಟ್ ಲಾಯರ್ ಅವ್ರು ಡ್ರಾಫ್ಟ್ ಮಾಡಿ ಕೊಡ್ತಾರೆ, ಇವ್ರು ಬಂದು ಇಲ್ಲಿ ಹಾಕ್ತಾರೆ, ಅದನ್ನು ವೆರಿಫೈ ಮಾಡೋಕ್ಕೂ ಆಗಲ್ಲ, ಅವ್ರು ಚೇಂಜು ಮಾಡೋಕ್ಕಾಗಲ್ಲ. ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಹೆಂಗ್ ಹೇಳ್ಬೇಕು ಅಂತಾನು ಏನು ಇಲ್ಲ. ಸೆಕೆಂಡ್ ಇಸ್ ವೆನ್ ಪೀಪಲ್ ಡೋಂಟ್ ಪ್ರಾಕ್ಟೀಸ್ ಇನ್ ದ ಹೈಕೋರ್ಟ್, ಅವ್ರ ಪಾಪ ಗೊತ್ತಿಲ್ಲ, ದೇ ಆರ್ ಸ್ಟಾರ್ಟಿಂಗ್ ಟು ಪ್ರಾಕ್ಟೀಸ್, ಇಲ್ಲಿ ನೋಡೋಣ ಟ್ರೈ ಮಾಡೋಣ ಅಂತ ಅವ್ರಿಗೂ ಎನ್ಕರೇಜ್ ಮಾಡಬೇಕು. ವಿ ಕ್ಯಾನ್ ಗೋ ಟೆಕ್ನಿಕಲ್.
I am not saying that. But your lordship, when he has made the application to.
And AGA accepts notice for respond number 1 and 2. 3 ಆಗಿದೆಯಾ?
Notice is order minutes.
Learned counsel for the petitioner submits that the reason why the prayer sought for in the above petition, the reason why the prayer for issuance of a NOC without insisting on a survey map has been sought for is on account of an affidavit stated to have been filed by the ADLR.
Yes.
In WA number?
Contempt or
In
writ?
contempt numbers.
In
I'll
contempt.
give the number, yes.
I am, it is between them. Let's.
Or will, in contempt petition number so and so, that survey maps cannot be issued in respect of the Ramnagara village, there being certain issues as regards the identity of the properties, etc. He seeks for and is Ramnagara bracket Akrali village, Joida Taluk, Uttarakhand district. He seeks for and is granted 3 days time to place on record the said affidavit released on 25th February. New check mark for Mr. Kanwar. If there is any problem, what is the problem? ಗೊತ್ತಿರಬೇಕಲ್ಲ ಮಿಸ್ಟರ್
According to my instructions, the document which he had placed on record before the PDO was not believable for the reason his property was not mentioned there.
He
Survey.
gave a village map.
Yes.
Full village map ಕೊಟ್ಬಿಟ್ರು. So no problem about that.
Yes.
But is survey being carried out, survey sketches are available or survey being carried out in this village? And
Let's ascertain it today itself.
if it can be done, then
Yes.
we'll ask him to, we'll relegate
Yes.
him to them to file an application.
Please.
Carry out a survey and then he can attach it.
Please, I'll also place it on.
Now,
If it is not, my instructions are this. The number property which he is claiming, the RTC has been the RTC extract has been generated, but the existence of a property itself is in dispute. There is no such property according to the allotment. These are rehabilitation properties which were allotted under rehabilitation. Now the original map of allotment that was done doesn't bear this number at all, this property number. So the PDO said, you produce some document to show that there is an existence of the property. I will visit the property and then issue the NOC on the same day.
In regards to
Now he is disputing that. The moment when the PDO went to the spot, the neighboring owner started claiming that that property belongs to him, which he is laying a claim. Subsequently, there is an FIR registered against this person by that neighboring owner in respect of the same property.
Is this a problem with most of the properties or only one?
No, only this property, but there is a dispute now arose. Yes.
Now, in regards to filing of application, sir, we have to file it online. Even the said website has been blocked and I'm not able to file an application online. So I have no remedy as well.
The third
Online for what? Survey.
For survey, the ADLR.
submits that the petitioner is also unable to file an online application for a
Yes.
survey map.
Yes.
Since
There is some piky issue. So I'm not able to file the application also online.
As regard the aforesaid property, learned AGA is directed to also inquire into this aspect and make a submission by next date. If everything is working, then he should do it. But if it's not working, what is to be done?
Ultimate solution.
It may not only be the problem of this petitioner, in baki ordunu irutte.
Yes, I will verify.
Check ಮಾಡಿ ಹೇಳಿ. And what is the solution? 25th.
Before, dear Lord Khan,
The notice has to go to local body, my lord. The change of name, there is a correction in the name in the birth certificate. Mr. Bhushan Kulkarni may be directed, Municipal, Hubli Dharwad Municipal Corporation, Zone 5.
ಏನಂತ ಹೆಸರು ಕೊಟ್ಟಿದ್ದು?
In fact, the correct name is Muhammad Shaiz Mullah. That finds a place at Annexure F, page number 18, my lord. An application came to be filed on 30th October 2024. It has been depicted as Muhammad Ariz Mullah. Now the corporation has issued an endorsement stating that I should get a court decree for that.
Your parents are Sana Firdos Nadaf, wife of Tausif Ahmad Mullah.
Please, my lord, parents, my lord, now the grandfather had given an application. As such, he has obtained a GP and he has presented the petition before this court, my lord.
Sana Firdos Nadaf ಆಗಿದೆ.
Please, my lord, that finds a place at page number 14, typed copy at page number 14A, my lord. Sana Firdos Nadaf.
So the mother's name is given for the child.
No, that remains correct, my lord. The child's name is been written as Muhammad Ariz. That find a place at page number 60.
Baby of Sana Firdos.
Baby, my lord.
So name is written as Muhammad Ariz.
Ariz. In fact, Shaiz.
Where is your application?
At page number 17, my lord. To correct it as Muhammad Ariz to Muhammad Shaiz.
ನಿಮ್ಮ ಫಸ್ಟ್ ಡೀಟೇಲ್ಸ್ ಕೊಟ್ಟಿದೆ ಇಲ್ಲಿ.
ನನ್ನ ಫಸ್ಟ್ ಡೀಟೇಲ್ಸ್ ಕೊಟ್ಟಿದ್ದು that was sent by the very hospital authorities. No specific name was given by the parents to the hospital to write it as such, my lord.
Okay. You are supposed to fill in the details and give it.
ಅಲ್ಲ ಅದು that is not coming forth from the records.
ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ಎಲ್ಲಿ?
ಅಲ್ಲ ನಂದು ಅಪ್ಲಿಕೇಶನ್ ನಾವು ತಗೊಳ್ಳೇ ಇಲ್ಲ ಅವರು ಡೈರೆಕ್ಟ್ಲಿ ಇದರಲ್ಲಿ ವೆಬ್ಸೈಟ್ ಅಲ್ಲಿ ಇದು ಮಾಡಿ ಅಪ್ಲೋಡ್ ಮಾಡಿ.
Who is the respondent counsel? The Bhushan Kulkarni is directed to accept notice for the respondent. He is also directed to place on record the application, if any, filed as regards the registration of birth of the petitioner, either by themselves or through the hospital, by next date of hearing. Released on 27th February.
Please, madam.
25, Susayam Patil.
Suit between brothers, my lord. Suit between brothers. His father had left some amount in the SB account. Suits for declaration and injunction, and I filed application to keep the amount in FD, and the honorable court rejected my application. And objections were that I may withdraw the amount. The order is at page number 36, my lord.
Order really?
Page number 36.
36.
Orders on I number 6. Page number 9.
36 Wakalat na.
Sorry, my lord. Page number mistake.
You have not mentioned the
One more
amount and
one
the details.
One more partition suit is there. Both are connected.
amount mention ಮಾಡಿಲ್ಲ and details of the account mention ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
There one more partition suit is there, and it is clubbed along with this matter, and it is also before the same court.
ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಡೀಟೇಲ್ಸ್ ಕೊಡ್ಬೇಕಲ್ಲ.
In the plaint it is written, and in the 20 lakhs it is mentioned.
ಅಕೌಂಟ್ ನಂಬರ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಇದ್ದಾರೆ.
Account number, it is in the application itself, my lord.
That is what the order is.
I
Apart from chances of withdrawing.
See, annexure C.
Not at all mention the amount in the application, both are.
Account number is given, my lord. Annexure C.
And the SB account number.
Annexure C, I have mentioned the account number.
Page?
Page I am missing, my lord, annexure C.
Account number ಕೊಟ್ಟಿದ್ದೀರಾ?
Please, and I have produced the, before this honorable court, that one more partition suit where I have mentioned the amount also, my lord.
Whose name is this SB account?
Please.
In the name of the father.
The name of the father.
Stay ಮಾಡಿದ್ರೆ no use for anybody.
It will be lying without interest, and both will not enjoy the amount, and it is not a small amount, 20 lakhs.
Issue notice to the respondents returnable by, emergent notice returnable by 28th March. The further proceeding in OS number 247 or 24 on the file of the third additional senior civil judge and CJM Dharwad is stayed till the next date of hearing. Both the petitioner and the respondent number 1 are also restrained from any manner dealing with the amounts lying in SB account bearing number 30006248228 of ಯಾವ branch ಇದೆ?
State Bank of India, Hubli.
State Bank of India.
Main branch.
Personal banking branch, Hubli, Kalburgi Complex, 104 Club Road, Hubli, till the next date of hearing. Process fee and copies to be furnished by end of day 24th February. Acknowledgement of service on the counsel for the respondents before the trial court to be filed on or before 3rd March. Failing either of which, the interim order will stand automatically.
26, Lakshman T. Pantagani.
I am for petition. But this is in respect of the labor. Here, the outsourcing agency has supplied the manpower to the petitioner institution, wherein their services were up to 14/1/2022. Accordingly, as per Annexure E, the authority has given a notice stating that your lordship kindly take Annexure E, wherein they have only up to 14/1/2022 their services have been terminated, and it was also intimated to the outsourcing agency. In fact, he also the outsourcing agency also, as per Annexure, informed to the laborers, stating that now the services they were taken for the services in the during COVID 2020-21. Now their services have been relieved. However, they are claiming that January only up to January they were worked. Now they are saying that again over and above 2 months they have continued. The labor court without considering, there is no appointment order and anything in respect of extending that. Now they are claiming that they are entitled for 2 more months. Your lordship kindly take Annexure page number 53, Annexure F, page number 53. Here, it was informed to the outsourcing agency.
Page number illa.
Please.
Page number
53, page.
How did it clear office objection? No page number.
Sorry, my lord. Sorry.
Office objection illde heng bantu?
Sorry, my lord.
9-10 ವರೆಗೂ ಇದೆ.
Annexure F.
ಇಲ್ಲಿ ಮತ್ತೆ 33 ಇಂದ ಶುರು ಆಗಿದೆ. Yes,
53. Yes, 53. Here it was informed to the outsourcing ಮೇಲ್ಕಾಂತಿ ವಿಷಯ ಹಾಗೂ ಉಲ್ಲೇಖ ಸಂಬಂಧಿಸಿದಂತೆ ಜಿಲ್ಲಾ ಆರೋಗ್ಯ ಮತ್ತು ಕುಟುಂಬ ಕಲ್ಯಾಣ ಅಧಿಕಾರಿಗಳು ಗದಗ ಇವರ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ವಿವಿಧ ಸಂಬಂಧಪಟ್ಟ ಸಂಸ್ಥೆಗಳಿಗೆ ಡ ವರ್ಗ ಹುದ್ದೆಗಳನ್ನು ತಾತ್ಕಾಲಿಕ ಹೊರಗುತ್ತಿಗೆ ಆಧಾರದ ಮೇಲೆ
ಮೇಸರ್ಸ್ BKR ಸ್ವಾಮಿ ಸೆಕ್ಯೂರಿಟಿ ಏಜೆನ್ಸಿ ದಾವಣಗೆರೆ ಇವರ ಸೇವೆಯನ್ನು ಈ ಹಿಂದಿನ ಜಿಲ್ಲಾ ಆರೋಗ್ಯ ಮತ್ತು ಕುಟುಂಬ ಕಲ್ಯಾಣ ಅಧಿಕಾರಿಗಳು ಗದಗ ಇವರು ಆದೇಶ ನೀಡುತ್ತಾರೆ. ಈ ಕೂಡಲೇ ಜಾರಿಗೆ ಬರುವಂತೆ ದಿನಾಂಕ 14/1/2022 ಅನ್ವಯವಾಗುವಂತೆ ಹೊರಗುತ್ತಿ ಸೇವೆ ಸಲ್ಲಿಸುತ್ತಿರುವ ಸಿಬ್ಬಂದಿ ಸೇವೆಯನ್ನು ಸ್ಥಗಿತಗೊಳಿಸಲಾಗಿದೆ. It was informed to the my lord outsourcing agency. Your lordship, next my lord annexer G, that is page number 55. My lord, the BKR, that is BKR Swami, that agency, outsource agency, intimated to the my lord their authority. ಇವ್ರಿಗೆ ಅಥಾರಿಟಿ ಹೇಳಿದ್ರು. ಮೇಲ್ಕಾಣಿಸಿದ ವಿಷಯ ಉಲ್ಲೇಖ ಸಂಸ್ಥೆಯಂತೆ ಜಿಲ್ಲಾ ಆರೋಗ್ಯ ಮತ್ತು ಕುಟುಂಬ ಕಲ್ಯಾಣ ಅಧಿಕಾರಿಗಳು ಗದಗ ಇವರ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ವಿವಿಧ ಸಂಬಂಧಪಟ್ಟ ಸಂಸ್ಥೆಗಳಿಗೆ ಉದ್ಯೋಗ ಈ ಹಿಂದಿನ ಜಿಲ್ಲಾ ಆರೋಗ್ಯ ಮತ್ತು ಕುಟುಂಬ ಕಲ್ಯಾಣ ಅಧಿಕಾರಿಗಳು ಅಲ್ಲ ಇರ್ಲಿಲ್ಲ, ಅದು ಕಂಟಿನ್ಯೂ ಮಾಡಿ ನಾವು ಅಲ್ಲಿಗೆ ಸ್ಟಾಪ್ ಮಾಡಿಸಿದ್ರು. 20 ಅಂದ್ರೆ ಸಣ್ಣ ಪುಟ್ಟ ಇದ್ದದ್ದು ಎಲ್ಲ ಮುಗಿಸಿ ಇದು ಮಾಡಿದ 22 ವರೆಗಿನ ಕಂಟಿನ್ಯೂ ಮಾಡಿದ್ರು. ನಾವು ದೇ ಆರ್ ಸೇಯಿಂಗ್ ದಟ್ ಓವರ್ ಅಂಡ್ ಅಬೌವ್ ಅಗೇನ್ 2 months ನಾವು ಕಂಟಿನ್ಯೂ ಮಾಡಿದ್ವಿ ಅಂತ. ದೇರ್ ಇಸ್ ನೋ ಎನಿ ಇಂಟಿಮೇಷನ್.
ಎಂಟ್ರಿ ಮಾಡರ್ ಏನು ಕೇಳಿಲ್ಲ
ಮಾಡಿ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಸಚ್ ಮಾಡಿ ಸ್ಟೇಯಿಂಗ್ ಅಪ್ ದಿ ಮರಡ್ ದಿ
ಕೇಳಿಲ್ಲ, ಏನು ಎಂಟ್ರಿ ಮಾಡಿಲ್ಲ ಇಲ್ಲಿ.
I'm sorry, Madam. I will answer by mistake, Madam. It has been
amendment application accepted.
But tomorrow. Pass I will have
amendment application.
Please.
27, Nitin Ramesh.
My lord, I appear for the petitioner.
Yes.
This is the issue, my lords. On the last date, construction license has been given to me on 22 January 2025. In just 8 days from there, a notice is issued for halting the construction, for saying that there is a violation of bylaw. Now that earlier round in 2024, a notice is issued to some person on 30/12/2024. A notice is issued based on a complaint made by someone claiming to be an activist, RTI activist, and a notice is issued to some person by name Amar Dalabanjan. Now he replied, your lordship will find that at my lords, this is at page 49, my lords. That is annexure F.
Yes.
Then to that person is supposed to have given a reply at annexure G, page 50, saying it does not concern. My lord, saying that this issue does not concern me, he sends a reply, my lords. Now what happens is, all of a sudden, I mean, that was also in relation to the same property, and in the reply he says that this does not concern me or my property. On that date there was no construction, nobody had sought for the license, none of that. I had later on, my lords, the petitioner is a lady who made an application, and license was given on 22/1/2025. In just 8 days from there, I have not started the construction, just basic work, a shed was being made. And because the officers there come under the pressure of the so-called RTI activist who makes allegations against the officers, in just 8 days, on 30th, which is the impugned order, just giving 3 days time, they say that you have to stop the construction. It is the complete violation of the natural justice principle. The lordship will kindly see the notice.
Yes.
is annexure A, my lords. The lordship will find that. Kindly see, my lords, what the annexure A says. May I read that, my lord?
Yes.
ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಹಗರಿ ಬೊಮ್ಮನಹಳ್ಳಿ ಪುರಸಭೆ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಬರುವ ವಾರ್ಡ್ ನಂಬರ್ 17 ಕೊಟ್ಟೂರು ಸರ್ಕಲ್ ಬಳಿಯ ಮಿಲಿಟರಿ ಬಯಲು ಏರಿಯಾದಲ್ಲಿ DN ಸುಮನ್, my lords, that is me, my lords, petitioner, ರವರ ಸಂಖ್ಯೆ ನಂಬರ್ ಸೋ ಖಾತೆ ಸಂಖ್ಯೆಯ ಜಾಗದಲ್ಲಿ ಪುರಸಭೆಯಿಂದ 22/1/25 ಕಟ್ಟಡ ನಿರ್ಮಾಣ ಮಾಡಲು ಪರವಾನಗಿಯನ್ನು ಪಡೆದಿರುತ್ತೀರಿ. ಆದರೆ ಸದರಿ ಸರ್ವೆ ನಂಬರ್ನಲ್ಲಿ ಬಿಲ್ಡಿಂಗ್ ಬೈಲಾವನ್ನು ಉಲ್ಲಂಘಿಸಿ ಕಟ್ಟಡ ನಿರ್ಮಾಣ ಮಾಡಿರುತ್ತೀರಿ ಹಾಗೂ ಈ ವಿಷಯದ ಬಗ್ಗೆ ತಮಗೆ ಮೌಖಿಕವಾಗಿ ಹಲವು ಬಾರಿ ತಿಳಿಸಿದರೂ ಕೂಡ ಕಾಮಗಾರಿಯನ್ನು ನಿಲ್ಲಿಸದೆ ಕಟ್ಟಡ ನಿರ್ಮಾಣವನ್ನು ಮುಂದುವರಿಸಿರುತ್ತೀರಿ. ಆದ್ದರಿಂದ ಈ ನೋಟಿಸ್ ತಲುಪಿದ 3 ದಿನಗಳ ಒಳಗಾಗಿ ಕಟ್ಟಡ ಕಾಮಗಾರಿಯನ್ನು ನಿಲ್ಲಿಸಿ ನೋಟಿಸಿಗೆ ಸಮಜಾಯಿಷಿಯನ್ನು ನೀಡಲು ಸೂಚಿಸಿದೆ. ತಪ್ಪಿದಲ್ಲಿ ಪುರಸಭೆಗಳ ಕಾನೂನು ಅಧಿನಿಯಮ ಪ್ರಕಾರ ಕಾನೂನು ಕ್ರಮ ಜರುಗಿಸಲಾಗುವುದು ಎಂದು ಈ ಮೂಲಕ ತಮಗೆ ಸೂಚಿಸಲಾಗಿದೆ.
Photographs of the construction.
My lords, there is no construction, my lords. We are just beginning. We have taken the loans. We are beginning to start. My lords, in 8 days, I can't do any major construction. So this is clearly influenced by that RTI activist who has made this complaint. If it was a case where I have completely built the compound or any such thing, my lords, and I have only built a shed, I have just begun to get the workers there. In 8 days, I can't make any major construction.
Here, on the complaint.
Michael,
sorry.
Sorry.
Sorry. But after receiving the complaint, he ought to have been giving opportunity, calling for him, conducting spot inspection, ought to have been done it. Your Lordship kindly, I will setting aside this. If at all there is, they will.
The petitioner is before this court seeking for the following leads. The petitioner claims to be the owner why is this not properly covered, Mr.
My lord, I'm sorry. I'm sorry, my lord.
Where is the property details? Kata number 6-Roman 2-1 and plot number 6-Roman 2-1.
In ward number 17, please.
Ward number
17 of Kottur Circle, my lords. Ward number 17 of Kottur Circle. My lords, in the notice itself, annexure A, my lords, page 18.
Ward number 17. Kottur Circle, Balia.
Oh.
So what is that property?
My lords, that is a survey number, my lords. Survey number 6-2, my lords, 6-Roman 2.
Sale deed.
Lords, the sale deed is at Krayapatra is the next one, lords. Annex at page 19. It is schedule is at page 25, lords.
This is 6-3.
No, my lord, 6-1 only. Kindly see the schedule, my lords.
Military Bayalu Agribomanalli.
Yes.
Sottina Sanke 4727. Ward Sanke 17. Sottina Hale Sanke Mattu Nidirna Sanke 6-Roman 2-3.
One.
You made an application for 6-1.
One only, my lords. The notice is also on one only.
Nim sale date is 6-3.
But here when
kindly see the schedule, my lords. Schedule, my lords.
ನಾನು ಕೊಟ್ಟಿದ್ರಲ್ಲಿ 1 ಅಂತಿದೆ
ಎಲ್ಲಿ
ಇದರಲ್ಲಿ ಸೇಲ್ ಡೇಟ್
schedule 25 ಅಲ್ಲಿ ಇದೆ 6-1 only 25 page 25
ಇದು ಇನ್ನೂ ಒಂದೇನೋ ಇದೆ ಕ್ರಯಪತ್ರ annexure C.
Lords, that is the adjoining, lords. The one in question is at page 25.
DS Suman aduno.
We have that also, my lords. But what was sought? Construction license was sought for 6-1. In 6-1. Notice also is on 6-1. Schedule is at 25, page 25.
6-1.
Yes, right.
Ward number 17.
Hogri Bomanalli Taluk.
Measuring 30 feet. 22 feet. Totally measuring 660 feet. The petitioner had applied for a plan sanction, which came to be granted on
22-1. 22-1.
22-1.
Yes, 25.
Yes. On the basis of an alleged complaint, a notice came to be issued by respondent on
Respondent,
31/2025, stating that there is a violation of the building bylaw and as such called upon the petitioner to stop construction activities within 3 days. It is challenging saying the petitioner is before this court. If there is any violation of the building bylaws or plan sanction, it is for the authorities to take necessary action. Under ನಿಮ್ದು ಯಾವುದು 60 ಯಾವ ಸೆಕ್ಷನ್ ಪಂಚಾಯತ್ ಅಲ್ವಾ
67 ಮುನ್ಸಿಪಲ್ ಹೌದು ಮುನ್ಸಿಪಾಲಿಟಿ ಆಕ್ಟ್ ನಾಗ ಬರ್ತದೆ ಟೌನ್ ಮುನ್ಸಿಪಾಲಿಟಿ ಎರಡು
Karnataka Municipalities Act.
ಮುನ್ಸಿಪಾಲಿಟೀಸ್ ಆಕ್ಟ್ ಅಂದ್ರೆ 87 ಅಲ್ವಾ?
No, yes, not KMC, municipalities.
ಇದು TMC ನಾ ಇದು?
ಇದು TMC.
Not village.
No.
Under section 87. ಯಾವುದು provision Mr. Mandagani? Under section 187 of the Karnataka Municipalities Act 1964, by giving out the details by setting out the details as regard the violation of the building bylaws and or the plan sanction. Without doing so, a notice to merely stop work could not have been given. In that view of the matter, I pass the following order. Writ petition is allowed. A certiorari is issued. The notice dated 31/2025 issued by the first respondent annexure A is quashed. Liberty is reserved to the respondent to initiate such action in terms of section 187 of the Karnataka Municipalities Act 1964. As a
Great.
28, Gauri Shankar Mott.
Milords, the petitioner is a business owner, Milords. Milords, he being interested in opening a business at APMC Hubli, had approached respondent number 2, seeking allotment of land.
You want refund?
Refund, Milords. Refund of the allotment, earnest money and the bond, Milords. National savings certificate was taken of rupees 5,000 and 65.
Yeah, nothing, Lordship.
ಹಿಂದೆ ಇದ್ದಾರೆ ಫೋನ್ ನೋಡ್ತಾ ಇದ್ದಾರೆ.
PN30.
Application made, amount deposited, no allotment made, refund claim, no refund given, stating you will allot them in the next allotment.
I will go through and I will.
Representation as mandamus.
No, I will go through that and I will make submission.
Pass over.
No, kindly next week any date. Next week.
4 page ಇದೆ ನೋಡಿ.
No, next week any date I will.
ನಿಮ್ಗೆ 13 ಜನ ವರ್ಕ್ ಮಾಡ್ಬೇಕು ಲಿಸ್ಟಿಂಗ್ ಗೆ. ಬೇಡ. Pass over.
I have some matters at in afternoon. I have some in VC.
ನೋಡ್ಬಿಟ್ಟು ಅವ್ರಿಗೆ ಹೇಳಿ, ಅವ್ರು ಹೇಳ್ತಾರೆ. Yes.
May
29, Omkar Desai.
may I pay?
ಹೆಸರಿಲ್ಲ ಹೇಳಿ.
Lord,
Admission to Ayurvedic courses, my lord, is governed by the, my lord, rules framed under the National Commission for Indian System of Medicine. The basic qualification, my lord, as prescribed under Rule 5, running phase 1.5, my lord. There's a twofold basic requirement is required for any admission to the Ayurvedic courses, my lord, like any other courses to professional courses. Number one, my lord, the eligibility criteria, number 5, my lord, eligibility criteria, my lord, that a candidate should pass, my lord, 10 plus 2
ವಿನಾಶ್ ಬನ್ಕರ್
ನಿಮ್ಗೆ ಕಾಯ್ತಾ ಇವಾಗ ಶುರು ಮಾಡಿ ಅವ್ರಿಗೆ ಕೇಳ್ಕೊಳ್ಳಿ.
Blood and admission to
ಕೊಟ್ಟಿದ್ದೀರಾ?
Admission to courses to like the professional course like Ayurvedic, is governed by the in the present case Ayurvedic is governed by the rules under the framed under the National Commission for Indian System of Medicine. There is a twofold requirement is required for any admission to the Ayurvedic course. Number one, Rule 5.1, which is a basic qualification, a candidate should pass 10 plus 2 equivalent examination in PCMB, minimum 50% marks taken together in physics, chemistry and biology with respect to general merit category. And with respect to SC, ST and other backward classes, it's required 40%.
ನೀವು ಯಾವ ಕ್ಯಾಟಗರಿ ನೀವು?
We comes under the other backward classes. I produce the OBC.
OBC-ಗೂ 40%.
40% ಇದೆ. Then the second basic qualification is most important, this national eligibility test, which has to be cleared. And there also, he should have passed 50 percentile. There is a percentile, but here is the percent. There is a percentile 50% to the JM candidate, and others with respect to is the 40 percentile. Admittedly, I was cleared in more than 50% in the NEET. There is no dispute it. Now I only passed PCMB. I got it. One is 48, another one is 44%. On that basis, I made an admission by the central agency, and I completed almost 1 year. Now the university, by the impugned order, has rejected my approval on the ground running page 81, below, it's only on the ground the below percentage of PCB 10 plus 2. Even though they have not given reasons, but the reasons what they state is, since I belong to OBC but belong to other states.
Are you OBC in this state?
That is, I am belong to the OBC in other states.
Are you OBC in this state?
That is, I'll come to whether I am OBC in this state, that may not be, required for considering my admission to, since my argument to that effect is, the rules which is framed by the central agency, the rules which prescribes 10 plus 2, 50% to the JM candidate, 40% to the OBC, it's by the national agency which is prescribed. If I am the qualified to admission to other state, 40% to the other state, then I have to be qualified in this state also. The reason is, no. If I am claiming the reservation, if I am claiming the reservations on the the benefit of the, then they say, if that call, if you are not an OBC, you may be the OBC in other state. Since you are not an OBC in this state, therefore, we will not provide you a reservation to that effect.
Any benefit?
No. That is my argument. This already the division bench has hold this.
Hold and that
that cannot be. The reason is, when the national authority frame the rules, this is the with respect to the qualification which is prescribed, by the national agency. There also, since whether I belong to other state, since that was already the rules which say that the OBC candidates, even though in the other state, has a benefit of getting admission if he has scored 40%. I'm sorry.
Usually the petitioner had not sought admission under reserved category, but was admitted under management quota.
ನಮ್ದ್ರಲ್ಲಿ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಅಡ್ಮಿಷನ್ ಆಗಿದೆ. ವಿ ಹ್ಯಾವ್ ನಾಟ್ sought any reservation to sought a reservation in the any benefit of the reservation by the state government authority. It was admitted to the management quota. My lord, para 5 notes, that's fine. Well, there also, my lord, in the division bench order, he has secured less marks in the NEET percentile, even though, my lord, he was eligible, my lord, he belonged to other state.
ಅದಲ್ಲಪ್ಪ ಇದ್ರಲ್ಲಿರೋದು.
ಹೌದು.
From what we see of
Please.
is that NEET PG reduced the percentile cut
Reduce
by 7.5 to 42.5 and 32.5.
Please.
Therefore, ಇಲ್ಲಿ ಎಷ್ಟು ಪರ್ಸೆಂಟೈಲ್ ಬಂದಿತ್ತು ಅಂತ
ಅಲ್ಲ ಅದು ನೀಟ್ ರೆಡ್ಯೂಸ್ ಆಗಿಂದನೂ ಮಿಲಾಡ್ he is not qualified. That is the reasons.
On account of reduction in percentile cutoff, the petitioner became eligible. Para 6.
Please, Milord. May I read para 5 notes? It is like make. Milord, I will just read para 2 onwards. What is the facts also? Just only 1 minute. Milord. The petitioner is a candidate belonging to other backward class category. He appeared for a NEET PG exams 2017. The petitioner did not qualify at the first instance, admittedly the central government by communication dated so and so in excess of powers under regulation 9 of the PG medical education amendment regulation 2012 reduced the percentile cutoff marks in NEET PG 2017 examination to 32.5 percentile for reserved category. Admittedly, the petitioner thereupon was declared eligible by the NEET, which is evident from the communication dated so and so. The petitioner was thereafter admitted to the postgraduate course MS Orthopedics on 35/2017. The respondent university, however, after the petitioner had completed 9 months of PG course, by communication dated so and so, informed the dean of the.
What is irrelevant is what the court has held is that once NEET approves, you have no business to say no. Whatever NEET has given admission, you have to accept.
That is accepted.
Till NEET has approved.
Here, the NEET is approved.
Which arise for consideration in this petition is whether the petitioner who was admitted to the PG course, as he was declared eligible for admission to the PG medicine course by NEET, can be disapproved by RGUHS. And they said no.
Once it is approved by the NEET, then university is not.
That is what has been held.
Since it's a central regulations, my lord.
ಅದ್ರ ಬಗ್ಗೆ ಏನಿಲ್ಲ
But still my argument.
In exercise of powers is binding on the admission of the petitioner, which is in accordance with norms which cannot be disapproved by the RGUHS.
They cannot make a discrimination simply because I belong to others. But
that is not. The only this one is once NEET
approves, then university is not having.
NEET approval agide.
That is only they saying that OBC PCMB alli nanu.
You have to take it up with NEET.
I'll secure instructions. Because copies notice agilla.
Led counsel for the petitioner by relying upon the decision dated 29th November 21 in WP number of the division bench dated 29 November 21 in WP number 33249 of 2018 submits that once NEET as the National Eligibility Entrance Test bracket NEET and approved the petitioners, the Rajiv Gandhi University of Health Sciences bracket RGUHS could not go beyond the said approval and disapprove the student. Shri Avinash Bandkar, who accepts notice for respondent number 1 and 2, seeks for and is granted 3 days time to obtain instruction, make a submission. ಯಾವ್ದಿದೆ exam? 3/3.
Third ಇದೆ.
Released on 25th at 2:30 p.m. Notice to respond number 3.
It may be dispensed.
Already is dispensed with. At
Please.
least.
30, Santosh Raut.
Divorce.
Please.
And
Please.
Priya.
This is a petition wherein the petitioner have challenged the order.
Wife, second wife, first wife, divorce ಆಗಿದೆಯಾ? ಅಡುವೆಯಪ್ಪ. ಸಲ ಇದು. ಇದೆ ಸೇಮ್ ತಾನೆ. ಅಡುವೆಯಪ್ಪ ಬಸಪ್ಪ. ನೆನ್ನೆ ಬಂದಿದ್ದ ಇದೆನಾ?
ಇದೆ ಸ್ವಾಮಿ.
ಹಾ.
In this case, what has happened, my lord? The respondent number 1 herein filed the suit for partition. Suit came to be decreed. I filed the appeal, wherein shares were modified. Thereafter, I prepared the RSA. During pendency of RSA, they concluded the FDP, wherein I have not been arrayed as a party. Even in the execution also they have not arrayed as a party. When I,
my lords, my friend is telling only half the things. Suit was decreed, awarding a share to the plaintiffs, and the trial court holds that he can work out his remedy in the FDP. This was set aside by the first appellate court, confirmed by the second appellate court, not taken in appeal again.
Irrespective of whatever it is, he was a party in the appeal.
Got himself
RA
impleaded.
as different number 5 to 7.
Yes, ma'am.
So if he was a party in
No,
that,
he did not challenge that order at all.
whether he has
FDP
challenged or
challenge,
not,
he has not challenged the FDP order. He
Yeah.
challenged the EP order after it was closed, my lord. So the writ petition filed against the side order was dismissed, that he is not a agree party. There the whole thing stops. Then he starts disturbing my possession. So I had to file a suit for injunction
he is a party in RA 73.
in OS.
RA 73 and OA
He has
73
filed,
5, 6,
his
7
prayer
ಬಂದ್ರು.
is rejected, my lords.
Prayer reject ಆಗ್ಲಿ, but
ಆಮೇಲೆ
all of them have
RSA
to be
ನು
made
reject
parties in the
ಆಗಿದೆ.
FDP.
Allah, since work out the remedy and that was rejected by the lower appellate court as well as the second appellate court.
Can you choose who you will
I
file?
understand that, my lords. To the extent of my share, I'm protecting my rights. To the extent of 1/10 share. His vendors are on record. They were aware of all the proceedings. They keep quiet. And now again they file another suit for partition.
Not on the factual aspect.
Allah, one more suit for partition is filed by the vendors.
We are not saying yes or no to that.
No, my
We are
lords.
only saying that if a person is a party to the suit and in the appeal,
I do admit, my lords.
then you go ahead with the FDP without making him a party.
The vendors were aware. Adrallu, vendors having known, they kept quiet. Now the grievance is suit for injunction is filed. Injunction is granted, confirmed in the MA, which is under challenge before this honorable court.
Challenging here.
My lord, after the passing of the order by this honorable court at ink page number 127, I filed suit for injunction against the respondent and others, my lord. During pendency of my injunction suit, they filed one suit for injunction against me, wherein injunction order was obtained. I filed MA, wherein MA was rejected, wherein the trial court and first appellate court says that it is not a bar to make us party in FDP and EP. There is no necessary to make us a party in FDP and EP. And considering the revenue records, injunction has been granted. To show my possession, my lord, if my lord may peruse the complaint given by the respondent's son, I think page number 240. 240. The complaint at 242. Wherein second paragraph. ಹೀಗ ಇರುವಾಗ ಈಗ ಸುಮಾರು ದಿನಗಳಿಂದ ನನ್ನ ತಾಯಿ ಸಿದ್ದವ್ವ ಸೋಯನ್ಸೋ ನಾಡುಗಡೆ ಇರುವರ ಕಬ್ಜಾ ಇರುವ ರಿಸಾ ನಂಬರ್ 3 ಎಕರೆ ಸೋಯನ್ಸೋ ನಮ್ಮೂರು ಸೋಯನ್ಸೋ ಇವರು ಕೂಡಿ ನನ್ನ ತಾಯಿಗೆ ವಿನಾಕಾರಣ ತಂಟೆ ಮಾಡಿ ನಾವು ನಿಮಗೆ ಜಮೀನು ಬಿಡುವುದಿಲ್ಲ ಅಂತ ಕಾರಣ ತಾವು ಸದರಿಯವರನ್ನು ಕರೆಸಿ ಯೋಗ್ಯ ಚೌಕಾಶಿ ಮಾಡಬೇಕಂತ ನ್ಯಾಯ ದೊರಕಿಸಿಕೊಡಬೇಕಂತ ವಿನಂತಿ.
This is an order passed on injunction application.
Yes, my lord.
The injunction application only, they have considered who is in possession.
Yes, my lord.
You are not challenging the FDP order.
No,
My lord, that has been challenged, my lord.
ಯಾವ್ದು?
FDP
FDP
ಫೈಲ್ ಮಾಡಿ
ಮಾಡಿದ್ರಿ.
ಎಲ್ಲಿ?
RA ಫೈಲ್ ಮಾಡಿತ್ತು. RSA is pending, my lord.
ಮತ್ತೆ ಅದ್ರಲ್ಲಿ ಸಕ್ಸೀಡ್ ಆಗೋರ್ಗು ಇಲ್ಲಿ ಬರಕ್ಕಾಗಲ್ಲ.
My lord, FDP order ನಲ್ಲಿ ಡಿಲೇ ಆಗಿತ್ತು.
ಆಯ್ತಪ್ಪ, but now the FDP order is there.
FDP order is there. Based on that, the first appellate court says arraying us as not necessary party, hearing is not necessary. Agreed by that, RSA is pending, my lord.
ಆಯ್ತು. So until that order is passed, that order will be applicable.
My lord, my submission, my lord. If my lord may peruse the execution order, my lord. Execution order. I have produced the entire order sheet of the execution case. If my lord may peruse pink page number 112. 112.
Yes.
The execution was claimed to be closed on the memo filed by the decree orders, my lord, wherein actual possession was not taken. The court says delivery warrant was executed for say of DHR. Actual possession had not had been taken by the
Five 12. It is very
Delivery
clear
warrant
that
executed.
executed.
For
but-
say of DHR.
actual possession was not at all taken, my lord. If they could have taken, I could have immediately filed something.
Where is the shara relating to the delivery warrant?
My lord, I have produced the order sheet, my lord.
Order sheet
Shara
ಇರತ್ತಪ್ಪ. Delivery warrant shara ಬೇರೆ ಇರುತ್ತೆ. ಮಾಜರ್ ಇರುತ್ತೆ.
Mazar, I did not produce, my lord. I will produce, my lord.
That is why it was posted to another day for say of DHR ಏನಪ್ಪ ಹೇಳ್ತೀಯ ಬಂತ ನಿಂಗೆ ಪೊಸಿಷನ್ ಪೊಸಿಷನ್ ಬಂತು ಅಂತ ಹೇಳಿ ಕ್ಲೋಸ್ ಮಾಡಿದ್ರು.
ಇಲ್ಲ. That if my possession is disturbed, my lord, I could have filed, so at least
1220 is delivery warrant executed.
that in the order sheet it has been recorded. But if my possession is disturbed, I ought to have filed something. Thereafter, I filed a writ petition. Then I filed the suit, my lord. This order was recorded. Order was recorded in 5/12/2020, my lord. Thereafter, I filed the
ಬೇರೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ that without being made a party to the FDP ಆಯ್ತು ಅಂತ. That is not what is under challenge here. That is a challenge in the RSA.
my lord, my submission, my
He
lord.
cannot be deciding on that when it is pending in the RSA.
Please, my lord.
ಎರಡ್ ಕಡೆ ಮಾಡಕ್ಕಾಗಲ್ಲ. So until that happens, that is final.
My lord, my request is, my lord, pending disposal of RSA, and when I have not been arrayed as a party to the FDP, at least status quo, status quo order.
RSA ಅಲ್ಲಿ ಕೇಳ್ಕೊಳ್ಳಿ. We can't substitute ourselves for RSA when the RSA
My
is
lord,
pending.
when they're pleading in the plaint itself, my lord, pursuant to the FDP and EP, we have taken possession to substantiate that they have produced the record of rights. But they have not produced any warrant regarding actual delivery of possession.
Mazar produce ಮಾಡಿ. ನಿಮ್ಮ ಹತ್ರ ಅದು
Please,
ಇದೆ.
minutes. The EP, against the EP, they filed a writ petition that was dismissed on that very count. my lords.
My lord,
It's also produced at
Back in
annexure J.
that is also I have produced. That is
Annexure
page number
H, my lords.
127.
Huh?
127, my lord.
127.
Wherein it has been observed by this honorable court, when I am not a party to the execution proceedings, obviously execution cannot obviously be agreed by the order by which the execution petition has been closed. ನನ್ನ ಪಾರ್ಟಿನೇ ಇಲ್ಲ ಅಂದ್ರೆ ನಾ ಅಗ್ರಿ ಆಗಲ್ಲ ಅಂತ ಅಬ್ಸರ್ವೇಷನ್.
Mazar report produce.
Please, my lords. In spite of all this, the plaintiff who has succeeded in the suit throughout, is not able to enjoy her property to the extent of 1/10 share, my lords. The other share which they have purchased is in their possession. Their vendors again filed another suit.
Direct counsel for respondent seeks fund is granted.
Respond number one.
Yeah,
15 days, means 2 weeks.
15 days.
2 days, means, because the old records.
Direct counsel for respondent seeks fund is granted 2 days time to produce the Shara stroke Mazer as regard the delivery warrant which was executed as reflected in the order dated 5/12/2020 and EP number 30 of 2019.
Please.
We list on 25th at 2:30 p.m.
Till then status quo orders.
ಮತ್ತೊಂದು ಜಗಳ ಸ್ಟಾರ್ಟ್ ಆಗತ್ತೆ.
ಇಲ್ರಿ ಪೊಲೀಸ್ ಕಂಪ್ಲೇಂಟ್ ಆಲ್ರೆಡಿ ಆಗತ್ತ.
ಅಲ್ರಿ ನೀವು ನಮ್ಮ ಪೊಸಿಷನ್ ಯಾಕೆ ಇದು ಮಾಡ್ಬೇಕು? We have taken 2 injunction orders against us.
You basic things that you should have got it.
31 Sonu Suhel.
I am for petitioner, my lord. Writ of mandamus, my lord. Petitioner seeking direction of respondent number 3 to consider the report of respondent number 4, my lord, wide annexure L. My lord, petitioner are original residents of Sidhalli village of Hukkeri Taluk and are refuse of Ghataprabha dam backwater, my lord. They are lost their house and entire property, my lord. Now they are residing Prabhunagar village and district Belgavi, my lord. My lord, day before yesterday, I argued before this honorable court. This honorable court directed to the respondent to file affidavit on 24th, my lord. Both are similar matters, my lord.
24th. That AG accepts notice for respondent number 1 to 4, connect with so and so, released on 24th.
Much obliged.
32 Ingraj Mardi.
This is a writ of mandamus. The notification was issued in the 2009 and 2002 they are taking possession, and the Honorable Apex Court already specific direction in the annexure V, my lord, annexure P, page number 40, my lord. It is specific direction that, my lord, to conclude an inquiry and to conduct to identify that whether the possession has been taken 2002-2009. 2009 notification, 2002 they are taking possession. We have entitled for the rent and damage under section 48 of the Land Acquisition Act, and the specific judgment is also mentioned by the Apex Court. After 1 year also till today they have not conducted any inquiry regarding the rent and damages.
Balcott Development Authority.
That R3 is for the GK Hiregaoder.
And AGA accepts notice for respondent number 1 and 2. Shri GK Hiregaoder is directed to accept notice for respondent number 3. Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that the representation submitted by the petitioner dated 14/3/2024 at Annexure C and 2011/2024 at Annexure C1 in pursuance of the order passed by the Honorable Apex Court in SLP number 16025 of 2019 is yet to be considered. The order of the Honorable Apex Court was passed on 6th February 24, directing the Special Land Acquisition Officer to verify whether the petitioners have been dispossessed from the property, and if so, to take action as indicated therein. It was therefore required for the SLO to act in terms of the order of the Honorable Apex Court and do the needful at the earliest. Not having done that resulted in the petitioner filing a representation on 14/3/24 and again on 2011/2024, despite which the SLO has not taken any action. In that view of the matter, writ petition is allowed. The respondent number 2, special deputy, the respondent number 3 is directed to act in terms of the order passed by the Honorable Apex Court in SLP number
16.
16025 of 2019 and consider the representation of the petitioners dated 14/3/2024 at Annexure C and 20/11/2024 at Annexure C1 within a period of 30 days from today and pass necessary orders within 30 days from today.
33, Satish, MS.
Please.
30 days from today, Allah. Mr. Mardi, 30 days from receipt of copy of this order. Receipt of copy of this order. Yes, Mr.
Because the order under challenge is at Annexure E, my lords, wherein the application is filed by the respondent number 1. Suit for partition and separate possession.
You are?
I am the father-in-law of the plaintiff.
You are a party, not a party.
I am party, my lords. I am a party in the suit.
Plaintiff or defendant?
Insofar as, my lords, my respectful submission is, the very same properties are under challenge in regular appeal filed by one Shanta. The same properties are also being challenged in a suit for partition by one Shanta. That is the wife of petitioner's brother. She has filed an appeal challenging the very same property and challenging the will. Under the will, the present respondent number 1, who is the plaintiff, she is claiming a share. That will is under challenge in RA, in regular appeal, my lords, 5039. That is still pending consideration before.
First,
I am the, my lords, the father-in-law.
Father-in-law, are you a party to the suit?
Yes, I am the party to the suit.
As what? What is
My
your
lords,
rank?
as a defendant, my lords, defendant number 1.
What is the application which has been filed?
Application, my lords, under section 19 of the Hindu Adoption and Maintenance Act, seeking, my lords, maintenance by the daughter-in-law.
Yes.
And now, my lords, the said application came to be allowed, granting, my lords, 6,000 rupees as a maintenance. And insofar as the very same property which she is claiming, my lords, partition and claiming that I am in possession, that was gifted by my sons, as per Annexure J, my lords, for my maintenance. I have got the only property under which, my lords,
Plaintiff is your daughter-in-law,
yes,
who is estranged from your son.
lords, I'm ready to give her a residence. I have informed her to come and join with us, but she has voluntarily she has left out, and now she is claiming a maintenance. There is a, my lords, Annexure J, my lords, there is a gift deed executed by her husband in my favor as a maintenance, my lords, for my wife and myself, and that is 1 acre.
Your son.
Yes, my son has executed.
Your
Both
son
sons.
and your daughter-in-law not staying together,
No, my lords.
estranged.
Please, my lords.
Where is your son?
No, my lords, he has died.
He has died.
He has died. The first son has died, and second son, my lords, he is the respondent number 3 before this court. And
Whose wife has filed another suit?
The first son wife has filed a suit claiming maintenance. And the very same property, my lords, there is an appeal pending for consideration, wherein the will which she is claiming a share is under challenge before the district court.
You are only directed to pay maintenance. At
Insofar as, my lords, maintenance is concerned, my submission is at Annexure J, my lords, they have executed a gift deed in my favor for my maintenance. That is only 1 acre 31 cents, my lords. And by virtue of that property, my lords, I am maintaining myself and my wife. Now she is claiming maintenance as against me. Annexure J, my lords, is the gift deed for my maintenance. It has been executed by her husband. That is the husband of plaintiff. Because there is a will executed by my father, granting the entire share in respect of grandchildren. To protect my interest, my lords, to maintain myself, they have executed a gift deed. Only on that property, my lords, I am taking shelter and I am having my daily, I am earning my daily food.
It is her husband's property. It may be your son.
Because the very same property, my lords, they have gifted out for my maintenance.
This is your daughter-in-law who is 25 years and your granddaughter who is 3 years. Or you don't want to give maintenance.
My lords, my submission is, I am not denying the maintenance, my lords. Insofar as, my lords, the property which they have gifted me as a maintenance.
It is not under challenge here.
But I am, my lords, I am ready to give them a shelter. I have informed them, but I am ready to give the shelter. But trial court, my lords, has a.
You have said 6,000 rupees kodi, I am in a shelter. No. What is under challenge is the maintenance which has been awarded,
yes,
not the suit.
Not the suit, but the property. What she has stated in the application is, by virtue of that property, I am getting the income. It is given for my maintenance, my lords.
Maintain
maintain ಮಾಡೋದಕ್ಕೆ I am, my lords, ready, but
You are
insofar as I'm
also
ready to give.
51 years only, not too old.
Allala, that
You
is
can
not,
take care of yourself.
that is not.
They are
very-
25 and 4 years. ಯಾರು ನೋಡ್ಕೊಳ್ತಾರೆ? ನಿಮ್ ಗ್ರ್ಯಾಂಡ್ ಡಾಟರ್ ತಾನೆ?
Alla, so far as that aspect.
Don't do these kind of things. Just because your son has expired, she is a daughter-in-law, let her take care of herself.
Alla, I'm not on that point, notes. Insofar as the properties are
Not you,
concerned.
your client. Notice to the respondents is dispensed with in view of the proposed order to be passed. The petitioner is before this court seeking for the following reliefs. Respondent number 1 and 2 had filed a suit in OS number 127 or 23 before the additional civil judge in JMFC Hospete, seeking for partition and separate possession of the properties described in the schedule thereto. Pending consideration of the said suit, the plaintiffs had filed an application IA number 3 under section 19 of the Hindu Adoption Maintenance Act, seeking for interim maintenance from defendant number 1. Defendant number 1 is the father-in-law of plaintiff number 1 and grandfather of plaintiff number 2. His son having expired, the plaintiffs are living separately, and their contention was that they have not been, their rights in the properties have not been made available, and they have no other source of income to take care of themselves. The defense urged by the petitioner herein was that the husband of plaintiff number 1 and father of plaintiff number 2 had during his lifetime executed a gift deed of the properties in favor of defendant number 1, and those being the only properties. There is no other mode of income for defendant number 1, and as such it is contended that the awardal of maintenance of 6,000 rupees per month is not proper, and as such the said order dated order dated 19/4/2024 is under challenge in these proceedings.
1910.
19/10/24 is under challenge in these proceedings. Having perused the said order, it is clearly seen that plaintiff number 1 is about 25 years of age and plaintiff number 2 was about 3 years of age then and now about 4 years. The maintenance which has been awarded, the relationship between the parties is not in dispute. It's also not in dispute that the husband of plaintiff number 1, son of defendant number 1, has expired, leaving behind a child of 3 years. In that view of the matter, the trial court, considering that there would be requirement for clothing, food, education, medical assistance, and other essentials for survival, the wife and children cannot be neglected by the father-in-law, has directed payment of a sum of rupees 6,000 per month as maintenance. I do not find any infirmity in the said order. The petition stands dismissed at the stage of admission itself.
Lakshman T. Mantalani.
I am from petitioners. But the petitioners are the landless agriculturists, wherein in view of section 94A, they filed the application seeking regulation of their unauthorized cultivation.
Challenging a order of 2021.
Yes. But here it was served lately, your lordship kindly see, here, though the deputy, the revenue inspector, as per Annexure D,
ಬೇರೆ ಯಾವ್ದು petition? Challenging an order of
challenging the order Annexure E and E1, E and E1. Here, they are cultivating the land, since 18 years. In view of section 94A, they have filed an application under section 57 seeking regulation of unauthorized cultivation.
Hmm.
For that, my lord, the Tahsildar directed the revenue inspector for conducting a spot inspection and submitting a report. Your lordship can take on page number 28 Annex D is the, my lord, the report of the revenue inspector. He specifically, my lord, mentioned ಸದರಿ ಸೆಕೆಂಡ್ ಪ್ಯಾರಂದ ಸದರಿ ಸರ್ವೇನಾಮ ಜಮೀನನ್ನು ಸದರಿ ಅವರು ಸುಮಾರು 18 ವರ್ಷಗಳ ಹಿಂದಿನಿಂದಲೂ ಸದರಿ ಜಮೀನನ್ನು ತಮ್ಮ ಕಬ್ಜೆಯಲ್ಲಿ ಇಟ್ಟುಕೊಂಡು ಅಕ್ರಮ ಸಾಗುವಳಿ ಮಾಡುತ್ತಾ ಬಂದಿರ್ತಾರೆ. ಹಾಗೂ ಸದರ ಜಮೀನು ಕಲ್ಲು ಹಾಗೂ ಕಡಕದಿಂದ ಕೂಡಿದ್ದು ಇದನ್ನು JCB ಹಾಗೂ ಟ್ರ್ಯಾಕ್ಟರ್ ಬಳಸಿ ತುಂಬಾ ಕಷ್ಟಪಟ್ಟು ಅಭಿವೃದ್ಧಿ ಮಾಡಿ ಸಾಗು ಮಾಡುತ್ತಾ ಇದ್ದರು. ಈ ಮೇಲಿನ ವಿಷಯಗಳು ಜವಾಬ್ ಪಂಚನಾಮ ಹಾಗೂ ಸ್ಥಾನಿಕ ಚೌಕಶಿ ಮೇಲಿಂದ ತಿಳಿದು ಬಂದಿರ್ತದೆ. ಹಾಗೂ ಸದರ ಜಮೀನನ್ನು ಈಗಲೂ ಕೂಡ ತುಂಬಾ ಅಭಿವೃದ್ಧಿಗೊಳಿಸಿ ವ್ಯವಸಾಯಕ್ಕೆ ಅನುಕೂಲ ಮಾಡುವಂತೆ ಜಮೀನನ್ನು ಮಾರ್ಪಡಿಸಿ ಸಾಗು ಮಾಡ್ತಾ ಇರ್ತಾರೆ. ಈಗ ಸದರ ಜಮೀನಲ್ಲಿ ಗೋವಿನ ಜೋಳ ಬೆಳೆಸುವುದು ಕಟಾವು ಮಾಡಿದ ಬಗೆಯ ಕುರುಹುಗಳು ಜಮೀನಲ್ಲಿ ಕಂಡು ಬರುತ್ತದೆ. ಸದರಿಯವರು ಜಾತಿಯಿಂದ ಇರುತ್ತಾರೆ. ಈಗ ಸದರ ಕುಟುಂಬದ ಉಪಜೀವನವು ಸದರ ಜಮೀನನ್ನೇ ಅವಲಂಬಿಸಿರುತ್ತದೆ. ಲಾಸ್ಟ್ ಮೆರಡ್ ಆದ್ದರಿಂದ ಅಕ್ರಮ ಸಾಗುವಳಿದಾರರ ಮಂಜೂರಾತಿ ಅರ್ಜಿಯನ್ನು ಅಕ್ರಮ ಸಕ್ರಮ ಯೋಜನೆಯಡಿ ಭೂ ಮಂಜೂರಾತಿ ನೀಡಲು ಅಡ್ಡಿ ಇಲ್ಲ ಅಂತ ಮಾನ್ಯ ಆಧಾರ ಪೂರ್ವಕ ಸಾದರಪಡಿಸಲಾಗಿದೆ. But this is the revenue inspector who has recommended for my lord regularization, wherein my lord the Tahsildar, in fact, my lord Annex E, page 30, my lord. My lord, in class 3 ದಲ್ಲಿ ಇದರಂತೆ ಉಲ್ಲೇಖ 4ರ ಪ್ರಕಾರ ತಹಶೀಲ್ದಾರ್ ರಾಯಬಾಗ್ ಇವರು ಅನರ್ಹ ಅರ್ಜಿಯನ್ನು ನಿಗದಿ ನಮೂನೆಯಲ್ಲಿ ಮಾಹಿತಿಯನ್ನು ಭರ್ತಿ ಮಾಡಿ ಮಂಜೂರಾತಿಗೆ ಅನರ್ಹವಾಗಿರುತ್ತಾರೆ. Just my
Where
lord,
is the Tahsildar's report?
he has not given anything, my lord. Behind my back, my lord, all those things have been happened only without giving an opportunity.
ಇದರಂತೆ ಉಲ್ಲೇಖ 4ರ ಪ್ರಕಾರ ಉಲ್ಲೇಖ 4 is ತಹಸೀಲ್ದಾರ್ ರಾಯಬಾಗ್ ತಾಲೂಕು ಇವರ ಪ್ರಸ್ತಾವನೆ. ಏನ್ ಡೇಟು ಗೀಟ್ ಏನಿಲ್ಲ,
ಏನ್ ಅನರ್ಹ ಆಗಿರ್ತಾರಂತೆ ಕೊಟ್ಬಿಟ್ರು.
ಓರಲ್
Even without notice to them, will also.
ನಮಗೂ ನೋಟಿಸ್ ಕೊಟ್ಟಿಲ್ಲ.
ಅದು ಇಲ್ಲ. ಬಟ್ ಇದೇನ್ ಪ್ರಸ್ತಾವನೆ ಅಂದ್ರೆ ಡೇಟ್ ಏನಿಲ್ಲ, ಬೇರೆ ಎಲ್ಲದಕ್ಕೂ ಡೇಟ್ ಇದೆ.
Fresh consideration, madam. Your lordship may direct the authority to file pass fresh order.
And AG accepts notice for respond number 1 to 4. The petitioner is before this court seeking for the following reliefs. Aim of the petitioners is that they have been in unauthorized cultivation of the land in survey number 120 of Nagral village, measuring about 3 acres, 30 guntas, from the last about 18 years, and as such they had filed form number 57, regularization of their unauthorized occupation. The revenue inspector vide his report at either date ಏನು, either date ಇಲ್ಲ,
Annex D
ದಿನಾಂಕ blank.
ಅದು ಬ್ಲಾಂಕ್ ಬಿಟ್ಟಿದೆ. That is also.
Has that been given or not? That is not even referred in annexure E.
ಅದು ಹೇಳಿ Annex E ದಲ್ಲಿ ಅದು ರೆಫರ್ ಮಾಡಿಲ್ಲ. ಇದು ಜಸ್ಟ್ ಅನರ್ಹ ಇರ್ತಾರೆ ಅಂತ ರೆಕಮೆಂಡ್ ಮಾಡ್ಬಿಟ್ರು.
But ಇದಕ್ಕೂ ಡೇಟ್ ಇಲ್ಲ.
That is both revenue inspector and Tahsildar, revenue authorities.
The petitioners claim that the revenue inspector, delete ಮಾಡಿ ಅದನ್ನ. The petitioner claimed that the revenue inspector while annexure D had recommended the regularization.
D1.
D and D1. However, a perusal of both D and D1 indicates that there is no reference number nor is a date indicated in the said perusal bed. I think that as recommended. The Deputy Commissioner respond number 1, respond number 2, while annexure E and E1 has rejected the form 57 filed by the petitioners on the ground that the Tahsildar has submitted a report that the petitioners are not eligible. It is challenging the same. The petitioners are before this court. The submission of Sri Lakshman Mandkani, learned counsel for the petitioner, is that once the revenue inspector had recommended, the Tahsildar ought to have accepted the same and not have submitted a contrary proposal. And as such, and further, that the revenue inspector's recommendation has not been considered by the deputy commissioner in the impugned order. Furthermore, he submits that the order of the deputy commissioner has been passed without furnishing the Tahsildar's report to the petitioner and providing an opportunity to the petitioners to make their submissions in relation thereto. As such, he submits that the impugned orders are required to be quashed. Heard, learned counsel for the petitioner, learned AG and perused papers. Though the petitioners claim that the revenue inspector had recommended the regularization of the unauthorized occupation of the petitioners in terms of Annexure D and D1, a perusal thereof does not indicate any reference number or a date. Insofar as the order of the deputy commissioner placing reliance on the report of the Tahsildar, Annexure E also does not refer to a date of the report of the Tahsildar, except to contend that there is a recommendation made by the Tahsildar that the petitioners are not eligible. Be that as it may, this report of the Tahsildar has not been furnished to the petitioner and they have not been provided an opportunity to rebut the said report as rightly contended by Sri Lakshman Mandani, and counsel for the petitioner. In that view of the matter, I pass the following order. Writ petition is allowed. A certiorari is issued. The orders dated 25/9/2024 passed by second respondent at Annexure E and D1 are quashed. The matter is remitted to respondent number 2 for fresh consideration. The respondent number 2 is directed to furnish the report of the Tahsildar to the petitioners to enable them to submit their written reply thereto. The respondent number 2 shall also ascertain the veracity of the report submitted by the revenue inspector and take the same into consideration while deciding the matter. Matter afresh in accordance with law. Pending IS.
35, Irangouda Kapoor. Please.
It's for petitioner's notes. That's petitioner is plaintiff slash decree holder. The suit is filed by the plaintiff for recovery of money, recovery of amount to the tune of rupees 12 lakhs. When decree was done in my favor, it was party decreed. The operative portion is at page number 25. That is Annexure B. But subsequently, I filed an execution petition. Here, the respondent the defendant was placed ex parte. The notice was issued to him, but
How was it served?
Sorry,
How was it served on?
Court notice only.
Court notice ಹೆಂಗಾಗತ್ತೆ? Defense personnel ಗೆ defense personnel ಗೆ ಹೆಂಗಾಗತ್ತೆ? Court
No, he was working there in the same address. Previously, before filing of the suit itself, a legal notice was also issued in that regard, He
Where
was
is the
working in the
address?
same place, in the same address.
The plaint.
Plaint is at Annexure A, page number 11.
So he is at Tamil Nadu Battalion, execution petition. No?
Please,
Plaint ಅಲ್ಲಿ Tamil Nadu Battalion.
Please.
So how do you serve a notice on a person serving in the Indian Army?
That's through the superior officers,
So where is that service?
The court was held sufficient. I do not have the document with me right now, It was served, it was held, it was placed ex parte as served, is what is written
The report of the superior officer, commanding officer received.
Please, he has to
Where is
receive
that?
it. That document is not produced here, by way
Produce,
of
ma'am.
annexure.
ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ?
It is not available with me right now, at the top of my hand,
You have it in your office or your client has it? Your counterpart has it, sir.
Yes, I'll have to verify.
Counsel for the petitioner seeks for and is granted a week's time.
Please, I'll verify.
Produce the service report of the summons on the respondent in the suit in voice number 570 of 2022 in terms of order. Rule 28 of Order 5 of the Code of Civil Procedure. And the report received from the commanding officer in that regard.
I'll keep it, please.
Relist on 27th.
27. So what has happened in that, my lords, defendant is due to retire on 28th and the retirement benefits is.
Served to the commanding officer, yes.
Yes, I'll keep that present. I'll keep that present.
36, Hirangauda, Kapoor.
Please. Let's hear, let's, the petitioner, let's, is a challenging, let's, annexure C, let's, that is the fresh proceedings initiated to acquire my land. Let's, my land is survey number 46/2, let's, to the extent of 7 acres, 16 guntas. But now what has happened in this case? Now there's a village called as Hirehalli Grama. That's what has happened. Now there was a requirement of a bus stand there, and this task was it was tasked to respondent number 5, let's, divisional controller KKRTC, to let's identify a place as to where it could be built. Let's now initially it was identified by way of annexure B, lots, survey number 136 to the extent of 20 guntas was to be acquired, lots. And a detailed report, DPR, was also in that regard sent to the approval. That is at annexure B, lots, page number 14. Subsequently, lots, even to the extent of rupees 5 crores is what they demand for the development of the bus stand also. Let's, at the fact end, when the last step of acquiring of the land, suddenly they deem it appropriate. I don't know how much.
Because that is in a different person. They don't know the ownership. Those issues are there. So it will get delayed.
Let's please, now this was the initial proposal that was sent. Now they do not conduct any spot inspection with regards to my land, nor they approach me. Suddenly, page number 22, annexure C, they say now 136, instead of 136, 46 will be acquired.
1 to 4. Shri Prashant Osmani is directed to accept notice.
Siddhu Bhuti, Your Lordship, I think. KKRTC, Your Lordship, Siddhu Bhuti.
KKRTC.
Siddhu Bhuti, Your Lordship. Siddhu Bhuti. Prashant Osmani, NW KRTC.
NW. Ella RTC. Prashant Bodhi.
Siddhu Bhuti.
Siddhu Bodhi. For respondent number 5, counsel for the petitioner to furnish 2 sets of the petition along with annexure on the said counsel. Relist on 27th February.
Please.
37, Manjunath, Karigannavar.
In this matter, my lord, instead of will, I have mentioned the gift deed in the entire petition, my lord. Some correction I have.
ಹಾಕಿದ್ದೀರಾ?
ಮಾಡಬೇಕು. I have to file application, my lord.
ಯಾವಾಗ ಹಾಕ್ತೀರಾ?
Within 2 days, I have filed, my lord. In this matter, what happened? On the basis of will, I have made application to mutate my name. Same was allowed. Only contention by the respondent R4, my lord, is that she filed a suit for declaration and sought for only temporary injunction.
Subject to civil code.
That is order passed by the Tahsildar. AC confirmed that order, but the DC reversed the order.
DC reversed the order?
Yes, my lord. Though Tahsildar stated that it is subject to the result of the suit.
DC ಏನು ಮಾಡಿದ್ದಾರೆ?
My lord, page number 38. ಪುನರ್ನಿರೀಕ್ಷಿತ ಮನೆಯನ್ನು ಪುರಸ್ಕರಿಸಿದ್ದು ಆದೇಶವನ್ನು ರದ್ದುಪಡಿಸಿದೆ.
ಬಾಧಿತ ಪಕ್ಷಗಾರರು ಮಾನ್ಯ ದಿವಾನಿ ನ್ಯಾಯಾಲಯದಿಂದ ಪರಿಹಾರ ಅಲ್ಲಿಂದ ಆರ್ಡರ್ ತಗೊಂಡ್ ಬರ್ಬೇಕು.
AC and DC is held against him, Your Lordship.
No, Tahsildar AC ನಮ್ಮ ಪರವಾಗಿ DC
Held against the
respondent for.
AC ಏನಂದ್ರು?
Page number 30, Tahsildar. Before the passing of the order, not 2 lines.
ಉಭಯ ಪಕ್ಷದ ಮಾನ್ಯ ದಿವಾನಿ ನ್ಯಾಯದ ಖ್ಯಾತಿಯರು ಅಸು ದಾವಾ ನಂಬರ್ 82/2023 ಅಂತಿಮ ಆದೇಶಕ್ಕೆ ಬಾಧಿಸು ಅಂತ ಅಭಿಪ್ರಾಯಪಟ್ಟು ಪ್ರಕರಣದಲ್ಲಿ ಈ ತರಗೆ it was allowed by the Tahsildar to mutate my name
While the suit was pending.
He doesn't say suit. He says allow the application.
Please.
Assistant
application
Commissioner-
for not to originate was allowed by the trial court, my lord.
Assistant Commissioners confirmed it.
Yes, my lord.
Deputy Commissioner is rightly said, you get the order from the court.
My lord, status quo may be in respect of mutation, it can be.
Suit says, ಆಗುವವರೆಗೂ ಹೆಂಗ ಕರೆಕ್ಟ್ ಆಗಿ ಮಾಡಿದ್ದಾರೆ ಆರ್ಡರ್. And AG accepts notice for respond number 1, 2, 3. Vivadiraj P. Vadavi, who has filed caveat, accept notice for respond number 4.
Three.
The petitioner is before this court seeking for the following reliefs. Submission made by the petitioner is that there is a mistake which has occurred in the petition. What was required to be mentioned was a will,
Yeah.
was that the petitioner claims under will and not a gift deed.
Yes.
And as a gift deed. As such, the words gift deed mentioned in the petition have been considered to be as that of a will.
Three.
The claim of the petitioners is that one Mehboob B. Qasim B. Gadad, mother of the petitioner and respond number 4, had executed a will dated 21/10/2022, bequeathing the property in RS number 801 measuring 14 acres 29 guntas in Anigiri village, Anigiri Taluk, Dharwad to the petitioner. Thereafter, when the petitioner sought to get his name entered into in the revenue records, his sister, respond number 4, objected to the same and has also filed a suit in OS number 82 of 2023 for declaration and permanent injunction, wherein a temporary injunction has been granted, restraining the petitioner from alienating the suit secured property. The petitioner having filed an application for mutation of his name in the revenue records, the Tahsildar, noting the pendency of the suit, directed the entry of the name of the petitioner, which came to be challenged by the petitioner before the second respondent assistant commissioner who
Refund number 4 challenge.
respond number 4 preferred an appeal before respond number 2, assistant commissioner, who dismissed the appeal, challenging the said orders of the Tahsildar and the assistant commissioner. Respond number 4 filed an appeal in RP number 29 of 2024. The first respondent deputy commissioner taking note of the suit in OS number 82 of 2023 being pending had directed both the parties to obtain necessary orders in the said suit and thereafter approach the authorities for necessary mutation. It is challenging the same, the petitioner is before this court. Admittedly, the relationship between the petitioner and respondent number 4 is admitted. Petitioner being the sister and petitioner being the brother and respondent number 4 being the sister. Further, admittedly, the owner of the property was their mother. The petitioner claiming that there is a will executed in his favor. Respondent number 4 claiming succession rights.
No, my lord. Under the will, she also is claiming.
My lords, there was a will in my favor.
2016. Also claiming that there is another will executed in her favor. There being a dispute between the both, there being a dispute that respondent number 4 also claiming that there is another will executed in her favor. There being dispute between both of them, which are now subject matter of OS number 82 of 2023, the rights of the parties would have to be determined in the said suit. The property continues to stand in the name of the mother.
Please.
And the entries of the name of either the petitioner or respondent number 4 have not been made in the revenue records. In that view of the matter, I do not find any infirmity in the orders passed by the Deputy Commissioner, inasmuch as the interest of both the parties are preserved and taken care of by the Deputy Commissioner so as not to permit undue alienation and or multiplicity of proceedings. As rightly observed by the Deputy Commissioner, the parties would be governed by the result of the suit in OS number 82 of 2023. There being no infirmity in the said order, petition stands dismissed.
38, KL Patil.
Challenging the order passed by the
Suit for
partition, my lords.
Nevo.
I am the defendant, my lords.
Yes.
Wherein the defendant number one, the husband of defendant number one, and has set up that, my lords, there was a partition between the family members. Accordingly, he produced a certified copy of the partition memo, my lords, before the trial court. The trial that was, while marking that, my lords, the trial court was, the other side was objected, and trial court was not rejected to mark the said document, my lord, since it is not registered under section 49 of the Registration Act, my lords, which is forthcoming in pay.
Notice to the respondents, returnable by 16 April. The further proceedings in OS number 289 of 2017 pending on the file of the 4th additional senior civil judge and JMFC Dharwad is stayed till the next date of
Yes.
hearing. Process fee and copies by 24th. Acknowledgement by 3rd March, failing which interim order will stand automatically.
As notice to respond number 6 to 16 may be dispensed.
Memo.
I will file the memo.
Counsel for the petition. Notice to respond number 1 to 5, Madi.
1 to 5.
Notice to respond number 6 to 16
16, my lords.
is dispensed with at the request made by the counsel for the petitioner by filing a memo on the ground that they are co-defendants.
Co-defendants.
39, the big party.
No confidence motion, your Lordship. Panchayat. Only one, your Lordship.
ಯಾವಾಗ season end ಆಗದು?
ಎಷ್ಟು sorry.
February ಅಲ್ಲಿ end
ಎಷ್ಟು
ಆಗಿದೆ.
ಹದಿನೈದು
ಇದೆ last.
Page 16 may kindly be seen. PDO has certified, your Lordship. That is the only ground.
It is the, your
What
Lordship.
date ಇದು?
10-2.
10 ಹೆಂಗಪ್ಪ ಇದು? ಮೊನ್ನೆಲ್ಲ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟು
Directions ಕೊಟ್ಟು throughout Karnataka ಅಂತ register.
Again, your Lordship, it is endorsed by the PDO now.
ಆರ್ಡರ್ ಆಗಿ ಕಮ್ಯುನಿಕೇಟ್ ಆದ್ಮೇಲೂ ಹಿಂಗ್ ಮಾಡಿದ್ರೆ ಹೆಂಗೆ? ಯಾರಿದ್ದಾರೆ ರೆಸ್ಪಾಂಡೆಂಟ್?
1 to 2, 1 and 2, your Lordship, government. 3 to, your Lordship, that
ಕೇವಿಟ್ ಏನೋ ಹಾಕಿದ್ದಾರೆ.
keep ಹಳೆ old earlier.
ಅವ್ರಿಗೆ ಕೊಡೋಣ ಯಾರು? ಇನ್ನು ಇದು 6 ತಿಂಗಳು ಬೇಡ.
ಇರ್ಲಿಲ್ಲ ಆಯ್ತು. ಕೇವಿಟ್ ಯಾರು ಹಾಕಿರ್ಬೋದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಯಾರು ಹಾಕ್ಯಾರ? ಹೆಸರು 100751.
CP 20342 ಹಾಕಿ ಹೇಳಿ ಯಾವುದು? AG accepts notice for respond number 1. Agri Bomanalli.
Agri Bomanalli, but Shivraj Hiremat.
Shivraj Hiremat.
Duraj Hiremat for respond number 2. This so and so is directed to accept notice for respond number 3 to 14. Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that the requisition notice submitted under Form 1 of Sub-Rule 1 of Rule 3 of the Rules of 1994 has been endorsed by the Panchayat Development Officer and as such is contrary to the decision of a coordinate bench of this court in Sanganna Biradar versus so-and-so. This court in Sanganna Biradar had categorically come to a conclusion that there cannot be any writing, seal, signature or the like of the PDO in a notice under notice under Form 1 of Sub-Rule 1 of Rule 3. The said order having been passed on
11-2.
ಕೆಲಸ ಮಾಡಿ
ಕೃಷ್ಣ ಕುಮಾರ್ ಸಾಹೇಬ್
ಈಗ ಪ್ಯಾರಾ 5 ಅಲ್ಲಿ ಜಗದೀಶ್ ಪಾಟೀಲ್ ಮಾಡಿ ಜಗದೀಶ್ ಪಾಟೀಲ್ ಅನಂತ್ ಕೊಳ್ಳಿನ ಜಗದೀಶ್ ಪಾಟೀಲ್ ರಿಪ್ಲೇಸ್ ಮಾಡಿ ಎಂ ಕನ್ನೂರ್ AGA ಇದೇನೆ ಶಿವರಾಜರೇ ಮಾಡ್ತಾರೆ.
ಕೃಷ್ಣ ಕುಮಾರ್ ಸಾಹೇಬ್
ಇದು ಚೆಕ್ ಮಾಡ್ಕೊಳ್ಳಿ. The Assistant Commissioner the first respondent Assistant Commissioner is directed to initiate suitable disciplinary proceedings against the respondent number 2 on account of respondent number 2 having acted contrary to the decision of this court in Sangana Gowda and Biradhar's case. ಅದು ಪ್ಯಾರಾ 3 and 4 ಹೊಡೆದ್ಬಿಟ್ಟು ಅದು
40 SS Mittal Court. Hello.
ಅಲ್ಲ ಕಾಪಿ ನಡೀತಿ. ಎಸ್
ಯಾರು ಕೇವೇಟ್ ಯಾರ್ದು ಹೇಳಿ
ಅವ್ರು ಯಾರು ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ ನಾವು
ವರ್ಡ್ ಕೇಳ್ಬೇಕು.
ಎಸ್ ನೋಡ್ಸಿ ಗೆಟ್
Yes, my lord. This petitioner's mother filed a suit for partition of her share in her father's share, my lord, in her property against defendant and others.
Appearing for
For caveator, respond
Yes.
number 1.2, my lord, I will undertake to file wakalat. Today I will file wakalat for 1.1, your lordship.
They are only
And today I am
contesting, my lord.
filing objection, statement of objections along with connection.
Yes, 2 to 4 may be dispensed, my lord, because there we are no claim.
Sunanda Patil, who has filed caveat for respondent number 1.2, accepts notice for respondent number 1.1.
1.1, yes, my lord.
Registry is directed to print her name as such.
Yes,
She has filed a statement of objection which is
Yes,
taken
ma'am.
on record. Counsel for the petitioner submit the notice to respondent number 2.1 to 2.4
4.
be dispensed with since they are co-defendants. The memo filed.
Yes, my
by
lord,
the
memo is
counsel
filed,
for
my
the
lord.
petitioner is accepted.
Yes, my lord.
Notice to respondent number 2.1 to 2.4 is dispensed with.
Yes, my lord.
Hmm.
My lord.
Ready?
A very short question you want, my lord, in this case.
ನೋಡಿದ್ದೀರಾ?
Yes, my lord. 25,
Suit for?
suit for partition, my lord.
Hmm.
My mother's suit was decreed, my lord. When my mother was alive, I was made a defendant too unnecessary, my lord, against her brothers. So suit was decreed, my lord. When that matter was taken appeal by the other branch, my lord. In the appeal also confirmed, my lord. When my mother appeal was pending, my mother died. There already myself and my brother Tukaram were there. My mother sister Irbasava came on record, my lord. So then FDP was filed for claiming my mother's half share, my lord. My mother's half share. So in what happened, my lord? So FDP was passed, an order was passed drawing the final decree. In execution petition, my mother's share was allotted and given possession to only the 1.1, 1.2. So now they say that no, you are not entitled for any share, though I am son, because you have taken the contention in the suit. So mother has no right in other property, so you are not entitled. This matter neither decided nor heard anywhere. Nowhere in the suit it is said that I am not entitled. Based on this, the executing court had denied, say that you have no right. This is only question, Maharaj. Can executing court deny my share in my mother's share, which is my mother got in her on father property?
Relationship is not in dispute.
Not in dispute, my lord.
All the legal heirs of your mother are on record?
Yes, are on record. Half share, no dispute. Only my lord, what happened, my lord, in the suit, my lord, a defendant, one other branch brother has filed WS and adopted by the other defendants, unmindful of that this man's share is there. That's the only thing. Simply ನಾನು ನಿಮ್ಮ ಮಗು ಹಕ್ಕಿಲ್ಲ ಅಂತ ಕಾರಣ ಡಿನೈ ಮಾಡಕ್ ಬರೋದು.
You are playing both sides. ಅವಾಗ ಅಲ್ಲಿ ಬಂದಿದ್ರೆ ಅಲ್ಲಿ ಬಂದಿರಬಹುದಾಗಿತ್ತು.
ಇಲ್ಲ ಮನ.
ಇಲ್ಲ ಆದ್ರೆ ಇಲ್ಲಿ
ಇಲ್ಲ ಮನ.
ಬಂದ್ರೇನು ನಂಗೆ ಬರುತ್ತೆ ಅಂತ ನೀವು.
ಇಲ್ಲ ಮನ ಹಾಗಲ್ಲ. ಈಗ ಅವ್ರಿಗಿಲ್ಲ ಅಂದಂತ ಅದು ಡಿಸೈಡ್ ಆಗಿಲ್ಲ ಆ ಇಶ್ಯೂ ಏನು. ಎಲ್ಲಿ ಡಿಸೈಡ್ ಆಗಿಲ್ಲ. ನೀನು ಡಿನೈ ಮಾಡಿದೆ ಅದಕ್ಕೆ ನಿನಗೆ ಹಕ್ಕಿಲ್ಲ ಡಿಸೈಡ್ ಆಗಿಲ್ಲ.
ನೀವು ನೋ ರಿಸ್ಕ್ ಬೇಸಿಸ್ ನಿಮ್ದು. ಅಲ್ಲಿ ಅಗೇನ್ಸ್ಟ್ ಮಾಡಿದ್ರೆ ಆ ಕಡೆ ಹೋದ್ರೆ ಅಲ್ಲಿಂದ ಬರ್ಬೋದು ಅಂತ. ಇಲ್ಲಿ
ಇಲ್ಲ ಮಲ್ಲ, my mother's I can get only in my brother's share only. When if I oppose it, I support it. Others our branch in us claim ಇಲ್ಲ, ನಮಗೂ ಡಿಸ್ಪ್ಯೂಟ್ ಇಲ್ಲ. ಸೊ ಓನ್ಲಿ ಏನಂದ್ರೆ ಅದು ಏನೋ ಒಂದು ಬೈ ಮಿಸ್ಟೇಕ್ ಅವ್ರ ಅಡಾಪ್ಷನ್ ಮೆಮೋ ಹಾಕಿದ್ರು, ಮತ್ತೆ ಆ ಇಶ್ಯೂ ಏನು ಡಿಸೈಡ್ ಆಗಿಲ್ಲ. ಇವರು ಸಿನ್ಸ್ ಶೇರ್ ಡಿನೈಡ್ ಹರ್ ಮದರ್ ಶೇರ್ ಇನ್ ಅವರ್ ಫಾದರ್ ಶೇರ್ ದೇರ್ ಫಾರ್ ನೋ ಇಶ್ಯೂ ಅಂತ ಏನೂ ಆಗಿಲ್ಲ. ಆಮೇಲೆ ನಾನು ಅಪ್ಲಿಕೇಶನ್ ಹೇಳಿದೆ, ಪ್ಲೀಸ್ ಕ್ಲಾರಿಫೈ ದಟ್ ಮೈ ಮದರ್ ಶೇರ್ ಎನ್ಶ್ಯೂರ್ಸ್ ಬೆನಿಫಿಟ್ ಆಫ್ ಮೀ ಮೈಸೆಲ್ಫ್ ಅಂಡ್ ಅದರ್.
1.1 is your sister.
Yes, sir.
1.2 is your brother.
Brother, yes. ಅಷ್ಟೇ ನಾನು ಅದರಲ್ಲಿ ಅದು ಒಂದು ಏನೋ ಆ ಅಡಾಪ್ಷನ್ ಮೆಮೋದಲ್ಲಿ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ, ಅದರಿಂದ ರೈಟ್ ಕೆನಾಟ್ ಬಿ ಡಿನೈಡ್.
Rightly it should be rejected. You are playing both sides.
No, by mistake the adoption memo is filed. The advocate for adoption memo ಹಾಕಿದನ್ನ separate WS ಹಾಕಿಲ್ಲ, adoption memo ಹಾಕಿದನ್ನ that mistake has occurred.
Sign ಮಾಡಿದ್ರೆ advocate sign ಮಾಡಿದ್ರು.
ಅಲ್ಲ ಪಾರ್ಟಿ ಸೈನ್ ಮಾಡಿದ್ರು, ಬಿಕಾಸ್
Party
ಸೈನ್ ತಗೊಂಡು ಹಾಕಿದ್ದಾರೆ. ಅಲ್ಲ ಅಂದ್ರೆ ದಟ್ ಇಸ್ ನಾಟ್ ಡಿಸೈಡೆಡ್ ಅಂದಲ್ಲ, ಅದು ರಿಜೆಕ್ಟ್ ಆಗಿಲ್ಲ.
Your Lordship, page number 20 of the writ petition, Your Lordship, that is the order passed by the trial court, Your Lordship. Para number 12.
Yes.
At this stage, again, JDR number 4 come up with these Is, number 6 and 7, rejecting the bailiff report and for passing an order of delivery of possession of the suit property in his favor along with decree holders, and stated that he is also entitled for the relief in the execution petition, and he is also legal heir of original plaintiff by name Kallava Subrai Kochari, and he is having 1/3 share in the suit property. However, these contentions of JDR number 4 cannot be acceptable because the judgment and decree and other record pertaining to OS number 82/2000 array 319/2010 and FDP 11/2013 produced on record clearly discloses that the deceased decree holder Kallava Subrai Kochari has filed OS number 82/2000 for the relief of partition and separate possession of the joint family properties against Kadapa and others, and in the said suit present JDR number 4 was defendant number 2. Further, in the said suit present JDR number 4 has appeared and contested the suit by adopting the written statement of defendant number 1 and by denying the share of Kallava in the suit properties. In OS number 82/2000 present JDR number 4 and defendant number 1 in the written statement denied the very relationship of DHR Kallava and her right in the suit properties. Both, but the contrary.
Relationship of
Kallava. And JDR number.
My mother's, when my mother was alive, my lord, my was made only a formal party, my lord.
You are denied a relationship only.
No, not in a relationship. Mother had no share in the other branch ಹಾಕೊಂಡಿರೋದು ಅಡಾಪ್ಟ್ ಆಗಿರೋ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ ನಮಗೆ. The other branch had denied that my mother had no share. That means Basava's branch had denied my mother had wrote. That adoption memo is complicated, my lord. ಆಮೇಲೆ ಅದರಲ್ಲಿ ಸೂಟ್ ನಲ್ಲಿ
separate suit, Mr. Mittal.
ಅಲ್ಲ ಮಲ್ಲ, ಇಫ್ ದಿಸ್ ಆರ್ಡರ್ ಅಲ್ಲ ದಿಸ್ ಆರ್ಡರ್ ವಿಲ್ ಕಮ್ ಇನ್ ಬಿಕಾಸ್ ಇಲ್ಲಿ ಅಲ್ಲ ಸೂಟ್ ನಲ್ಲಿ ನೋ ಡಿಸಿಷನ್ ಆಗಿದೆ, ಅದ್ರ ಬಗ್ಗೆ ಡಿಸಿಷನ್ ಆಗಿಲ್ಲ. ಇನ್ ಸೂಟ್ ಇಸ್ ನಾಟ್ ಡಿಸೈಡೆಡ್, ಪ್ಲೇಂಟಿಫ್ ಸಾಫ್ ಶೇರ್ ಅಂತ ಅಷ್ಟೇ ಡಿಕ್ರಿ ಆಗಿದೆ. ಆಮೇಲೆ ಇವನ್ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಕೋರ್ಟ್ ನಲ್ಲಿ ಮಲ್ಲ FDP ನಲ್ಲಿ ಕೂಡ ಪ್ಲೇಂಟಿಫ್ ಸಾಫ್ ಶೇರ್ ಅಂತ ಆಗಿದೆ.
We know that whatever is held here will not come in the way of deciding your suit for partition.
ಅಲ್ಲ ಮತ್ತೊಂದು 25 ವರ್ಷ ಆದ್ಮೇಲೆ ಈಗ ಆಲ್ರೆಡಿ 25 ಲಿಟಿಗೇಷನ್ ಆಗಿದೆ.
Sitting on the fence ಕೂತ್ಕೊಂಡು ಎಲ್ಲ ಕಡೆ ಬೆನಿಫಿಟ್ ತಗೊಂಡು
one small mistake should not lead to
small mistake. You denied your relationship with the mother.
ಅಲ್ಲ that is not an issue decided, mala. Not all decided and reject ಮಾಡಿಲ್ಲ ನಂದು ಎಲ್ಲಿನೂ. Neither in the appeal, even in the appeal ನಲ್ಲಿ ರಿಜೆಕ್ಟ್ ಮಾಡಿಲ್ಲ ನನ್ನ ಶೇರ್.
I should be hold in favor of a son.
That advocates
his mother.
Mother relations, mother our father ಇಲ್ಲ, other branch ಅವರು ಮಾಡಿರೋ ತಪ್ಪಿಗೆ I am suffering.
Denied her share in the property.
That is the
she is related.
No relationship ಅಲ್ಲ that mother another branch has denied that my mother had no share ಅಂತ ಅವ್ರು ಮಾಡಿದ್ರು adopted. Yes, that is the mistake for adoption. I do consent. But mala, but whether
that's a stand that you took on legal advice.
That is not considered, decided in the suit, my lord. Adar ಮೇಲೆ deny ಮಾಡಿಲ್ಲ.
ಅದಕ್ಕೆ you file a separate suit.
ಅಲ್ಲ,
And as per
ಮತ್ತೆ again,
Remember right.
Annexure R8, my lord, this honorable court has already held that the final decree proceedings are already attained
Yes,
to
yes.
finality, your lordship.
ಅಲ್ಲ ಅದರಲ್ಲಿ ಆಗಿಲ್ಲ, ಅದರಲ್ಲಿ ಫೈನಲ್ ಡಿಕ್ರಿನಲ್ಲೂ ನನ್ನ ಶೇರ್ ಡಿನೈ ಆಗಿಲ್ಲ. ಮೈ ಮದರ್ ಶೇರ್ ಗ್ರಾಂಟೆಡ್. ಓನ್ಲಿ ಥಿಂಗ್ ಇಸ್ ಐ ವಾಸ್ ಆಲ್ರೆಡಿ ಆಲ್ ಅಲಾಂಗ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಪಾರ್ಟಿ ಇದ್ದೆ. ನಂದು ಡಿನೈ ಮಾಡ ಮದರ್ ಶೇರ್ ಇಸ್ ಗಿವನ್ ಅಂತ ಅಷ್ಟೇ ಮಾಡಿದರೆ ಡಿನೈಯಿಂಗ್ ದಿ ಶೇರ್ ಆಫ್ ದಿಸ್ ಪಿಟಿಷನರ್ ಅಂತ ಎಲ್ಲಿ ಆರ್ಡರ್ ಮಾಡಿಲ್ಲ.
You file a separate suit. This bailiff warrant will be executed, they will get.
ಎಕ್ಸಿಕ್ಯೂಟ್ ಆಗಿದೆ, ಅವ್ರ ಪೊಸಿಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಅದ್ರ ಬಗ್ಗೆ ಇಲ್ಲ.
Now you file a separate.
ಮಲ್ಲ ದಿಸ್ ಆರ್ಡರ್ ಶುಡ್ ನಾಟ್ ಕಮ್ ಇನ್ ದಿ ವೇ.
Let him file it.
ಮಲ್ಲ
Maybe, but this petition
This
itself
order-
is not maintainable because the EP itself is closed.
well, that I am seeking clarification, that's why I filed this, not again. So permission may given, but this order should not come in the way of my right, my lord.
Told. Petitioner is before this court seeking for the following relief. One, Srimati Kallava had preferred a suit in OS number 15, OS number 82 of 2000 before the senior civil judge at Ukeri for partition and separate possession of the plaintiff's half share in the said property. Defendant number 1 therein had filed a written statement denying the plaintiff amendments. The petitioner herein, who was defendant number 2 therein, had adopted the said written statement. The trial court had decreed the suit. FDP proceeding in FDP number 11 of 2023.
13, your lordship.
11
FDP 11 by 2013.
13.
13.
13, my.
11 of 2013.
Yes.
A final decree was also drawn up
8/7/2015.
on
8/7/2015. 8/7/2015.
7/2015.
Yes.
Subsequently, EP number 141 of 2015 had been filed. What is D? It is at the final stages when the execution proceedings was nearing closure. A bailiff had been appointed to hand over possession to respond number 1.1 and 1.2, that the petitioner filed an application on 28/3/2022 seeking for delivery of possession to the petitioner along with respond number 1.1 and respond number 1.2. The said application having been objected to. Another application had been filed under section 151 of the Code of Civil Procedure for rejection of the bailiff report and issuance of fresh warrant to hand over possession to the petitioner and respond number 1.1 and 1.2. Both the application have been objected to. The trial court, the execution court, while it's ordered at 5th November 2014, dismissed those applications. It is challenging the same, the petitioners are before this court. The submission of Shri S.H. Middle Court Learned Counsel for the petitioner is that the petitioner has committed a mistake when adopting the written statement filed by defendant number 1. The petitioner being defendant number 2 in the said suit in OS number
82/2000.
82 of 2000.
And in fact, his presence was not required, my lord. Mother was alive.
Yes. You know why you were there. Plaint ನೋಡಿದ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ. His submission is that relationship between himself and Kalava not being in dispute. The decree holders, respond number 1.1 and 1.2, being his brother and sister and brother respectively. The petitioner is also entitled to equal share with them in their mother Kalava's property. And as such, the applications filed ought to have been rightly considered, favorably considered, and orders passed. A perusal of the impugned order, more particularly at para 12, thereof would indicate that the petitioner, who was defendant number 2 in OS number 82 of 2000, has adopted the written statement filed by defendant number 1, wherein the right of Kallava in regard to the properties have been disputed and denied, so also the relationship with the family being denied. This aspect of the relationship being denied would have to be separately considered when the petitioner has adopted the said written statement. When the relationship is denied, the petitioner cannot now claim that being a legal heir of Kallava is entitled to equal share with respond number 1.1 and 1.2. The petitioner chose to remain quiet till the year 2022, even though the EP was filed in the year 2015. And it's only when the delivery of possession was required to be made to respond number 1.1 and 1.2 that such an application came to be filed by the petitioner seeking for delivery of a portion of the property in his favor, claiming 1/3 right. The relationship having been disputed, it would be for the petitioner to establish the relationship now to claim a right under Kallava by separate proceedings, since the rights of the petitioner has not been determined in any of the proceedings till date. That being so, I am of the considered opinion that the applications filed by the petitioner in IA 6 and 7, as indicated above, have been rightly rejected by the execution court. It is for the petitioner to file separate proceedings to establish his rights, if any. However, it would have to be observed that the observation made in the present order and that in the order dated EP number dated 5/11/2024 in EP number 141 of 2015 would not come in the way of the determination of the right of the petitioner in a suit if and so filed by the petitioner.
Yes. Yeah.
Partition, Anandarkolli.
ಯಾವ್ದು interesting point.
Yes.
Very ಬಂದ್ ನೋಡೋಣ.
Lordship's kind serial number 74, my lords. Lords, that is a writ petition I am for respondent that can be allowed on consent. May I seek at 2:30 with some cost. They have sought for recalling of PW1 for cross examination. Third application anta reject agide. Lordships may kindly impose cost and timelines.
Serial number 105, my lords. I appear for the petitioner, my lords. They have filed an affidavit, my lord. I'll make submission on Tuesday or Wednesday, my lords. My lords.
In that petition, I appear for respondent.
And make it on Wednesday.
Please, your lordship. Interim order may kindly.
In that, my lords,
ನೋಡಿದ್ದೀರಾ?
Oh, sorry, my lord. 27th, your lordship.
may I, my lords, seek, in that matter, my lords, I appear for respondent. It is, my lords, a very small question. Report, my lords, has filed. Now, in the fresh, I'm not objecting for adjournment. In the fresh list, my lords, that means, my lords, dispose of the matter.
105 relist on 27th in the preliminary hearing category.
Please.
Entry order granted, my lords.
Interim order.
Please.
Seal number 46, your lordship.
Ah.
Tuesday, your lordship. In the afternoon, I have to attend the hospital, your lordship.
Huh?
In the afternoon, hospital ಹೋಗ್ಬೇಕಾಗಿದೆ ಸರ್ ಅದಕ್ಕೆ.
Yakri?
ಮೊನ್ನೆ ಕಾಲಿ ಮಲ್ಕಲ್
At the request of counsel for the petitioner, relist on 25th.
66 also. 66 also, your lordship.
66 also, same data.
Same date, your lordship.
Yeah, 66 better. 66, a memo filed by the counsel for the petitioner to treat respond number 5 and 6 as the legal representative of deceased respond number 7 is accepted. Respond number 5 and 6 are treated as the legal representative of deceased respond number 7. Counsel for the petitioner to carry out necessary endorsement in the cost title. Relist on 25th. 25th March.
Please, your lordship.
My lord, serial number.
One ನಿಮಿಷ ಹಿಂಗ್ ಬರ.
Serial number 28 months.
ಹಾ.
We will pay the return within 15 days.
ಹಲೋ ಮಾಡೋಣ ಮಧ್ಯಾಹ್ನ. ನೀವು ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಹಿಂಗಲ್ಲ, ಹಿಂಗೆ ಬರೋದು.
Serial number 48. Serial number 48.
ಹಾ.
Behalf of Sadiq Gudwal.
Yes.
Kindly have it on Monday, my lords.
23 matter, no urgency. 48, at the request of counsel for the petitioner, relist on 28th March. ನೀವು ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೆಂಟ್ ಆ ಕಡೆ PN ಅಟ್ಟಿ ಅವ್ರದ್ದು ಇದು, ಇವಾಗ ಇಲ್ಲಿ ಬರಬೇಡಿ, ಇಲ್ಲೇ ಇಲ್ಲಿ ಬರ್ತೀವಿ.
Interest can be waived off, my lord. They are claiming the interest.
ಆಯ್ತು.
My lord, serial number 101, my lords.
ಹಾ.
There are two coordinate bench decisions as well, my lords. It's a similar matter, my lords. The government has acquired the property. They are neither allowing any development to be taken place, nor they are revoking the
ಏನಮ್ಮ
understanding.
you have mentioned?
At 2:30, my lords, may kindly.
30 if it reaches.
Serial
Please,
number
ma'am.
55, there is a possibility of settlement between the parties.
55.
Only on 10 days time.
Counsel for the petitioner submits that, counsel for both the parties submit that.
Yes.
There's a possibility of, the parties are exploring the possibility of settlement, given 3 weeks' time. They will endeavor to report the settlement. Relist on
Serious.
21st March.
Interim order may carry.
Interim order earlier granted is extended till next date.
Some urgency, my lord's memo. Yesterday it was listed. So I engaged in the code number 5. It is listed on 24th. It is urgency.
ಬೆಳಿಗ್ಗೆ ಕರೆದು ಪಾಸ್ ಓವರ್ ಆಗಿ
ಇಲ್ಲ ಬೆಳಿಗ್ಗೆ ಪಾಸ್ ಓವರ್ ಆಗಿಲ್ಲ. ಸೆಕೆಂಡ್ ಹಾಫ್ ಅಲ್ಲಿ ಕರೆದಿದ್ರು. ಐ ಆಮ್ ಎಂಗೇಜ್ ಇನ್ ಸೋಮವಾರ that is 24.
Seal number 45, your lordship. I am filing objection. I have received papers yesterday.
45.
My lord, in the meantime, my lord, the.
I am having serious objections, your lordship, to that case.
Wait. We'll see. They're not adjourning.
Serial number 69, I undertake to appear for respondent.
I am for petitioner, my lords.
Ah.
I've served a copy, my lords.
That counsel for Shivraj V. Iramat submits that he would be appearing for the respondent. He seeks for.
Next week.
It's a case of mandamus, my lords, directing them. my lords.
Presentation was not on the rate petition.
ಪಾಸ್ ಓವರ್ ಇನ್ನೊಂದು ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಕೂಡ ಕೇಳೋಣ ಅಷ್ಟೇ, ಅದಕ್ಕೋಸ್ಕರ ಸುಮ್ಮನೆ. ಹಾ 77 ಓಕೆ 77 ವಿಲ್ ಸಿ ದಟ್ ವೆನ್ ಯು ಅನ್ಕವರ್ ಇಟ್. ಎಸ್ ಏನ್ ಲಿಬರ್ಟಿ ಏನಕ್ಕೆ? ಹಾ 63 petitioner is before this court seeking for the following reliefs. A memo dated so and so has been filed, signed by the counsel for the petitioner, which reads as under. By the representative of the petitioner and the counsel for the petitioner has been filed, which reads as under. Accepting the said memo, the petition is dismissed as withdrawn, reserving liberty to the petitioner to again approach this court in the event of any dispute raised by the union as regards the settlement.
So, serial number 78, my lords. My name is reflected in the petitioners for counsel, counsel for petitioners. I have not found any wakalat.
Serial number 78 wrongly.
77 is C.S. Shettar.
78.
78, I am.
Only my name has been mentioned.
His name has been shown. My name, my lord, Vijay Kumar B. Horatti.
ಇದೆ ಅದೂನು ಇದೆ.
I have not filed wakalat, my lords.
His name is wrongly has been shown, my lord. His name has to be deleted. Subhendu.
ಆಯ್ತು, ಮಾಡಿ ಅರ್ಜೆಂಟ್ ಮಾಡೋಣ ಇವಾಗ.
ಇಲ್ಲ, it is urgent.
ಇರ್ರಿ. ಒಳ್ಳೆ ಕತೆ ಮೆನ್ಷನ್ ಮಾಡಿದ್ರೆ ಅರ್ಜೆಂಟ್ ಆಗತ್ತೆ.
ಶ್ರೀರಾಮ್ 110 ತಗೊಂಡಿಲ್ಲಲ್ಲ, ಯಾರು ತಗೊಂಡಿಲ್ಲಲ್ಲ?
ಇಲ್ಲ 49 ತಗೊಂಡಿದ್ದಾರೆ. ಕಾಲರ್ ಟು ಮಾಡೋದಿಲ್ಲ, ಕೊಡುದಿಲ್ಲ.
ನಿನ್ನೆ 2:30ಗೆ ತಗೊಂಡಿರ್ತಾರ
ಅಲ್ಲ, ಅವ್ರು ನಿನ್ನೆ ಬೆಳಿಗ್ಗೆ ತಗೊಂಡ್ರು ಸರ್.
ಇಲ್ಲ 10:30 ಆಯ್ತು, ನೀವು ಕರ್ದೇ ಇಲ್ಲ.
ಅಂದ್ರೆ ಇದು ಸ್ಪೆಸಿಫಿಕ್ 2:30 ಹಾಕೊಂಡಿದ್ ನಾ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ಸ್ ಕರೆಲ್ಲ ಕೊಡುದಿಲ್ಲ.
ನಿನ್ನೆ ನಾವು
ಬರ್ತಾರೆ ಸಾಹೇಬ್ರು. ನಿನ್ನೆ ಹಂಗೆ ಮತ್ತೆ ರಿಪೀಟ್ ಮಾಡಿಸಿದೆ, ಈಗ ಸಿಗ್ನೇಚರ್ ಮಾಡಿಸಿದೆ.
ಯಾರು ತಗೊಂಡಿಲ್ಲ ಅಲ್ರಿ ಈಗ ಕಂಟಿನ್ಯೂ ತಗೊಂತೀರಿ ಬೇರೆ ಮ್ಯಾಟರ್ಸ್ ಕಂಟಿನ್ಯೂ ಅದಾಗಿ ಹಿಯರಿಂಗ್ ಅವನ
ಆಮೇಲೆ 2:30 ಮುಗಿಸಿ
2:30 ಎಲ್ಲ ಅಂತಂದ್ರೆ
ಅಂದ್ರೆ ವಾಯ ಅಣ್ಣ ವಾಯ ಅಲ್ಲೇ ಹೋಗಿತ್ತು.
ನಾವೆಲ್ಲ ರೌಂಡ್ ಹಾಕೈತೆ ನೋಡ್ರಿ.
ಅದ್ರೊಳಗೆ ಎರಡು ರೌಂಡ್ ಹಾಕಿದ್ದು ಕೊಟ್ಟಿರ್ತೀವಿ ಅವು ಸಮ್ ಹ್ಯಾಂಡ್ ಸಮ್ಮನ್ ಸಿಗ್ತವೆ ಪ್ರಾಡಕ್ಟ್ ಎರಡು ಹೇಳಿದ್ನಲ್ಲ ನಾಲ್ಕು ಹ್ಯಾಂಡ್ ಸಮ್ಮನ್ ಇನ್ನು 10 ಗಂಟೆ ನಾನು ಹೋಗಿದ್ದೆ ಸಾಹೇಬ್ರು ಕರ್ಕೊಂಡು ಸಾಹೇಬರು ಶಾಂಪು ಸಾಹೇಬರು ನೀನೆಲ್ಲ ಕಷ್ಟ ಬರ್ತಾರ ಅದಕ್ಕೆ ಏನು ಬರ್ದಿಲ್ಲ ಅಷ್ಟು ರಿಸೀವ್ ಮಾಡಿದ್ರು ಅವರು ಬರೆದು ಕೊಟ್ಟಿದ್ರು ಕೊಟ್ಟಿಲ್ಲ ಕೊಟ್ಟಲ್ಲ ಇದ್ರೊಳಗೆ ಏನು ಬರ್ತದೆ ಅಷ್ಟು ಸೈನ್ ಮಾಡಬೇಡ ಆಮೇಲೆ ಡೀಪ್ ಅಲ್ಲಿ ಕಷ್ಟ ಆಯಿತು ಡೀಪಲ್ಲಿ ಸೈನ್ ಮಾಡಿ ತಂದು ಕೊಡ್ತೀವಿ ಆಮೇಲೆ ಪೀಸ್ ವಿಶಾಲ
ಆಯ್ತು ಸಿಗ್ತಾ ಇಲ್ಲ ಎಲ್ಲಿ ಕೇಳಿದೆ ನಾನು ಹೇಳಿದ್ಲು ಮಕ್ಕಳು ಪೆಂಡಿಂಗ್ ಕೇಳಿದೆ ಮತ್ತೆ ನಮ್ಗೆ ಹೇಳೋರು ಹೇಳ್ಬೇಕಾಗಿಲ್ಲ ನಾವು ಅಲ್ಲಲ್ಲ ಇಲ್ಲಿ ನಮ್ಮ ಕಲಿಕೆ ಟೆನ್ಷನ್ ಇಟ್ಟೊತ್ತನ ಹುಡುಕಾಡ್ತಾನೆ ಅದಕ್ಕೆ ಹಂಗ್ ಮಾಡಿದ್ರೆ ಒಂದು ಈಗ ಇನ್ನೊಂದು ಅಪಿಯರೆನ್ಸ್ ಕರೆಕ್ಷನ್ ಇತ್ತಲ್ಲ ಕರೆಕ್ಷನ್ ಮಾಡಿಸಿದೆ ಮಾಡಿಸಿ ಕೊಟ್ಟು ಅಪಿಯರೆನ್ಸ್ ಮತ್ತೆ ಚೇಂಜ್ ಆಗ್ಬೇಕಲ್ಲ ನಿಂದ ಅದನ್ನ ಇಟ್ಟು ಹಂಗೆ ಬರ್ತದೆ ಮಾಡೀನಿ ಅದ್ರೊಳಗ ಟೀಚರ್
They moved applications against the two offices. One is Adhyaksha and another is Upadhyaksha.
Ibburugu.
Yes, ma'am. That is the main point, my lords.
3-2. Yes.
Yes. Firstly, my lords, the members, they don't have right, my lords, or the locus standi to move no confidence motions, my lords, against the two offices at the same time. Or.
As
That,
the case may be.
yes. My lords, if or is to be taken into the literal interpretations, my lords, that's where it is clearly specifies that, my lords, motion of no confidence against Adhyaksha or Upadhyaksha. Or is always, my lords, a disjunctive. If in place of and, it is a conjunctive.
The legislature probably thought ಇಬ್ಬರಿಗೂ ಒಟ್ಟಿಗೆ ಮಾಡಲ್ಲ.
No.
ಒಬ್ಬರಿಗೆ ಏನಾದ್ರು ಮಾಡಬಹುದು, ಅದಕ್ಕೆ ಆರ್ ಯೂಸ್ ಮಾಡಿದ್ರು.
No. That legislature, my lords, think over of all the issues.
And you, if let us test your argument.
Yes.
If you are arguing, if the word and has to be used instead of or.
Yes.
Then
motion of no confidence against Adhyaksha or Upadhyaksha of a Gram Panchayat. Every Adhyaksha or the Upadhyaksha of a Gram Panchayat shall forthwith deemed to be vacated of his office if the resolution expressing want of confidence in him passed by the majority not less than 2/3 of the total number of the Panchayat at the meeting, especially conveyed for the purpose in accordance with the procedure as may be. My lords, if we look into, my lords, where why, my lords, the intention of or and and here clause 5 may kindly be seen, my lords. Rules.
Rule 5.
Rule 5.
Rule 5 or sub rule 5?
Sub rule 5, excellent. Where, my lords, save as otherwise the act, all the meetings conveyed for the purpose of consideration of the motion shall be not of any reason to be adjourned. If there is no quorum within 1 hour, 1 hour after the time appointed for the meeting shall stand dissolved and the notice under sub rule 1 so. The time stipulations, my lords, under sub rule 6 is only 1 hour. Assuming for a moment, my lords, if the proceedings of Adhyaksha is going on, if the proceedings went on up to 1 hour,
Quorum idre, it can continue for the whole day.
No, in respect of another office is concerned.
It's the same meeting.
No, same time, same place.
It's the same meeting.
No, offices are different. Meetings might be one.
Of the same panchayat.
Let us assuming for a broader concept is concerned, my lords.
If we have to test your submission.
Yes.
If the word Adhyaksha and Upadhyaksha ant helidre,
I don't have a case.
And you don't have a case first. Okay.
Yes.
In case bagge alla, we are looking at the legal point.
Yes.
So if the words were Adhyaksha and Upadhyaksha, then a notice of motion of no confidence cannot be moved unless it is moved against both. ಒಬ್ಬರ ಮೇಲೆ ಮಾಡಕ್ಕಾಗಲ್ಲ, ಇಬ್ಬರ ಮೇಲೂ ಮಾಡಲೇಬೇಕು.
Yes.
Everywhere the word used is or. So if we use supplant or with the word and, then any motion of no confidence has to be moved against both Adhyaksha and Upadhyaksha.
The moving of no confidence, my lords, is entirely, my lords, the rights of the members. It is and, my lords, where 49 speaks regarding, my lords, the procedure contemplated. Motion of no confidence against Adhyaksha or Upadhyaksha of a Gram Panchayat.
So ನೀವು ಈಗ ಲಂಡನ್ ಹಾಕಿದ್ರೆ, it will be every Adhyaksha and Upadhyaksha of the Gram Panchayat shall forthwith be deemed to have vacated, provided that no such resolution can be moved unless notice of so and so. Provided further that no resolution expressing want of confidence against an Adhyaksha and Upadhyaksha shall be moved within the first 15 minutes, 15 months. Provided also that where resolution expressing want of confidence in any Adhyaksha, any ogala, confidence in Adhyaksha and Upadhyaksha. So, Nimma submission tagondre, it has to be moved against both. Which is not the intention of the legislature. It has to always to be or.
Yes.
They may have confidence in the Upadhyaksha. Maybe Upadhyaksha will become the next Adhyaksha.
No, but my lords, where my lords, the definition, my lords, insofar as dictionary meaning is our concern, where or is to be, my lords, the alternative.
The dictionary meaning, will it give the, what is the effect of using that word, giving that meaning that you want?
Yes,
absolutely.
Yes.
ಇವಾಗ ಅಧ್ಯಕ್ಷ or ಉಪಾಧ್ಯಕ್ಷ ಅಂದ್ರೆ notice of motion can be moved for ಅಧ್ಯಕ್ಷ or ಉಪಾಧ್ಯಕ್ಷ.
Yes.
If you say and, ಇಬ್ಬರಿಗೂ ಮೂವ್ ಮಾಡಬೇಕು. ಒಬ್ಬರನ್ನ ಮಾಡಕ್ಕೆ ಬರಲ್ಲ.
If in the form number 1, if they have mentioned only specifically only the Adhyaksha, then my lords, only it is applicable only to the Adhyaksha.
Correct. So
if and was there in the my lords in section 49.
ಅದಕ್ಕೆ we can't, or would include and also. And cannot include or.
But my lords, and always specifies my lords in all the acts, where my lords section 5, my lords Citizens Act, my lords the constitutions, and also my lords in the literal meaning of law of lexicons, and everywhere it is an alternative, my lords, where the office of Adhyaksha and the office of Adhyaksha is entirely a different provisions, where my lords alternative, my lords, is a the entire, my lords, it revolves upon, my lords, the conjunctive and the disjunctive, where my lords, my lords, where in all, my lords, in the definitions on the legal dictionary meaning.
ಯಾವ್ದು ನೀವು ರಿಲೈ ಮಾಡ್ತೀರೋ ಕೊಡಿ ನೋಡಿ.
Yes.
ನೀವೆಲ್ಲ ಇಟ್ಕೊಂಡು ನಾವು ನೋಡಕ್ಕಾಗಲ್ಲ. Yes.
Yes. Where it gives, my lords, the definition with alternative. And in both the offices, the members, that there is nowhere it has been mentioned that two offices motions cannot be moved in only in one applications by the members. Since the word used is no confidence motion. Motions applicable most in respect of two offices.
Yes. That's your submission.
Yes. And even in respect of, my lords, the rules of, my lords, Taluk Panchayat and Jilla Panchayat is the word specifically, my lords, the or is also been specified, my lords. Where, my lords, not take much, even in the grammar book, there it is conjunctive, my lords, is always, my lords, an alternative as such. Where, my lords, in one applications, my lords, they moved by the office of Adhyaksha and the office of the Upadhyaksha, my lords. Even, my lords, it is coming into the way of, my lords, section clause 6, where 1 hour, if assuming for a moment, if there are 25, 26 members or 30 members of the Gram Panchayat members are there, some discussions going on, my lords, as such. If it is exceeds 1 hour, if Upadhyakshas, the motion starts, he may raise only 1 hour is elapsed, my form number 2 automatically deemed to be elapsed.
Say 2 point raise ಮಾಡಿದೀರಾ.
Yes.
Or disjunctive.
Yes.
ಇನ್ನು ಒಂದು time lapse.
Time lapse. Where my lords even where my lords coordinating my lords conjunctions my lords says where my lords and cannot be considered as a or, but or cannot be considered as a and, but sometimes and can be considered as a or. Where yes, but reverse it is not there my lords, the reverse policy as such.
Yes.
And even my lords where or is always an alternative right given to the members. Assuming for a moment where if a person having 2 rights, where my lords he should have qualifications my lords certain one, alternatively he should have alternative my lords means alternative rights itself, or and my lords he should have compulsorily both. My respectful submissions before my lords is this.
So ನೀವು ಅದೇ ನಿಮ್ಮ ಎಕ್ಸಾಂಪಲ್ ಅಲ್ಲಿ BE computers or BE electronics, if one candidate has both BE computers and electronics on disqualify ಮಾಡ್ತೀರಾ? Or ಅಂತೇಳಿ
or no, where my lords where if he having one qualifications it is sufficient, it is sufficient.
Next ಹೇಳಿ.
Where even my lords slide I made a research even in the or my lords even in the dictionary meaning words I pass on my lords it's where some these my lords this is accepted my lords by all the universities and all
grammar class ಮಾಡಿಸ್ತಾ ಇದ್ದಾರೆ.
I tried my level best to
Good, we are very happy.
to
Whether we agree with you or not,
no that's
we are happy with the research and the effort.
where my lords where in article 5 my lords citizens of the commencement of the constitutions, at the commencement of this constitution every who has been domicile of the territory, who has been in the territory of India, or
ಏನು ಓದ್ತಾ ಇದ್ದೀರಾ?
my lords the article where will or my lords where he must have my lords if and was there my lords it is a conjunctive meaning he should satisfy all the criteria. If or if in respect of if or comes he should have only one criteria. Where my lords here the specifically words used my lords in section 49 motion, no confidence motion. If the adhyaksha and upadhyaksha my lords parallelly moved only in one the resolution as such or in only in form number 1, my lords that is contrary to the section 49. Where my lords if the application in form number 1 itself my lords is a defective which is in the consonants my lords, is against to the section 49, the consequential acts which is done by the assistant commissioner my lords is inadmissible in the act law. Yes, only my respect.
The first instance, my lords, this is the second round of litigation by the petitioners. Annexure E.
ಇನ್ನ ಬಿಟ್ರೆ ಮೂರನೇ ರೌಂಡು ಬರುತ್ತೆ.
Please. As regards sub rule 5 that my learned friend read, save as otherwise provided in the act or these rules, a meeting conveyed for the purpose of considering a motion under sub rule 2 shall not for any reason be adjourned. This is a premature ground wherein the meeting is yet to be commenced, my lords. The first instance. And as regards the terminologies or and is concerned, I would persuade my lords to adopt the mischief rule of interpretation in order to achieve the object sought to be achieved by the parliament, my lords. On these lines, I am relying upon 2 of the decisions of the apex court, my lords. First decision is of the constitutional bench in the context, my lords. Para 44, straightly taking my lords to paragraph number 44. Bangalore Water Supply and Sewerage Board versus A. Rajappa. My lord's permission, I may be permitted to read. My lords.
Lord Denning.
May I read, my lord?
Yes.
Para 44, Lord Denning has stated the judge's task in reading the meaning of enactments. The English language is not an instrument of mathematical precision. Our literature would be much poorer if it were. He must set to work in the constructive task of finding the intention of Parliament, and he must do this not only from the language of the statute, but also from a consideration of the social conditions which gave rise to it and of the mischief which it was passed to remedy. And then he must supplement the written word so as to give force and life to the intention of the legislature. A judge should ask himself the question, how if the makers of the act had themselves come across this rug in the texture of it, they would have straightened it out. He must then do as they would have done. A judge must not alter the material of which the act is woven, but he can and should iron out the creases. Now, the creases, my lords, it is the constitutional rights of the members therein in order to move the no confidence motion in a democratic process. The next decision, paragraph 8 in the British Airways Private Limited Company versus Union of India.
Yes.
Para 8, my lords. While interpreting a statute, the court should try to sustain its validity and give such meaning to the provisions which advance the object sought to be achieved by the enactment. The court cannot approach the enactment with a view to pick holes or to search for defects of drafting which make its working impossible. It is a cardinal principle of construction of a statute that effort should be made in construing the different provisions so that each provision will have its play, and in the event of any conflict, a harmonious construction should be given. The well-known principle of harmonious construction is that effect shall be given to all the provisions, and for that any provision of the statute should be construed with reference to the other provision so as to make it workable. A particular provision cannot be picked up and interpreted to defeat another provision made in that behalf under the statute. It is the duty of the court to make such construction of a statute which shall suppress the mischief and advance the remedy. While interpreting a statute, the courts are required to keep in mind the consequences which are likely to flow upon the intended interpretation. In this backdrop, my lords, all that the petitioners are intending to, in the guise of this frivolous litigations, I would say, my lords, they only intend to prolong and see to it that the tenure is completed. I rest my submissions.
Shweta? (41). The petitioner is before this court seeking for the following reliefs. The petitioner is aggrieved by the notices dated 14/2. The petitioners, first one, Adjournment, na? The petitioners, the first petitioner, Adhyaksha, and the second petitioner, Upadhyaksha, are before this court aggrieved by the notices dated 14/2/2025 issued by respondent number 1, fixing the date for consideration of the no confidence motion as 3/3/2025 at 11 a.m. in the office of the Gram Panchayat, Iregondnagar, Kustgi Taluk, Koppal district. Shri Anand Kolli, learned counsel for the petitioner, firstly submits that the requisition notice issued under Form 1 in pursuance of Sub-Rule 1 of Rule 3 is a joint requisition notice which has been issued as regards both the Adhyaksha and Upadhyaksha, And as such, the requisition notice itself is not in accordance with the applicable law, inasmuch as the words used in the statutes are adhyaksha or upadhyaksha, and as such, a single requisition notice could not have been issued in respect of both the adhyaksha and upadhyaksha. A second submission is that in order to consider both the notice of motions, the first respondent assistant commissioner has fixed the same date, time and venue as if both the resolution would be considered at the same time, which could not be so considered. Again, he submits that there should have been separate meetings fixed in respect of the adhyaksha and upadhyaksha. Lastly, he submits that in terms of sub-rule 5 of rule 3 of the rules of 1994, if there is no quorum within 1 hour after the time appointed for the meeting shall stand dissolved and notice given under sub-rule 1 shall lapse. In this regard, he submits that if the meeting were to take up the notice of motion insofar as the adhyaksha is concerned, and if the same were to go on for more than 1 hour, then the second notice would have automatically lapsed. Thus, his submission is that the intention of legislature is not to have a joint or a common meeting, but to have separate meetings under separate notices. In this regard, he relies upon the definition of the word or. In this regard, he refers to section 49 of the Act of 1993 and submits that the usage of the word whenever adhyaksha or upadhyaksha are found is with a disjunctive in between of the word or. That is to say, adhyaksha or upadhyaksha. At no place in section 49 is a conjunctive earned used, namely adhyaksha and upadhyaksha. Therefore, there being a disjunctive or in between the words adhyaksha and upadhyaksha, there should have been separate notices of requisition under Form 1, separate notices calling for the meeting under Form 2, and there should be separate meetings held at different times in terms of sub-rule 2 of rule 3 of the rules of 1994. In this regard, he places reliance on the definition of the word or in the law lexicon by P. Ramanatha Iyer, second edition, reprint 2010, more particularly at page 1369, which is reproduced hereunder for easy reference. By referring to the said definition, he submits that when the word or is used, the same is a disjunctive and is referred to in the alternative, and as such, he submits that the adhyaksha and upadhyaksha cannot be read together, but would have to be read separately in the alternative to each other. His submission is also that if the said definition as held by, as pointed out, as contained in the law lexicon is applied, then separate notices have to be issued to the Adhyaksha or Upadhyaksha as contained earlier. He relies on contemporary English grammar by Jayanti Dakshinamurthy. More particularly, chapter 26 thereof, relating to conjunction, and submit that there are 4 different types of conjunctions, namely correlative conjunctions, compound conjunctions, coordinating conjunction, and subordinating conjunction. Insofar as the usage under section 49 as also rule 49 of the Act of 93 and the various rules of the various rules contained in the rules of 1994, the word or the word and would be a conjunction, and if the word and had been used, it was only then that a single notice could have been issued, and to both the Adhyaksha, single requisition notice could have been issued under Form 1. Since the word and has not been used, that is, a conjunctive word has not been used, there being an alternative disjunctive in terms of the word or used, Adhyaksha and Upadhyaksha have to be read separately. And he once again reiterates that all the actions would have to have been taken separately. And on that basis, he submits that the requisition notice being required to be quashed, all other further proceedings would also have to be, all other further actions taken in pursuance thereof would also have to be quashed. Shri
Abhishek Khalid. Abhishek Khalid.
Abhishek Khalid, learned counsel for
Respondent number 3 minutes. Caveator respond.
Bari 3 ga 3 to 14.
I undertake to file on behalf of 4 to 14
Who has filed caveat,
for R3.
who has filed caveat for respond number 3 and accepted notice for respond number 4 to 14, submits that the petitioners are only seeking to prolong their stay at the office of the Adhyaksha and Upadhyaksha.
Yeah.
Notice of requisition notice having been moved twice earlier.
Once.
Once
This
earlier
is the second time.
was quashed by this court on account of PDO,
Yes.
on account of the said notice containing a endorsement and signature of the PDO, the same being contrary to the decision of a coordinate bench of this court in Sanganna Biradar's case. The second time a notice of motion, notice of requisition has been moved, and once again a pedantic argument is sought to be advanced, trying to give an interpretation of the word or, which is not the correct interpretation. His submission is that this court would have to apply the rule of mischief in order to interpret the provision. Section 49 having been introduced in order to provide a right to the members of the Gram Panchayat to move a notice for no confidence. The said right being a democratic right guaranteed under Section 49, a democratic right. This court ought to give meaning and purport to said rule and not interpreted in a pedantic manner to take away the rights vested with the other members of the Gram Panchayat. In this regard, he relies upon the decision of the Honorable Apex Court, Constitutional Bench of the 9-judge,
7 judges. bench.
7-judge bench of the Honorable Apex Court in 1978, 2 ACC 213, more particularly para 44 thereof, which is reproduced hereunder for easy reference. His submission is that this court ought to interpret the words that the legislature has used in a manner to give meaning to the said words by taking into account the social conditions which gave rise to it and the mischief which it was passed to remedy. His submission is further that this court is required to give force and life to the intention of the legislature while interpreting the aforesaid provisions. He also relies upon the decision of the Honorable Apex Court in 2002, 2 ACC 95, more particularly para 8 thereof, which is reproduced hereunder for easy reference. His submission in this regard, by relying on British Airways case, is that this court should try to sustain the validity and give meaning to the provision of the Act so as to advance the objects ought to be achieved by the enactment rather than to pick holes or to search for defects, making the working of the statute impossible. In that background, he submits that the usage of the word or cannot be supplemented with the word, cannot be interpreted in such a manner that it requires 2 separate notices when the intention of the members of the Gram Panchayat is common in respect of both Adhyaksha and Upadhyaksha to move a notice of no confidence against both of them. On the above basis, we submit that the writ petition is required to be dismissed and the meeting permitted to go on. Third, Shri Anand Kolli, learned counsel for the petitioner, Shri Abhishek L. Khaled, learned counsel for respond number 3 to 14, Shri M.M. Kannur, learned AGA for respond number 1, 2 year. Hiregonnagar, Kushtagi.
Shivraj,
Koppal.
Beligiri Mutt.
Vijay Kumar Beligiri for respond number 2. Peruse papers. The questions, the points that would arise for consideration are: 1, whether the usage of the word or in section 49 of the Act of 93 and the rules of 94 is conjunctive, is disjunctive in such a manner as requiring a notice in form number 1 to be issued to the Adhyaksha and Upadhyaksha separately, or notice in form number 2 to be issued to the Adhyaksha and Upadhyaksha separately, as also for a separate meeting to be conducted for considering the motion for no confidence separately in respect of the Adhyaksha and Upadhyaksha. Whether the actions taken by the members of the Gram Panchayat and that of the Assistant Commissioner suffer any legal infirmity requiring intervention at the hands of this court. 3, what order? Answer to point number 1. The vehement submission of Shri Anand Kolli, learned counsel for the petitioner, is that the word or has to be given its true grammatical meaning, and it is only, and when such a meaning is given, it would require 2 separate requisition notice under form 1, 2 separate notices of meeting under form 2, and 2 separate meetings in terms of sub-rule 6 of rule 3, as also sub-rule 6 of rule 3. Section 49 is reproduced hereunder for easy reference. A perusal of section 49 would indicate the heading of section 49 would indicate that a motion of no confidence against Adhyaksha or Upadhyaksha of Gram Panchayat is dealt with under the said section. In subsection 1, it is stated that every Adhyaksha or Upadhyaksha of the Grama Panchayat shall forthwith be deemed to have vacated his office if a resolution expressing want of confidence is passed. The second proviso to subsection 1 would indicate that no resolution expressing want of confidence against an Adhyaksha or Upadhyaksha shall be moved within the first 15 months. Third proviso indicates that resolution expressing want of confidence in any Adhyaksha or Upadhyaksha, if has been considered negatived by the Gram Panchayat, a similar resolution in respect of the same Adhyaksha or Upadhyaksha shall not be given notice of or moved 6 months from the date of the from the decision of the Gram Panchayat. It is because of the usage of the word or between the word Adhyaksha and Upadhyaksha that Sri Anand Kolli has contended that it is disjunctive and separate actions have to be taken. Though references have been made to the definition of or in the law lexicon, those are relating to completely different and alternative items. In the present case, the Adhyaksha and Upadhyaksha, there is an Adhyaksha and a Upadhyaksha for every Gram Panchayat. That is to say that the Adhyaksha and Upadhyaksha are not in the alternative, but both the posts are available in any Gram Panchayat. It is for that reason that section 49 provides for a motion of no confidence to be moved against either the Adhyaksha or Upadhyaksha. It does not, however, restrict a notice of no confidence to be moved against both the Adhyaksha or Upadhyaksha. The right being vested with the Gram Panchayat members to move a motion of no confidence against the Adhyaksha or Upadhyaksha would also include a right to move a motion of no confidence against both the Adhyaksha and the Upadhyaksha. The permutation combination in which the members of the Gram Panchayat may act could vary in terms of some of the members, in terms of the members may want to move a no confidence motion only against the Adhyaksha or only against the Upadhyaksha or as regards both of them. If the argument of Sri Anand Kolli were to be tested by using a conjunctive word and in section 49, then the said section 49 would read as under. Shriram. Shweta?
So by using a conjunctive word,
Section 49 would read as under. Now if section 49 were to be read, then a resolution would be required to be moved against both the Adhyaksha and Upadhyaksha jointly. That is to say that a resolution cannot be moved against the Adhyaksha or Upadhyaksha separately, but the members of the Gram Panchayat would be perforce constrained to move a common motion as against both the Adhyaksha and Upadhyaksha, whether they want to move such a motion against both of them or not. That is not the purport, in my considered opinion, that is not the purport of section 49 of the Act of 1993. The Act provides the option to the members of the Gram Panchayat to move a motion of no confidence as held earlier, as observed earlier, against either the Adhyaksha or Upadhyaksha or against both of them. Merely because the word, disjunctive word or is used would not mean that a common motion cannot be moved against both the Adhyaksha or Upadhyaksha. Further, the rules relating thereto Subrule 3, Subrule 1 of Rule 3 only speaks of a written notice of intention to make a motion under proviso to section 49 in form 1. There is neither the word Adhyaksha or Upadhyaksha used in the said rule. Similar is the case with Subrule 2 of Rule 3, which enables the Assistant Commissioner to convene a meeting for consideration of the motion at the office of the Gram Panchayat. Subrule 3 of Rule 3 requires a notice in Form 2 to be given to every member, including the Adhyaksha and Upadhyaksha. The usage of the word "and" in Subrule 3 of Rule 3 would indicate that if a notice of motion is moved, then if a notice convening a meeting to consider a notice of no confidence is to be issued in Form 2, then the said notice shall be served on every member, including the Adhyaksha and Upadhyaksha, and not only as regard the person against whom it is being moved, that is, the Adhyaksha or Upadhyaksha. The legislature has therefore consciously used the word "and" in Subrule 3 of Rule 3, has also consciously used the word "or" in Section 49 as aforesaid. Subrule 5 does not make any usage of the word Adhyaksha or Upadhyaksha, but only provides for a meeting to be convened for the purpose of consideration of the motion shall not be adjourned. Subrule 6 provides for no quorum, provides that if there is no quorum within 1 hour from the time appointed for the meeting shall stand dissolved and notice given under Subrule 1 shall lapse. Again, in either both Subrule 5 and Subrule 6, the word Adhyaksha or Upadhyaksha are not used, but only reference is made to the notice. Subrule 9 Subrule 9 of Rule 3 provides for a motion is to be carried by a majority of not less than 2/3 of the total number of the members of Gram Panchayat. Then the Adhyaksha or Upadhyaksha, as the case may be, shall forthwith cease to function as such. And further provides for the Assistant Commissioner to inform the Adhyaksha or Upadhyaksha, as the case may be, regarding such cessation. Meaning can be gathered from Subrule 9 to indicate that a notice of motion, if moved against the Adhyaksha only, then he shall cease to function as Adhyaksha. If a notice of motion is moved against the Upadhyaksha only, then the Upadhyaksha shall cease to function as the Upadhyaksha, and either of them would have to be informed by the Assistant Commissioner. There is no embargo under Subrule 9 of Rule 3 that a notice of motion cannot be moved against both Adhyaksha or Upadhyaksha. In that view of the matter, it is clear that Section 49, providing a valuable democratic right to the members of the Gram Panchayat to move a notice for no confidence against either the Adhyaksha or Upadhyaksha, it is at the discretion of the Gram Panchayat members to move the said motion against either the Adhyaksha or Upadhyaksha or both of them. There is no restriction which has been provided either in the Act or the rules. Coming to the second argument of Sri Anand Kolli, that in terms of sub-rule 6 of Rule 3, if there is no quorum within 1 hour after the time appointed for the meeting shall stand dissolved and the notice given under sub-rule 1 shall lapse, meaning thereby to indicate that if at the beginning of the meeting, the notice of motion for notice of no confidence motion, the motion for no confidence against the Adhyaksha is taken up and the discussion were to last for more than 1 hour, then the second notice would automatically lapse. Is again a pedantic argument which has been advanced. The sub-rule 6 of Rule 3 only provides for quorum not to be present within 1 hour and does not provide for a meeting not being conducted within 1 hour. Both the meetings scheduled at 11 a.m., notice having been issued. If it is only if there is no quorum as required, then sub-rule 6 of Rule 3 would be applicable. If the quorum is there for consideration of the motion of no confidence against one of the office bearers, the said quorum would continue for the next meeting. If at all there is no quorum for the next meeting, then the question of would continue for the next meeting, since the meeting, both the meetings are proposed to be held at the same time. Thus, the question under that's what sub-rule 6 of Rule 3 deals with is not the time taken for conduct of the meeting, but the presence of the quorum at the beginning of the meeting. As rightly contended by Sri Abhishek L. Khalid, Learned Counsel for the respondent number 3 to 15.
14. 3 to 14.
3 to 14. This argument is a premature argument since the meeting is proposed to be held on 3rd March. It is the outcome of the said meeting and the quorum present at the said meeting which would have to be considered for appreciating the argument under sub-rule 6 of Rule 3. Be that as it may, what this court would have to opine at present is that sub-rule 6 of Rule 3 would relate to the quorum at the beginning of the meeting and not the time at which the notice of motion, no confidence is taken up. In that view of the matter, coming back to the facts of the matter, a common notice has been issued under Form 1 by two-thirds of the by more than one half of the members, as required under the second proviso to the first proviso to subsection 1 of section 49. Thus, it satisfies the requirements thereof. Merely because a common notice, a common requisition has been made for both the Adhyaksha and Upadhyaksha, the same does not fall foul of subsection 1 of section 49 of the rules of the Act of 93 or the rules of 94. The notice issued in form number 2 by the Assistant Commissioner is not a common notice, but is a separate notice. The one at Annexure C is in respect of the Adhyaksha. The one at Annexure D is in respect of Upadhyaksha. The Assistant Commissioner, in my considered opinion, could have issued a common notice on the common notice convening the meeting on the basis of a common requisition notice. The issuance of separate notice or common notice would not make any difference insofar as form number 2 in that regard is concerned. In that view of the matter, I answer point number 1 by holding that the discretion is of the Gram Panchayat members to move a notice of no confidence either against the Adhyaksha or Upadhyaksha or together. Moving a common motion for no confidence against both the Adhyaksha or Upadhyaksha cannot be said to be contrary to the applicable law. Point number 2. In view of my finding on point number 1, I do not find any infirmity in Annexure C and D, which are impugned in these proceedings. What order? The petition stands dismissed.
Grateful, man.
ನೆಕ್ಸ್ಟ್ ಇನ್ನೊಂದು ನಾಳೆ ಸೋಮವಾರ ಇನ್ಯಾವುದೊಂದು
Not a single ball remain on the snooker board.
ಗೊತ್ತಿಲ್ಲ ಇಲ್ಲ ಅಂತ ತರ್ತಾನೆ ಇದ್ದೀರಾ. ಬಟ್ ದಿಸ್ ಎ ಗುಡ್ ಪಾಯಿಂಟ್. ಟ್ರೈ ಮಾಡ್ಬೇಕು. ಟು ಡೂ ಇಟ್ ಫಾರ್ ಯುವರ್ ಟ್ರೈ ಮಾಡಲಿಲ್ಲ ಅಂದ್ರೆ ಅಡ್ವೊಕೇಟ್.
Yes, sir. Obviously.
Sometimes it may work, sometimes it doesn't.
No, obviously. Of course.
42. Oblige.
It's a good effort.
Sir, Hegde.
Please, my lord. The defendant number 1 petition, my lord. Defendant number 1 petition. Suit for my lord declaration and partition. Declaration to the effect that the plaintiff is the adopted son of the late Manohar and Satyava. My lord, this defendant has taken the defense of the will, my lord, which is executed by the late Satyava, who is the daughter of the defendant number 1, in favor of the defendant number 1, my lord. Before this filing of the suit, my lord, this defendant number 1 has filed the P&S proceedings. Accordingly, my lord, the district court has granted the probate and succession certificate in favor of the defendant number 1 on, my lord, 27/1/2022. Thereafter, my lord, this plaintiff has filed the appeal before this honorable court in MFA, my lord. After in the matter that MFA came to be allowed, stating that the legality of the will is under challenge in the suit. After passing of the order, my lord, thereby that probate and succession certificate has been set aside. After passing of the order, my lord, I filed the application.
A counterclaim.
Oh.
Issue notice to the respondents, returnable by 22nd April. The further proceedings in
191 of 2022, my lord, OS number 1.
Correct. In OS number 191 of 22, pending on the file of the principal senior civil judge and JMFC Jamkhandi, he stayed till the next date of hearing. Process fee and copies to be furnished by end of day 24th February. Acknowledgement of service on notice on the respective counsels appearing for the respondents before the trial court to be filed on or before 3rd March. Failing either of which, the interim order will stand automatically.
Much obliged.
43, MC Keri.
It is challenge. I number 4 order is challenged before this one. May I pass on the genealogy? I'm not disputing the granted share, my lord.
Suit
for partition filed by mother and.
Oh, this EP is either.
EPL in no. EPDP is also I'm not disputing also. When EP is filed, wherein during the pendency of the suit, the mother is died, my lord. She has executed a will in respect of plaintiff number 1. Now my lord, the execution petition in itself, under provisions of section 47, they are tried as if it is a suit. It is not permission under the
Can
law.
you file an application of 151 to discard the evidence of the decree holder?
Inherent power ಹಾಕಿದ್ದಾರೆ. Correct.
ಅಷ್ಟೇ. ಏನ್ ರೈಟ್ ಇದೆ ಹೇಳಿ?
Please, madam.
ಡಿಕ್ರಿ ಹೋಲ್ಡರ್ ಎವಿಡೆನ್ಸ್ ಡಿಸ್ಕಾರ್ಡ್ ಮಾಡಕ್ ಜಜ್ಮೆಂಟ್ ಲೆಟರ್ ಅಂಡ್ 151 ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಕ್ಕಾಗತ್ತೆ. You can only cross-examine them if you want to. If you don't want to, don't cross-examine.
The establishment of will itself is illegal. The order which is passed by the earlier application, I number 3, itself is illegal.
They have a right to lead evidence. You have a right to cross-examine. You can't say our evidence I discard ಮಾಡಿ ಅಂತ. You cross-examine them.
No, under provisions of my lord, in EP itself, there is no question of establishment of will, my lord. There is no pleadings and issues and everything.
That's a matter that you can argue. You cannot say discard the evidence. They were required to lead evidence. They have laid evidence on something.
It's permitted me in I number 1.
Cross-examine them.
I number 1, my lord, which is rejected earlier point of time. DHR has filed an application for issuance of warrant. Annexure G, page number 51. The very court has given a categorical finding saying that without proving the will, the execution court cannot pass in warrant.
See, now
In favor of-
evidence has been laid. You have to cross-examine. Arguments you can advance on that evidence led, ಇದು correct or wrong, ಆಮೇಲೆ ನೀವು argument ಮಾಡ್ಬೋದು. Discard ಮಾಡಕ್ಕೆ ಆಗಲ್ಲ.
Even if it is, my lord, the inception itself, the will which is incorporated in section 40, under the provisions of section 47 of the act.
ನಿಮ್ದು ಯಾವ್ಯಾವ ಸೂಟ್ ಹಾಕಿದ್ರೆ ಹೇಳಿ, ಎಲ್ಲರೂ ಡಿಸ್ಕಾರ್ಡ್ ಮಾಡ್ಬೇಡಿ ನಿಮ್ಮ ಎವಿಡೆನ್ಸ್. ಸರಿ ಇಲ್ಲ ಎವಿಡೆನ್ಸ್.
No, that court has not, my lord, let the evidence in the EP
It should be appreciated, Mr. Ukeri, not discarded.
But my lord, infringement, that what use it 151 ಹಾಕಿದ್ದಾರೆ ಅವರು. But my lord, abruptly they are produced some documents and laid evidence without giving an opportunity by filing an objection. That's also
Cross-examine. Cross-examine them. Notice to respondent is dispensed with in view of the proposed order to be passed. Petitioner is before this court seeking for the following orders. The respondent, having filed execution petition number 6 of 2021, had led evidence therein. The petitioners who are judgment debtors 1 to 4 had filed an application under section 151 of CPC for discarding the evidence of the decree holders in IA number 4. The said application came to be rejected while order dated 9/12/2024. It is challenging the same. The petitioners are before this court. Shri MC Ukeri, learned counsel for the petitioners would submit that the decree holder has led evidence on aspects which cannot be decided by the execution court. Furthermore,
based on will.
That the evidence has been led as regards a will, as regards which the execution court cannot give a finding. Lastly, his submission is that the evidence was led by the decree holder when the judgment debtors were not present. Ashtana heard Shri MC Ukeri, learned counsel for the petitioner, and peruse papers. The right of the decree holders to lead evidence in the execution petition cannot be does exist, and it cannot be said that the decree holder could not have led evidence. Once evidence is led, it is for the judgment debtors to cross-examine the said witness on the documents which have been produced. The judgment debtor or any party, the judgment debtor cannot seek for discarding of the evidence just because the judgment debtor do not like the evidence or are of the opinion those evidence are irrelevant. Upon cross-examination by the judgment debtor, it is for the court to appreciate the veracity or otherwise, materiality or otherwise of the said evidence and pass necessary orders. The same cannot be considered in an application filed under section 151 of the Code of Civil Procedure by exercising the inherent powers vested in the execution court. In that view of the matter, I do not find any infirmity in the order passed, impugned order, reserving liberty to the petitioner to cross-examine the witness of the decree holder. Petition stands disposed.
But here, my another point of view on the section 47, non call in question. Section scope of 47. The court,
what
is executed, my lord, the court duty is only to execute the limited purpose to execute the decree which is passed. Other than that, my lord, it cannot go beyond the decree or to add something for that reason for.
You challenge only orders on IA4.
ಅಲ್ಲಿ ನಾನು ಕೇಳಿದೀವಿ. That is, my lord, set aside the order which is passed by the allowing the application as well as the evidence. ಅದು ನಾನು ಕೇಳಿದ್ದೀನಿ.
IA4 is 151 ಅಷ್ಟೇ.
Yes, my lord, I1 is 151.
47 ಅಲ್ಲ ಇದು.
ಇಲ್ಲ, the order which is passed earlier, my lord, that which I have sought for set aside that order, I number which is I number 2, wherein the court has abruptly accepted.
That is not subject matter of this writ petition. I'll separate a challenge ಮಾಡಬೇಕು ನೀವು if you want to challenge it.
Yes, my lord. Basically, ಅದನ್ನೇ ಚಾಲೆಂಜ್ ಮಾಡಿ ಅವರು ಅಪ್ಲಿಕೇಶನ್
ನೋಡಿ
ಬಿಫೋರ್
ಇದನ್ನ not expressing anything over challenge ಮಾಡಿ ನೋಡಿ.
Before
ಇರೋದು ಇಷ್ಟೇ. Yes. Two thirty. ಮಾಡಿ ಆಮೇಲೆ ಎಂಡ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಆಮೇಲೆ ನೋಡೋಣ ಎಂಡ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಬಂದಿದೆ ಎಂಡ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ತಗೊಳ್ಳಿ ಫಸ್ಟ್ 230
permitted to return documents.
The original documents and or certified documents, if any filed, are permitted to be, are directed to be returned to the petitioner after following due procedure.
Please.
233 matter, 1, Omkar Desai.
The petitioner of the PG course, my lord. They admitted in the year 17, 18 and 18, 19, my lord. Due to COVID period, they have not completed the course, my lord, within 6 years. In identical matter, they have admitted to appear there.
The Avinash Bankar for respond number 1, the Avinash Angadi for respond number 2, issue notice to respond number 3.
Yes, my lord.
Returnable by 19th March. Respondents are directed to permit the petitioner to appear for the final year examination scheduled to commence from 4/3/25 for the PG course in Ayurveda by accepting the examination fee to be paid by the petitioner and issuance of necessary hall ticket
Yes, my lord.
and compliance with all other formalities in relation thereto.
One submission, my lord. Petition number 1, 2 and 6 for first year and petition number 3, 4, 5 is for
For the respective examinations.
Please, ma'am. I request for hand delivery.
And delivery.
Please.
230 matter, 108, Prithvi KS.
Memo of withdrawal.
That's where a memo for withdrawal.
Memo of withdrawal ಇದೆಯಪ್ಪ ಅದರಲ್ಲಿ. One 108 ಕೊಡಪ್ಪ ಯಾಕೆ ಏನ್ ಕನ್ಫ್ಯೂಷನ್ ಇದೆ ಯಾಕೆ Petitioner is before this court seeking for the following. A memo dated 22/2025 has been filed, signed by the petitioner and the counsel for the petition, which reads as under. Accepting said memo, petitioner is dismissed as withdrawn.
109, Prakash Javalkar.
ಎರಡು ದಿನ
I'm sorry, Lordship.
Mr. Javalkar.
Immediately, I did a Gulfarg. In fact, Lordship, one request, Lordship, here. The assessment of the fees was made in the year 2022, Lordship. In fact, they are paid in the year 2024 and immediately returned it. Only thing is, Lordship, if they make fresh application, we'll consider as per the present.
My submission would be, again, fresh application means I have to go undergo with the trauma of again placing it before the concerned committee and all those aspects. I have already filed my layout map and all other details with all documents. So if at all there is any difference between the challan that has been issued in 2022 and the amount that has been paid by me, I am ready to pay that amount. Because on the other day also they made a submission that this amount is also refunded on the, this is what the submission made. But my lord, let me be very straight enough. Not a rupee has been refunded. So already I have paid 30 lakhs plus. So if there is any difference, I am ready to bear that. That is the 2 years calculation.
Because, Lordship, what happens?
Then a fresh application will not.
You will have to pay the interest on that money.
We have paid, Lordship, already. I received.
I am having my complete account statement with me.
ದುಡ್ಡು ನಿಮ್ಮ ಹತ್ರನೇ ಇದೆ.
ಚೆಕ್ ಕೊಟ್ಟಿದ್ದೇವೆ ಅಂತ.
ಇಲ್ಲ ಯಾವುದು ಚೆಕ್ ಇಲ್ಲ ಸರ್. I am having the complete account statement with me, Mago.
As per my instruction, Lordship, they have received me the letter saying that on 21/12/2024, through check number 179599, they're refunded by deducting some.
12 after 2 years.
ಅವ್ರು ತುಂಬಿದ್ದು ಅವಾಗ 24 ಅಲ್ಲೇ ತುಂಬಿದ್ದು, not 2 years.
31/12. They want to say after filing of my petition.
We have made order on 17/2/2022.
15th June.
We have made order. And on 15/3/2024, they said they had transferred amount, Lordship. And immediately, Lordship, on 12/11/2024, as per my instruction.
Find out properly.
Please, Lordship. Only thing is, Lordship, as per my instruction, what happens, Lordship, here, the amount has to be decided by the committee itself, Lordship.
If the amount has been refunded by you, we
Please.
direct them to file a fresh application.
Please.
The amount is with you, you do
Please.
the
As per
valuation.
truth.
So if some other amount to be paid, further amount to be paid, they'll pay it.
My lord,
Please.
If you are retaining the money, then you can't say that.
I'll just,
this letter is dated 21/12/2024. Check which they have mentioned is again 21/2024. My petition is filed on 15th July 2024. That is after filing of the petition, they want to say that it has been refunded.
Have you taken return
No.
of the money?
No, my lord, I have not.
ಅದು very firm.
Then you have nothing to worry if you have not taken.
ಇಲ್ಲ, ಅದನ್ನಿದ್ರೆ ಬೇಕಾದ್ರೆ
If you have not taken return, they'll.
Please.
Any difference amount, if it is there, I am ready to bear that amount.
We'll record the clear statement. It should not be embarrassing for him. ಅದಕ್ಕೆ.
Please. Tomorrow itself.
Council
Monday, it's
Please, my lord, no issue.
Counsel for the respondent submit that he has received instruction that the amount paid by the petitioner has been refunded. He seeks 2 days' time to verify and make his submission. If refunded, to place on record documents in relation thereto. Released on 5th March at 2:30 PM.
110, M. Show Prakash.
I appear on behalf of.
I appear for petitioner in this matter.
You did not inform Mr. Raghavan
No, we
that
are-
you are taking adjournment.
My lord, yesterday I taken adjournment, my lord.
But you have informed everybody.
We have informed.
ನೆನ್ನೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ರೆ ಅಡ್ಜರ್ನ್ಮೆಂಟ್
No, my lord, yesterday. we had no
ನಮಗೆ
information.
ಇನ್ಫಾರ್ಮ್ ಮಾಡಿಲ್ಲ.
ಪ್ಲೇಸ್ ಇನ್ಫಾರ್ಮ್ ಅಂತ ಇದ್ದೀರಾ
ಇಲ್ಲ ನಾನು ಅವ್ರಿಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೇನೆ ಇವತ್ತಿನ ಮ್ಯಾಟರ್.
Open ಯಾರು ಕೇಳೋದು?
ಸಾರಿ They are not.
You are misleading the court.
No, my lord, I am per petitioner, my lord. Yesterday I have informed, my lord, is to phone number, my lord, 944. My lord, one, my lord, yesterday I have taken number, one, Mr. Prashant G. Goundar.
He is here.
I'm here. No.
He was sitting here from morning to evening. ನೀವು ಬೆಳಗ್ಗೆ 10:30ಗೆ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ತಗೊಂಡೋಗಿ ಅವರು 6 ಗಂಟೆವರೆಗೂ ಕಾಯ್ತಾ ಇದ್ರು.
Nobody.
ಸ್ವಾಮಿ ಇಲ್ಲ ಅದ್ರಲ್ಲಿ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿ ನಾವು ನಂಬರ್ ಮೆನ್ಷನ್ ಮಾಡಿದ್ವಿ ಸ್ವಾಮಿ, ಇದರಲ್ಲಿ ಫೋನ್ ನಂಬರ್ ಹಾಕಿದೀವಿ, ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ವಿ ಎಲ್ಲರಿಗೂ.
ಹೇಳ್ತೀವಿ ಅದಕ್ಕೆ ಡೋಂಟ್ ಡೂ ದೀಸ್ ಕೈಂಡ್ ಆಫ್ ಥಿಂಗ್ಸ್. ನಿಮ್ಗೂ ಹಂಗ್ ಮಾಡಿದ್ರೆ ಯಾರಾದ್ರು? ನಾವೇನೋ ಇಲ್ಲ.
ಅಪಾಲಜಿ, my lord.
Yes, what is this? Make your submission.
Your Lordship, may I make a
My lord, one
submission?
submission, my lord.
So far as respondent number 11, Your Lordship, my senior's name is shown. However, a copy, I think, Your Lordship, is not served on us, and there is a prayer made against us. I do not have
There is a prayer made against you.
prayer number 6, Your Lordship,
How do you know prayer number 6?
on the
Without
internet,
any-
Your Lordship, on the website of
Prayer information.
prayer information.
Who is for the petitioner?
My lord, I am per the petitioner, my lord.
ಹೇಳಿ.
My lord, in this matter, my lord, we have engaged senior counsel, one Padmanabha Mahala, my lord. He is in bedridden, my lord. My lord, he is in hospitalized. My lord, 1 week time may be grant, my lord.
My lord, again, it's a wrong submission. He is not hospitalized. I mean, my lord, I know that.
My lord, yesterday, today morning, my lord, senior counsel also informed other side senior counsel, my lord.
Mr. Raghavan, if he is saying that the council is hospitalized.
No, my lord, let me tell. No, my lord, it's not correct. I tell you, Lordship, what happened. My lord, just about half an hour ago, Mr. Padmanabh Mahale himself called me and then said, "Do you have any objection if I ask for time?" I said, "Yes, we have objection." He said, "That is all, then I will not even accept this brief." That is all that happened. And my lord, there is, we can't see, my lord, the problem is that 1971 acquisition.
Mr. Rajana, ಹಿಂಗ್ ಮಾಡ್ಬೇಡ್ರಿ.
Yeah.
My lord, today
Counsel
morning,
only-
today afternoon, my lord, my senior counsel informed the other side senior counsel, my lord.
See, you make any legal argument, we'll consider it. You
Please, madam.
stretch your imagination to your legal argument, we have no problem, we are happy. Inge, submissions ಮಾಡಿದ್ರೆ it will be a problem. Please don't do this.
ಇದ್ರಲ್ಲಿ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬೇಕಿದೆ ಸ್ವಾಮಿ, ಅದಕ್ಕೆ ಒಂದ್ ವಾರ
ಇನ್ನೊಬ್ಬರು ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಹೇಳಿದ್ದಾರೆ. Now should we believe the senior? Especially with the yesterday's conduct.
ಎಸ್ಟರ್ಡೇ ನೆನ್ನೆನೂ ನಾವು ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ವಿ ಸ್ವಾಮಿ. ಅದರಲ್ಲಿ ಅವರು ಫೋನ್ ನಂಬರ್ ತಗೊಂಡು ಫೋನ್ ನಂಬರ್ ಬೇಕಾದ್ರೆ ಹೇಳ್ತೀನಿ ಸ್ವಾಮಿ. Moreover, state government also not filed statement of objection.
It's not good. We should not be getting involved in all these.
No, I'm things. Nobody called me. In fact, on
Photo submission hang ಮಾಡ್ಕೊಡೋದು ನೀವು ಹಿಂಗಿಲ್ಲ. Raghavan, we'll have it on Tuesday. We'll give him 2 more days to see whatever arrangement that he can make.
Very well. All right.
Since what you are also saying.
2:30, madam.
You are also saying Mr. Male says that he won't accept the brief. It is
Yes, he
opposed.
told me that, madam.
So he was engaged. He was proposed to be engaged or engaged.
That I don't know, my lord. He called me and told me that he was not well, and if we have objection, he will not accept the brief. I told him we will have objection.
And whatever arrangement you want to make, you make by Tuesday.
Next Friday, my lord. Send out next Friday, my lord.
Not at all.
They are trying.
Learned counsel for the petitioner submit that they've engaged a senior counsel and he seeks for a short accommodation. We list on, though the same is not a ground for adjournment. He engaged a senior counsel who is unwell. In that view of the matter, relist on 25th at 2:30 p.m.
Your Lordship, in the meanwhile, may I seek for a direction for copies, Your Lordship? Since the council is appearing.
ಎಲ್ಲರಿಗೂ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ ರಾಜಣ್ಣ?
ಕೊಟ್ಟಿದ್ದೀವಿ ಸ್ವಾಮಿ, ಎಲ್ಲರಿಗೂ ಕೊಟ್ಟಿದ್ದೀವಿ ಸ್ವಾಮಿ.
ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 11 ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಇದ್ದಾರೆ ಇಲ್ಲಿ. In the first matter.
Pollution ಸರ್ವ್ ಮಾಡ್ತೀವಿ ಸ್ವಾಮಿ, pollution control board.
Mr. Karvi.
KDB and
ಬಂದಿದೆಯಾ ಕಾಪಿ?
No, my lord. I was not.
KDB pollution.
ಬಂದಿಲ್ಲ. ಶಶಾಂಕ್,
I am not.
ರವಿರಾಜ್ ಪಾಟೀಲ್, ಪ್ರಶಾಂತ್ ನಿಮ್ಗಿದೆ.
ನಮಗೆ ಬಂದಿದೆ.
ಯಾಕ್ರಿ ಹಿಂಗ್ ತಗ್ಲಾಕೊಳ್ತಾ ಇದ್ದೀರಾ ಎಲ್ಲದಕ್ಕೂ?
ಸ್ವಾಮಿ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಎಲ್ಲರಿಗೂ ಸರ್ವ್ ಮಾಡಿರೋ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಇದೆ ಸ್ವಾಮಿ. ನಾನು ಕೌಂಟರ್ ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ.
ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ ಇವತ್ತು ಕೊಡಿ.
In fact, the point, my lord, is a 1971 acquisition challenge in 2024. None of the
We come to the merits after all these things get sorted out, Mr. Raghavan. Merits kodre helli.
And now to say.
Very preliminary stage of even appearance. So.
I know, my lord.
And
now to say, my lord, that
copies,
JSW has not set up as factory.
Copies if not served on the respondents to be served by end of day today, failing which the petition will be dismissed for non-prosecution. Copies ಏನೇನ್ ಬೇಕೋ serve ಮಾಡಿ.
Please, ma'am.
My lord, 2:30, my lord.
Yes, at 2:30.
Grateful.
Rahul Kuntoji.
Please, ma'am, for petitioner, my lord.
Yes.
Petitioners are the agriculture farmers, my lord. And come to page number 32, my lord, village map, my lord. The respondent number 4 and 5, who are the agriculturists, they have now obstructed the earlier road, my lords. Page number 32, my lords, for a moment, my lord.
And AGA accepts notice for respond number 1 to 3. Notice to respond number 4 and 5 is deferred for now. And AGA seeks for is granted 3 days time to obtain instructions and make his submission.
Yes.
Released on 25th at 2:30 p.m.
One submission.
Let him get his instructions.
They have also filed their report also, my lord.
Huh?
They have also filed the report, my lord. The chiller also. Please, my lords, for a moment.
ಇವಾಗ ಅವ್ರು ನೋಟಿಸ್ ಕೊಡ್ತಾರೆ.
Please, my lord.
ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ತಗೊಳ್ಳೋದು ಬೇಡವಾ?
Page number, annexure H, my lord, page number 38, my lord, from the bottom side. Second paragraph. ಒತ್ತುವರಿದ ಕ್ಷೇತ್ರ ಎಕರೆ 1 ಗುಂಟೆ ಅಂತ ತಾಲೂಕು ಭೂಮಾಪಕರು ವರದಿಯನ್ನು ನೀಡಿರುತ್ತಾರೆ. ಸದರಿ ರೀಸಾ ನಂಬರ್ಗೆ ಹಾದು ಹೋಗಲು ರೀಸಾ ನಂಬರ್ 869 ಉತ್ತರ ಮೂಲೆಯಲ್ಲಿ ವಹಿವಾಟು ರಸ್ತೆ ಇರುವುದು ಕಂಡು ಬಂದಿರುತ್ತಾರೆ ಅಂತ ಕಂದಾಯ ನಿರೀಕ್ಷಕರು ಅತನಿಯವರು ವರದಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. There is also report, my lord. And moreover, my lord.
And your lordship, they in the prayer, your lordship, they are sought for by them to consider their representation, your lordship, annexure C.
So in this view of the report, we'll direct. Third, 111. Petitioner is before this ಅಲ್ಲ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಲ್ಲಪ್ಪ.
My lords, one submission. In similar matters, this coordinate bench of this honorable court has directed, please, directed directed Tashildar to remove the obstructions which is illegally by the respondent, private respondents, my lord. I have also sought for the interim prayer also, my lord. For a moment, page number 18, my lords. In my petition, photographs have been filed, my lords.
And AG accepts notice for respond number 1, 2, 3, issue notice to respond number 4 and 5, returnable by 26th March. Connect the above matter to WP
No,
number
ma'am. This is different matter.
303072 of 2022.
This is different, my lords. In similar matter, this honorable court has directed the Tashildar to remove the obstructions.
That is, your survey number is different. This survey number
Number is
is different.
different.
He cannot, your lordship,
Survey numbers are different, my lord. I am,
what is the position in that survey? I now don't know.
ಇದು ಬೇರೆ.
survey numbers are different. In the similar situation, my lord, this coordinate bench,
ಬೇರೆ.
my lords, there are photographs also I have shown, my lords, page number 18 and 19, my lords, kindly share, my lords. Now the serial, for a moment, my lord, village map, page number 32, my lords. The petitioners are the owners of 868, my lords. Survey number. And the present respondent number 8, respondent number 5, my lords, he is the owner of 882. Now his land has been converted as the agriculture into the non-agriculture, my lord. Now he has constructed the gutter, my lords. Kindly come to the page number 18, my lords. My lords, see the any potential land.
ನಿಮ್ಗೆ ಎಲ್ಲಿದೆ 882 ಇಂದ?
No, my lords.
You are in 868.
Please, my lords. There are total 7 lands have been considered at a single point, my lord.
ಯಾವ್ದು?
My lords, 882, 883, 868, 869, 872, and 873, 874, my lords. They are also at a single point, my lord. In the meanwhile, my lords, 879, 872, there is a district main road, my lords. There is only 4 to 5 feet from the distance of the district main road, my lord. Respondent number 5.
Yes.
First order really. And AG accepts notice for respond number 1 to 3. Notice to respond number 4 and 5 is deferred for now. Relist on 25th at 2:30 PM.
Please, my lords.
112, Sunanda P. Patil.
Yesterday's matter. That is directed to submit whether there is a divorce in propositors and the
ಇದು ಅಡ್ವೆಪ್ಪ ಆಮ್ಲಿ ಬೆಳಗ್ಗೆ ಅದು ಕನ್ಫ್ಯೂಷನ್ ಆಗಿ ಸೇಮ್ ನೇಮ್ ತಾನೆ.
filing the memo, your lordship.
Ah.
The defendant, contesting defendant number 3 has submitted information to the deputy Tashildar Kittur and obtained the survival certificate. The name of the plaintiff is shown as wife.
My lord, I filed, my lords, defendant number filed a written statement wherein, lords, we have denied the same.
ಅಲ್ಲಪ್ಪ, you are saying she is the first wife.
She is not the wife, my lord. She is the second wife, lords, which are, my lords, are taken in contention of my WS. Lords, that Aadhaar card for a moment, my lords, the second document, which is produced by the petitioner, wherein my name is the first, my lord, then, my lords, my all children's, then, my lords, subsequently the name of the petitioner who is age about 73, no issues.
Correct, she has no issues.
She is not having.
Now,
any issues,
all the
that's why-
defendants are,
He
that's why
got
he has
married to
contacted
you.
second marriage.
That is why he got married.
my lord, my lords, in fact, I am the first wife, my lord, so, and out of that, my lords, the respondent 1 to 4 were born, and the respondent number 5 is the mother. And my lords, the respondent 1 filed an impleading application before the consumer court, which was rejected. Now, the petitioner also filed an application before the, my lords, consumer court. They have suppressed the fact that, my lords, they have not produced those documents before this honorable court.
Consumer court is okay, but who is the first wife, who is the second wife?
That is, my lords, matter of trial, my lords. We filed a WS, my lord, and my lord, the fixed deposit is concerned, my lord. Here. Now, my lords, for the moment, my lords, injunction order for a moment.
It is not filed by the defendant number 3, contesting defendant number.
He is also my brother, my lord.
And
Page
no
13
way-
for a moment, page 13, not the plaint. My lords, out of nine, my lord, the suit properties, my lord, there were 6 properties in the name of the defendant number 3. And my lords, I undertook that, my lord, I will not sell the property and I will not alienate the property, which are, my lords, more than,
Don't withdraw the money also.
my lord, 2022 matured, my lord.
Continue ಆಗುತ್ತೆ. It will
Alla
be
continue,
reinvested.
alla, my lords, since, my lords, the bank is about to close And we moved an application before the consumer court to withdraw that fixed deposit amount.
How is the bank going to close?
Allah, it's a cooperative bank. That is what, my lords, we filed an application before the consumer.
Do you have to say that it is going to close?
Allah, because it is in a loss, my lord. That is what. 2022, my lords, matured.
Pay to a nationalized bank.
My lord, 2022 is the matured.
We'll shift it to a nationalized bank. Any problem?
Allah, my lord, I have a loan in my lord's my account. My lords,
Adike,
I have pledged.
you can't use the money. Same thing will apply for it.
Allah, my lords.
What will have to happen and you can't take
My
away
lords,
the money.
indemnity bond I'll undertake, my lords. I'll file even affidavit also, my lord. For a moment, my lords.
They fix deposit ಮಾಡದ ಬೇರೆ ಬ್ಯಾಂಕ್ ಯಾವ ಬ್ಯಾಂಕ್ ಹೇಳಿ
Allah, ಅದು ಆಗೋದಿಲ್ಲ ಅದು, my lords.
ಯಾಕೆ ಆಗಲ್ಲ
Allah, consumer court ಅಲ್ಲಿ it is pending, my lord.
ಅದಕ್ಕೆ ಏನಂತೆ ಹೈಕೋರ್ಟ್ ಡೈರೆಕ್ಷನ್ ಮಾಡುತ್ತೆ
Allah, my lord, see, at this point of time, my lords, it is fixed in the name of
ಸ್ಟೇ
the.
ಮಾಡಿ ಇದನ್ನು ಕನ್ಸ್ಯೂಮರ್ ಫೋರಂ ಆದ್ಮೇಲೆ ಬನ್ನಿ ಅಂತ ಅಡ್ಜರ್ನ್ ಮಾಡೋಣ ಇದನ್ನ ಏನ್
Then, my lords, their prayer for a moment, my lord. Their prayer.
You cannot use the money. So your option are whether to continue it there only in FD so that you will get the interest or to another bank.
If that is the case, my lord.
ಕೊಟ್ಟು ಲೋನ್ ಕೊಟ್ಬಿಟ್ಟು ಆಮೇಲೆ ಎಲ್ಲಿ ಹೋಗೋದು
Allah, my lord, my property is, my lords, before the court, my lord. Lords, I undertook that I will not sell.
Also share is claimed.
Allah, adral share agi, even if she, my lord, entitled half share.
If you are the second wife's son.
Allah, I am not the, I am first wife this son.
If it is found that you are second wife's son, you will be entitled to 0.
Lords, if
Joint family property. If you are the first wife's son, you will be entitled to everything.
But my lords, in respect of fixed deposit is concerned, my lord.
As second wife, we will get 0 in Revan Siddhapa's case. That is the problem.
Allah, but in respect of fixed deposit, my lords, I am ready to take under, my lords, indemnity bond. Even I will file an affidavit, my lord. My lords, these all property, my lords, we have, my lord.
Yes,
My lords, even, my lord, the injunction order for a moment.
The
Lord,
operation of the order dated 23/4/2024 on IA number 1 in OS number 105 of 2024 passed by Senior Civil Judge Bailongal at Annexure D. He stayed till the next date of hearing.
my lord,
Just on 28th April.
My lord,
Consumer Forum.
my lord, may I make one submission? It can be disposed because I is not disposed of. The injunction I is not disposed of. It was only modified.
To withdraw, what else is it?
My lord,
You've been permitted to withdraw the money.
please.
Earlier order passed has been modified. ಅಯ್ಯ ಡಿಸ್ಪೋಸಲ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಏನು
Yes, my lord.
ಡಿಸ್ಪೋಸ್ ಆಗಿದೆಯಪ್ಪ
It will not come in the way of no, the consumer cases.
ಇಫ್ ಸಪೋಸ್ ನಿಮ್ಗೆ ಅಲ್ಲಿ ಬ್ಯಾಂಕ್
Their impleading application today is posted for orders, my lord. They have filed application before the court.
ಕ್ಲೋಸ್ ಆಗ್ತಾ ಇದೆ ಅಂದ್ರೆ tell us the name of a bank where we can shift it to, so don't be under double loss.
La will withdraw it, my lords, the consumer court.
Withdrawal ಆಗಲ್ಲ.
Further hearing, 113, Shivraj Mudhol, Shantai Gaudar.
My lord, in this senior counsel, he is on his legs before principal bench. My request for Monday, my lord.
Pass over.
Please.
ಇಲ್ಲ ಪಾಸ್ ಓವರ್ ತಗೊಳ್ಳಿ. ಆಮೇಲೆ ಇದು ಕೇಳಿದ್ರಲ್ಲ
114, Harsh Desai.
Here for respondent 4 and 5 in this case. Not sir, I'm awaiting instructions in the matter. I request to take up on Friday, my lords.
ಏನ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಅಪ್ಪ?
Not say.
ಇವತ್ತೇ ಫ್ರೈಡೆ.
I'm sorry, my lord.
ಇವತ್ತೇ ಫ್ರೈಡೆ.
ಇಲ್ಲ next Friday, my lord. Sorry.
Last working day.
ಇಲ್ಲ even otherwise, my lords, we are not ಇಲ್ಲ. Even if it is taken as parted also, we don't.
It is parted ತಗೊಂಡು ಹೋಗ್ಕೊಡುದು. ಈ ಬೆಂಗಳೂರಲ್ಲೂ ಅದೇ ಪಾರ್ಟೆಡ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಕಷ್ಟ ಆಗೋದು.
It will be overburden.
ಲಾಸ್ಟ್ ವೀಕ್ ಎಲ್ಲ ಪಾರ್ಟೆಡ್ ಆಗೋಗುತ್ತೆ, ಅದೇ ಪ್ರಾಬ್ಲಮ್. Try not to.
I understand, my lords.
Your lordships may adjourn the matter, my lord, he wants to engage somebody. But the lordships may kindly direct them not to precipitate with the proposed procedure.
Don't take any action until we decide this.
Kindly pass over, my lords. ಇಲ್ಲ pass over ಮಾಡಿ, I'll seek instructions, my lords, insofar as that.
ಬೇಗ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಬರುತ್ತಾ?
ಇಲ್ಲ, at least ಅದಕ್ಕಾದ್ರು.
77,
69, 69, 77, 69, 74, 77. 69. ನಿಮ್ ಸೀನಿಯರ್ ಇದ್ದಾರೆ 69.
69,
ಸುಬೇಂದು
Akrowadi.
Yes.
Not sir, for petitioner. The copy served today morning.
Hiramad accepts notice for respondent. 69. Yes.
But here, Lords, now the petitioner is a company here, Lords. I was given a tender, Lords, that is by Annexure A on 22/2/2022. Subsequently, I fulfilled the terms and conditions, have also supplied the required materials to the hostels. And in terms of Annexure B, C and C1 is the tax invoice receipt for 9 washing machines as well as 5 Sony TVs, my lords. And the Annexure B, my lords, at page number.
Accepts notice for respondent. Petitioner is before this court seeking for the following relief. The grievance of the petitioner is that the invoices submitted by the petitioner at Annexure C and C1 and the request made by the petitioner C and C1 dated 1/3/2022 and request made by the petitioner have not been considered by the respondent.
It's not request, my lord. In terms of
The oral request made by the petitioner have not been considered by the respondent for the last nearly 2 years. It is in that background that the above release have been sought for. The invoices have been submitted by the petitioner. It is for the respondent to either make payment of monies due on thereon or to reject the claim of the petitioner. Neither having been done, the petitioner has been forced to come to this court. In that view of the matter, I pass the following order. Writ petition is allowed, a mandamus is issued, directing the respondent authorities to consider the request and the invoice submitted by the petitioner and pass necessary orders, either making payment or rejecting the claim within a period of 30 days from the date of receipt of copy of this order.
Please, lords. Grateful.
74, Sonu Suhel.
In this case, we considering for allowing the writ petition with certain direction by this honorable court, because the cross-examination of PW1 and PW2 taken as nil. Twice they have filed an application, both time, my lords, the opportunity was given.
Twice.
My lord.
And my lords, with the time frame, my lords, the lordship may allow the writ petition.
Time frame now, Papa, new mistake made, court time frame.
Our mistake, my lords, court has given.
Our mistake, Papa, court get.
Let them undertake before the court, my lord, saying that within a certain time.
Adjournment. And if they take an adjournment, you will lose the right for cross-examination.
Date may be fixed for cross-examination.
Completely. Inga. Petitioner is before this court. Ella service complete agidya?
Awaiting the app.
1 and 2 ideyalappa?
1 and 2 are contested.
3.
We are the plaintiff. We are the plaintiff.
He is dispensed with at the request of the counsel for the petitioner, since respondent number 3 is a co-defendant of the petitioner. Petitioner is before this court seeking for the following leaves. The petitioner is aggrieved by the rejection of I-812 filed by the petitioners in OS number 133 of 2021, wide order dated 10/1/25 at Annexure E. The said application had been filed by the petitioner seeking for recall of the stage, permitting the petitioner to cross-examine PW1.
1 and 2 both.
1 and 2 both.
1 and 2. The submission of the learned counsel for the petitioner is that the petitioners were unable to cross-examine the said witnesses on the said date, and if the petitioner were not to permitted to cross-examine, the suit being won for recovery of money and declaration sale deed being null and void, the interest of the defendants would suffer irreparably, they not having any defense. Para. Shri SS Betur Mat Learned Counsel appearing for respond number 1 and 2 objects to the above petition by contending that twice earlier application filed by the petitioner for recall of PW 1 and 2 for cross-examination had been allowed, despite which the petitioner did not cross-examine. The present application is third in line filed for recall of PW 1 and 2. The applications have been filed only to prolong the matter and for no other purpose. Having considered the submission made by the counsel for the petitioner, taking into account the claim of a large amount of money to an extent of 54 lakhs being claimed against the petitioner, as also for a declaration that a sale deed is null and void, and for cancellation thereof, I have the considered opinion that one last opportunity, last and final opportunity is required to be granted to the petitioners to enable them to cross-examine PW 1 and 2. It is made clear that if the petitioners were not to utilize this opportunity and cross-examine and seek for any adjournment before the trial court when PW 1 and 2 are present, then this order would stand automatically rescinded. In that view of the matter, I pass the following order. Writ petition is allowed. A certiorari is issued. The order dated 10/1/2025, passed on IA number 12 in OS number 133 of 21 by Principal Senior Civil Judge and CJM Belgavi is set aside. Consequently, IA 12 in OS number 130, aforesaid IA number 12 is allowed. The stage is recalled. Petitioners are permitted to cross-examine PW 1 and PW 2 on the very next date that they are present,
Please. I'll inform the date.
without seeking for any adjournment. Pending IA stand disclosed.
77 CS sector.
Suit for specific performance of contract, my lords, suit is decreed ex parte. Execution, please. Execution proceedings are initiated, my lords. I am challenging the very initiation of execution proceedings. Similar matter, my lords, wherein plaintiff was directed to deposit the money. He had not deposited within the said time. Sale deed was also set aside. Here also, my lords, I'm seeking for
issue notice to
sole respondent.
Respondent, returnable by 22nd April. The further proceedings in OS number 8, in execution case number 18 of 2018, pending on the file of the additional civil judge in JMC Koppal, he stayed till the next date of hearing. Subject to till the next date of hearing. Process fee and copies by 24th, acknowledgement by 3rd.
Please. Much.
Lord's permission, my lords. Next date of hearing is 22/3/25.
On the earlier one, on the very next date of hearing, that is 22/3/2025.
Please.
Nim witness present irಬೇಕು.
Irtar.
ಇಲ್ಲಾದ್ರೆ
Pass over matters. 10 Sriharsh Nilopan.
second one, 10.1. .1 will dismiss, Mr.
With liberty to approach.
92. ಅಲ್ಲಿ ಒಂದೇ ಸತಿ ಹೋಗಿ ಎಲ್ಲ ಸಾರ್ಟ್ ಔಟ್ ಮಾಡಿ.
Yes.
ಇದು ಎವ್ರಿ ಇಯರ್ Last time we sort out ಮಾಡಿದ್ರೆ ಮಾಡಲ್ಲ. 10.1. Petitioner is before this court seeking for the following reliefs. The reliefs which have been sought for is pending the consideration of miscellaneous application number 242 of 2023 on the file of the Principal District and Session Judge Belgavi. The said proceedings in miscellaneous number 242 of 23 were filed under section
3 and 7.
3 and 7 of the
Charitable trust.
of the Charitable and Religious Trust Act 1920, seeking for
Page number,
acceptance of the resolution
page number
appointing
43.
the management committee as per the names which had been indicated therein. This court in this court in
This court as well as,
Paschim Vibhag Tikshna Mandal
and also division bench of this court.
the division bench ಹೇಳ್ತಾರೆ. The division bench of this court in a judgment dated 27/8/2024 in WP 77680 of 2013 has categorically held that proceedings under section 3 and 7 of the Charitable and Religious Trust Act 1920 are not maintainable insofar as appointment of trustees and or confirmation of the resolution appointing trustees. If there is any dispute between the trustees, in view thereof, the very proceedings in miscellaneous number 242 of 2023 are not sustainable and are required to be dismissed. The parties are free to bring about to the notice of the Principal District and Session Judge in Belgavi, along with the decision of the division bench of this court in WP number 77680 of 2013 for doing needful. In view of the said miscellaneous number 242 of 2023 not being maintainable, the question of the present writ petition being filed to issue mandamus pending consideration of miscellaneous number 242 of 2023 would not arise. Any dispute between the trustees and or the members of management would have to be sorted out by filing proceedings under section 92 of the Code of Civil Procedure and not under section 3 or 7 of the charitable so and so. Hence, I pass the following order. Writ petition is allowed. Writ petition is dismissed.
Disposed.
Liberty is disposed. Liberty is reserved to the parties to approach the competent court under section 92 of the Code of Civil Procedure. Liberty is also reserved to the parties to file necessary application for dismissal of miscellaneous number 242 of 23 in terms of the judgment of the division bench of this court dated 27th August 2024 in WA 100006 of 2022. Yes.
On
What is the other matter?
In writ appeal, submission matter. In writ appeal, the appellate court has directed the Tahsildar to submit the bill before this court. Bills of, and that is
The
Jatra
report
expense.
as directed by the writ appeal court
This court also,
may be submitted as directed before this court. ಏನ್ ಮಾಡೋದು ಅದನ್ನ?
ಖರ್ಚಾಗಿದ್ದೆಲ್ಲಾನು ಅದು ಇದನ್ನ ಮಾಡ್ಬೇಕು.
ಅದು ನೀವು ತಗೊಂಡು ಅಲ್ಲಿ ಯು ವಿಲ್ ಹ್ಯಾವ್ ಟು ಫೈಟ್ ಇಟ್ ಔಟ್. ಜಾಸ್ತಿ ಆಗಿದೆಯೋ ಕಮ್ಮಿ ಆಗಿದೆಯೋ ಎಲ್ಲಿ ಹೋಗಿದೆಯೋ in section 92 you will have to look at, not now. Report will be filed, you can take copy.
Please.
Filed in this proceedings. Copy if applied for by any of the parties shall be furnished by the office. Yes, Sriyash?
Lord, here, a devotee, my lord, has been impleaded in a civil suit filed by the plaintiffs.
Prashant Matpati. R3 to 6, Mr. Patil, 7.
He's not,
Prashant Matpati.
he's not in this question.
Either.
Pleading.
ಯಾರು ನೀವೇ ಅಪೇರ್ ಆಗ್ತೀರಾ ಅವ್ರಿಗೆ 3 to 6?
It appears. Or here, they have filed an impleading application of some third parties, not parties before the trial court also.
ಈ 3 to 6 ಬೇಕಾ?
ಇಲ್ಲ, ನಮಗೆ.
Yes.
Short point is that, my lord, the lead petitioner which we has approached this
Let me
court.
submit.
You are the impleading application.
Yes, my application is allowed.
Dispute is between both of you.
Yes.
No, my
And
lord, dispute is
here-
not between us, my lord. He claims to be the devotee. My lord.
Dispute in.
In the subject matter of writ petition. Please, I'm sorry. My lord.
Prashant Beda. Bandru.
And he is not the party in the trial court as a, either as a chairman or as a.
Petition, ಶುರು ಮಾಡಿ.
Please,
ಬೇಗ ಬೇಗ.
Lord, suit has been filed seeking a declaration that the sale deed dated 4/5/1994 executed by defendant number 3 in favor of defendant number 4 is null and void, and also seeking a possession directing the defendant number 3 to hand over the possession of the suit property. Lord, in this case, my lord, the application is filed. Your lordship may kindly see the interim application at annexure E, page 39. He claims to be the, my lord, devotee of the temple. Whether devotee of a temple can be impleaded in a civil suit between the parties seeking a declaration of the sale deed as null and void.
Public trust.
If that is allowed, my lord, another 100 persons will come and file application that they are the devotees. We are.
What is the impugned order?
Lord, impugned order is at annexure A. Page 15, my lord. The page 17 is the order. My lord.
Are you planning to withdraw the suit?
No, my lord. Allah, that is only on their assumption, my lord.
Are you planning to?
They are not,
No,
they
my
are
lord.
defendants.
Are you planning to compromise?
No, my lord.
You are the plaintiff.
ಅಲ್ಲ ಅಲ್ಲಿ ಕಾಂಪ್ರಮೈಸ್
But ನಿಮ್ ಪಕ್ಕದಲ್ಲಿ ಬಂದು ನಿಂತಿದ್ದಾರೆ.
ಅಲ್ಲ, he's
ಅಲ್ಲ
plaintiff.
You are the plaintiff.
please.
You are for.
ಎಲ್ಲಿ impleading application cost?
ಇಲ್ಲ ಏನೋ ಮಿಸ್ಟೇಕ್ ಇದೆ. 3 is defendant. Who is for respond 1 and 2?
That is what is dispute, my lord. He claims that he is respond number 1 and 2.
Been served and they have not come.
Yes.
In writ petition.
Plaintiffs have not come.
And the defendant were in the suit, defendant number 1 and 2, defendant number 1, the present writ petitioner claims that he is defendant number 1 in the suit.
Allah, he has no locus to say, my lord,
He has
being a devotee in his.
neither he is a chairman nor he is the trustee.
He claims that he is a devotee. What is his locus to question
Some
the, my
third
lord,
party has
the
come
right
and
of the
challenged
present
the order.
plaintiffs?
That is what this honorable court last time directed them to produce the documents to show that how they have become, when they have become the chairman of the trust.
If you as trustees, you claim to be trustees, let us accept you are trustees.
Please.
If the trustees are going to compromise among themselves and eat up the property of the trust,
Please.
then what should anybody do?
No, at least one supporting document to that effect that we are going to withdraw or compromise the suit. my lord.
The fact that your plaintiffs are not before us is enough. to presume that?
How can it? My lord, that your lordship's view is right, but
Where are your plaintiffs?
Lord, may I submit, my lord? Whether
Matpati plaintiff ಅಂದ್ರೆ ಇಲ್ಲ ಅವರು.
ಅಲ್ಲ ಅವರು plaintiff ಗೆ ಇರಬೇಕು. Plaintiff.
Plaintiff ಇಬ್ರು served not represented.
Lord, my question is, my lord, whether a devotee has got a locus standi to question the suit, my lord.
But sometime we'll park that question. But if your trustees are compromising a temple's property, one more temple that we can't go to now. If you are compromising, what should the devotees do?
The right, my lord, what your lordship is right in protecting the interest of the public trust. It is right, my lord. But the thing is, if at all, my lord, they have entered into a compromise, his right of he has got an alternative remedy as against the compromise, not in this suit, because he is not neither a necessary nor proper party.
Or do we tell Mr. Kannur to find out if they have to appoint an administrator? If you are compromising and you don't want a devotee to come, and you are dealing with the public.
My lord, my point is, my lord, if your lordships dismiss my writ petition confirming the order of application filed by a devotee to implead in the suit, then the consequences of.
We will restrict their right to intercede only if you compromise.
My lord, he is neither necessary nor proper party, my lord.
You make a submission that you are not going to compromise.
I do agree, but my lord,
are you going to make that submission?
My submission is, if we let us assume that we have entered into a compromise, his right is not in this suit. My submission is he has to file a representative suit, my lord.
Why should he wait for you to compromise?
My lord, legal framework, if we think in the legal framework, my lord.
ನೀವು illegality ಮಾಡ್ತೀರಾ ಆಮೇಲೆ ಅವ್ರು legal ಹೋಗು ಅಂದ್ರೆ?
My lord, your lordship's view is right, but he has no, my lord, right to implead in the present suit of this nature, my lord.
The problem is you can ask the assistant commissioner to be impleaded or tahsildar to be impleaded. ಅವ್ರು ಏನು ಮಾಡಲ್ಲ ಅವರು. They'll just watch what you are doing and keep quiet. At least somebody is there to see if you are doing right or wrong. You are not making a statement that you are not settling.
Please.
You are not making that statement.
Yes, that is their assumption. My lord, the only intention of filing application is to disturb the managing committee. That's all, my lord.
But you are not.
I undertake before this honorable court, my lord, that we are not going to, we will pursue the suit.
You will pursue this.
Please.
As a defendant.
As a defendant.
What about the plaintiff?
Please, my lord.
What about the plaintiff?
Defendant, my lord, seeks, even I will go further that if he seeks to withdraw the suit, I will file an application for transposition as a plaintiff.
That is even better for you.
But better than, more than this, I cannot.
For you.
More than this, I cannot.
See, the fact that your plaintiffs are not before us is very suspicious, Mr.
My lord, there is no suspicion at all, my lord.
They have no objection. They have not filed an application.
ಅಲ್ಲ ಅಲ್ಲಿಯೂ ಅವ್ರ objection ಹಾಕ್ಲಿಲ್ಲ. Impleading application ಗೆ they have not filed objections.
And there is a serious allegation. Even the exception,
please,
to proper necessary party rule is if there is a collusion which may affect a third party. There is an exception for that. If there is collusion here, then that exception will apply.
My submission is even coming out of the, my lord, the subject matter of the writ, my lord, it will be a wrong precedent for others, my lord. In every temple dispute, a devotee will file an application. Yes, my lord.
That's the problem. ಇಲ್ಲಿ ಬರೀ ಟೆಂಪಲ್ litigation.
ಆಮೇಲೆ ಎಲ್ಲ 100 applications, the suit will never end, my lord. ಅವರು ಒಂದು even assuming that for protecting the interest of the temple, I consent for the dismissal of the writ petition also, my lord.
You file an affidavit saying that you are not settling, you will contest, let the
please, my lord.
plaintiffs also file it.
Please.
Then we'll consider.
Please, me.
With your lordship's permission, my lord, first of all, whether he has got the right to approach this court by as a writ petitioner. He is not a party there.
He is not a party in the
He is not a party who has approached this court.
I have filed, last occasion, this point was raised by the other side. I pointed out, my lord, the resolution, my lord, resolution along with the wakalat. Your lordship.
You are not a member, you are the trust.
Yes. This resolution, my lord, I read over this
And
resolution to your
defendant number
lordships, my
one
lord,
trust
and
is
your
represent-
lordships directed me to produce the meeting minutes, and I have produced along with the memo.
Order sheet.
And one of the party, my lord, he has resigned from the committee, and fresh secretary and president has been appointed by virtue of resolution.
What is the order you are referring to, Mr. Patil? When was it passed?
No, my lord,
Pardon,
your
my lord, your
lordships,
lordship may please to find that last time, your lordship directed them to produce any documents to show
Oh,
that
date, yeah.
oral order. By the-
Oral.
Lord, I
And
read over,
then
I
now
read,
also,
29-1.
I read over the resolution
till
produced.
29-1,
29-1.
25.
29-1-25.
Yes.
ಮೊನ್ನೆ.
ಹೌದು ಅದ ತಾವೇ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟರು.
To produce the minutes of the meeting of the trustees.
Yes.
Appointing Narasimha, son of Ramchandra Naik as president. And
Yes.
Prahlad Sarsan, so and so.
I have produced along with the memo, my lord,
Yavaga.
on 3/2/2025.
Have you seen these minutes, Mr. Patil?
No, that itself, minutes, they, if your lordship is pleased to see these minutes and the documents, they say that the earlier chairman who is defending, who is defendant number one in the suit, he has resigned and I have become as a chairman. Nothing is there. He's neither his resignation is produced, nor he is this thing. The defendant number one is some other person. Defendant number two is a secretary there.
Page 7
And
may
these
kindly
two
be seen.
persons, they claim that they themselves have become a chairman and secretary. They have filed this writ petition.
All the committee
That
members have
effect,
signed
there has to
the,
be amendment in the suit also.
all the committee members have signed the, my lord, meeting minutes. Page 7 of the typed copy may kindly be seen.
We'll stay the suit, you go and file 92.
92 are filing, my lord. This,
Ella will sort out again.
ಈ suit scope is totally different because suit is, they have sold one of the trustee has purchased the property of the trust. That
will
is,
that will be part of 92.
no, my lord, that will not come under that. To that, they have to go to civil court only. Because fraud played by the trustee against this thing. That is why the suit is filed, declaring that sale deed is null and void by one of the devotee, because it is a public trust. None of these trust committee people taken action against them. That is why one of the person came forward. And then I also, when I suspected that they may compromise themselves, I filed application to get myself impleaded as one of the defendant.
Any devotee were to come. ನಮ್ಮುಂದೆನೆ ಇಷ್ಟು ನಡೀತಾ ಇದೆ.
Because it is a public trust, my lord, and
ಒಂದು devotee 100 devotees ಬಂದ್ರೆ ಏನ್ ಮಾಡೋದು?
ಅಲ್ಲ, correct sir. If it is a public trust, ಅಲ್ಲಿ members ಅಂತ ಯಾರಿಲ್ಲ. There is no membership list at all. That is what in 92 scheme is to be framed actually. There is no rules, there is no regulations,
So file
no bylaws.
File that.
And now how they can claim that they themselves are that somebody comes there saying that I am a chairman and I have that, because in the suit chairman is somebody else, his secretary is somebody else.
We'll stay the suit so that it will
Suit,
prevent them from doing
that
anything.
itself, they are interested in getting this, we want the suit to be heard and disposed of, my lord. Suit stay adre.
That suit in the 92 better alwa, everything will sort out.
92 is scope separate ಆಗುತ್ತೆ ಸರ್, ಇದು ಇಲ್ಲೇ suit ನಲ್ಲಿ
Scheme formulate ಆದ್ರೆ ಇದ್ರಲ್ಲಿ ಇರೋದು ಇಟ್ಸ್ interstate dispute between them.
ಅದು ಅಲ್ಲ ಈ ಇದನ್ನ
ಏನು ಬೆನಿಫಿಟ್ ಇಲ್ಲ.
ಅಲ್ಲ ಇದು this will not come in the 92, and my only submission is I am coming there as a defendant. What harm is going, when they are going to, they say that they are office bearers of the trust, when they say that they are going to take action, safeguard the interest of the trust.
On Tuesday you think about it.
Yes.
As to which is a better this one. Because from what we see of it, unless you convince us otherwise, ಈ suit ನೋಡಿದ್ರೆ it is not, if your allegations are true, it is not in the interest of anybody. Unless a scheme.
ಅದು ಏನಾಗಿದೆ ಸರ್, one of the trustee then, he purchased the property of the trust.
So ಅದೆಲ್ಲ ಇಲ್ಲಿಗೆ ವಾಪಸ್ ಬರುತ್ತೆ.
ಅದು 92 ದಲ್ಲಿ ಕವರ್ ಆಗೋದಿಲ್ಲ ಸರ್, ಅದು only
ಅಲ್ಲಿ ಸ್ಕೀಮ್ ಆದ್ಮೇಲೆ the people will take a action. This suit will be stayed till then.
If suit is stayed, they will be happy. They want that suit to be stayed. That is why they approached this court via media.
What will you do as a defendant?
At least let the suit be decided, my lord.
You ask for any relief?
No, I want this suit to be heard and at least suits to be heard and disposed of.
Think about it. We'll have it on Tuesday.
Yes.
10 D-link and relist on 25th.
In preliminary hearing, my lord. Let it be brief.
Preliminary hearing.
Yes.
Not any other password idea.
Tuesday.
Lordship, serial number.
Lakshman team ante gaani please ಮಾಡಿ. I am filing my address. Amendment application is also not amended.
I 1/25 filed for amendment is allowed. Petitioner is permitted to carry out necessary amendment and file amended petition. The operation and execution of the order dated 27/6/2024 passed by Deputy Labor Commissioner and prescribed authority in so and so at Annexure A is stayed till the next date of hearing. Shri PM Atti accepts notice. ನೀವೆಲ್ಲ ಹೋಗ್ತೀನಿ ಅಂತ ಹೇಳಿ ಯಾಕಿಲ್ಲ ಇದ್ದೀರಾ? Accepts notice for the respond number 2, and AG accepts notice for respond number 1. Petitioner is before this court seeking for the following leaves. The submission of the grievance of the petitioner is that the petitioner having applied for allotment of a shop in the market yard of respond number 2 by having provided national savings certificate and making payment of monies. The allotment not having been made, the petitioner sought for refund of the amount which has not been granted. The fact, the undisputed fact is that allotment has not been made in favor of the petitioner. In that view of the matter, it was for the respondent to return the monies. The same not having been done, the petitioner has been forced to approach this court. As such, I pass the following order. Writ petition is allowed, a mandamus is issued directing the respond number 2 to consider the representation dated 22/2024 at Annexure F and G and pass necessary orders within a period of
Within 15 days, we will return it.
15 days from today, from date of receipt of copy of the order.
Your Lordship.
Lordship,
So they say, what was your?
Lordship 58 and 59, my lord.
Serial number 50.
Lord.
Nimsha, madam, is another passed over. ಏನಾಯ್ತು ಚೇತನ್?
My lords, till next date of hearing, my lords, we will not precipitate.
114, the submission of respond number 4 and 5, that they will not precipitate the matter till the next date of
Till
hearing.
next date of hearing.
Is placed on record. We list on 27th February,
20
Thursday.
So the Thursday, Friday, ಬೇಡ.
Thursday, Friday ಬೇಡ ಅಂದ್ರೆ next month ಹೋಗುತ್ತೆ.
It may be taken up on Tuesday, my lord.
ಇಲ್ಲ ಅಷ್ಟು ಬೇಗ, otherwise I would have said, my lords.
Release from parted next month. We are not going to keep any parted.
Friday, my lord, I have some personal difficulty, my lord.
We have no issue. We have a problem, so we won't keep it. Released on 5th March,
Fifth.
released from parted.
Please, my lords. My lords, serial number 44, my lords. Serial number 44. My land has been acquired in the year 1970 on 28/3/2024. This honorable court directed them to, my lords, whether alternative land is there or not, my lords.
113.
113. Yuvraj Mudod.
Senior has logged in. He is appearing. Who is appearing?
Yeah.
Nobody is appearing.
Yes, sir.
113 released on Monday.
Please, minutes. Monday at 2:30 minutes. I'm so
Yes.
grateful that you all are coming.
Please be there when it is called.
Lordship,
My sincere
58 and
apologies, my lord.
59 connected matter.
Yes.
Serial number 58 and 59, my lord, where, my lord, the agreed by the order of, my lord, IA number 2021 for, my lord, they are
ಏನ್ ಎಮರ್ಜೆನ್ಸಿ ಏನಾದ್ರು ಇದ್ರೆ
emergency, my lord, they have posted for evidence of a defendant.
ಅಷ್ಟೇ ತಾನೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಅಲ್ವಲ್ಲ.
ಅಲ್ಲ, for that reason, kindly, my lord.
ಏನ್ ಅರ್ಜೆನ್ಸಿ?
Now, as per the government scheme, as to the rural housing scheme, now the houses are being allotted to the landless person. In that, as per the norms introduced by the Rajiv Gandhi Housing Corporation, certain of the houses are to be allotted to the scheduled caste and scheduled tribes. But as per the panchayat is concerned, it has out of 100 houses, 90 houses are being allotted to the general and 10 houses to the minorities. So,
ನೀವು ಅಪ್ಲಿಕೆಂಟ್ ಪಬ್ಲಿಕ್?
I am the applicant, my lord. I am the public in the sense, my lord, I made
public interest litigation.
I made a representation, my lord.
Serial number 49, my lord.
My lord.
Number 49. There is a interim stay on behalf of
We'll make it
petitioner.
permanent.
We have applied for vacating the stay, my lords.
We'll make it
There is. Yes.
My lord.
I represent the petitioner.
My lord, my lord, my lord, my lord, Monday may be taken up, my lord.
My lords, Monday.
My lord.
56, serial number 56.
My lord, Monday may be taken up, my lord. Kindly, my lord.
47.
Oh, Monday.
67 Monday.
Shram. 58
Hello,
and
serial-
59.
49 Monday, na?
47.
ಇದರ ಪ್ರಕಾರ ಕರೆದ್ಬಿಡ್ರಿ, ಲಿಸ್ಟ್ ಪ್ರಕಾರ ಕರೀರಿ.
49 stay extend ಆಗುತ್ತೆ. Sir, 47
58 and 59 Monday.
Monday. 67.
ಅಲ್ಲ 58 59 ತಗೊಳ್ಳಿ.
67.
ಅಯ್ಯೋ ರಾಮ್. 58 59 Monday.
67, sir.
47 Monday.
82 after 2 weeks.
42 na?
Wrong, sir.
67.
Petitioner respondent 57.
82 2 weeks.
67.
ಒಂದ್ ನಿಮಿಷ ಇರಿ
No,
ಸರ್.
sir, 80
67, sir.
ಇವ್ರು ಮುಗಿಸ್ಬಿಡಿ. ಹೇಳಿ ಪ್ರಕಾಶ್ ಅವರೇ.
Sir, 83 stay ಬೇಕು.
ಈ ಗ್ರೂಪ್ ಎಲ್ಲ ಮಾರ್ಚ್ ಆರ್ಡರ್ಸ್ ಅವು ಯಾವ ಇರ್ತಾವಲ್ಲ ಅದಷ್ಟೇ ಕೊಡಕ್ಕೆ ಹೇಳಿದ್ದಾರೆ.
83 102. 83 ಮತ್ತೆ 100.
ಎಲ್ಲ ಎಂಟ್ರಿ ಮಾಡರ್ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ ಎಲ್ಲ ಮಾರ್ಚ್.
Yes, yes.
67,
Correct.
sir, please. 67. Monday.
ಹಲೋ, ಅದೇ ನೀವು ಪಾಲಿಟಿಷಿಯನ್ ಯಾರೋ ಮಂಡ್ಯದ ಏನ ಅಂತ ಹೇಳಿದ್ರಿ. ಮಂಡ್ಯ ಹಾಕ್ಸ್ತಾರೆ. ಬೇಡ ಅಂತ ಹೇಳಿ ಮಂಡ್ಯ ಇರೋದಿಲ್ಲ, ನಾನು ಬೆಂಗಳೂರು ಇರ್ತೀನಿ. ನಾನು ಹೇಳಿ ನಿಮ್ಗೆ 20 ಗುರು ಹಾಕ್ಸೋಳಿ. ಮಂಡ್ಯ ಇಲ್ಲ ಅಂತ ಬೆಂಗಳೂರು ಇರ್ತದ. ಅಲ್ಲಿ ಹೇಳ್ರಿ, ನಾ ಮೊದ್ಲೇ ಅಲ್ಲಿ ನೀವು ಹೇಳೋಕಾಗಿಲ್ಲ. ಅಲ್ಲಿ ಮುಂಜಾನೆ ಇಲ್ತಕ್ಕ ಕುತ್ಕೊಂತಾನೆ ಎನ್ಕತ್ತಕಾಯ್ತು ಒಂದೇ ಕೆಲಸ ಬಂದ ವಿಷಯ ಮುಂದ ಮತ್ತೆ ಹೇಳಕಲ್ತಿ ಮಂಡ್ಯ ಹಾಕತ್ತೀರಿ ಹೆಂಗ್ರಿ ನೀವು? ನಿಮ್ಗೆ ಹೇಳಲ್ಲ ಹೇಳ್ಬೇಕ್ರಿ ಅವ್ರಿಗೆ, ಮಂಡ್ಯ ಹೇಳಲ್ಲ ಅಂತ ಹೇಳ್ಬೇಕಲ್ಲ. ಹೇಳ್ರಿ ನಮ್ಮ ಗುರುವಾರ ಹಾಕತ್ ಹೇಳ್ರಿ. ಎಲ್ಲಿ ಸಿಕ್ಕ ಫೈಲ ಹುಡುಕ್ಯಾರ ಅವಮಾನ ಹೇಳ್ತದ ಇವತ್ತು ಏನ್ ಮಾಡುದು ನೋಡಿ ಬೇಕಲ್ಲ ಸುಮಾರು ನೋಡಿ ಸಮಾನ ಆಯ್ತು ಮತ್ತೆ ಇವು ಮೆಮೊ ಫೈಲ್ ಮಾಡ್ರಿ ಯಾವ ಕಾಯ್ತು ಮೊಬೈಲ್ ಹೋಗಿದ್ದೀವಿ ಆಯ್ತು ಹಲೋ ಆಯ್ತು ಸರಿ ಬರ್ತೀನಿ ನಾನು ಬರ್ತೀನಿ ಇದು ಬರ್ತೇನೆ ಇದು ಹೇಳಿದ್ದು ಹೇಳ್ತೀನಿ ಏನು ಅಂದ್ಬಿಡ್ತೀನಿ ಏನು ಹೇಳಿದ್ದು ಹೇಳ್ತೀನಿ ಏನು 4 ಪೇಜ್ ಬೇಕಲ್ಲ ಆಯ್ತಾ ಆಯ್ತು